will be taken on Friday. Malad,
Let us start from that side. Yes. Please hand over. New motion, wait for some time. Yes, Mr.
I'm suffering and losing all interest because of
Jagatu, please wait for some time. No further inclusion right now, yes. Unless it's extremely necessary.
My chartered accountant, I haven't debarred from my profession without conducting a proper inquiry.
See, all the matters are urgent. I'll take up the upgradations. I'll give some precedence to upgradation. Let me take up some upgraded matters. But inclusion right now, I'm not doing it unless it's extension or extremely urgent or something.
It's an extremely urgent matter. A person matter is an individual matter, which is family
Not right now. Yes, Mr.
Right. I'm giving a sleep matter.
Don't.
No. Pray for your lordship leave to effect short service and to list them at any day before Friday, because on that Friday the radar authorities without any jurisdiction has fixed a hearing on a complaint, making it clear that what orders they're taking to pass. Very drastic, my lord. It's in respect of the Marriott Hotel, building completed. Radar authorities have jurisdiction.
Mr. Shah, please wait for some time. Not right now. This is not so urgent.
Friday, my lord, I'll lose my forum. Once they pass it, be given to the appellate authority.
Sorry, Mr. Shah, not right now.
Matter pertaining to DRT, my lord, not there. The auction sale is tomorrow, my lord, at 4 p.m. My lord, twice the matter was.
DRT matters? No, go before the.
No, the DRT 2 is not there. And none of the party has been, DRT 3 or 1 has not given charge, my lord.
Cannot wait for the 11th hour, no.
My lord, no, my lord, I mentioned the matter.
No.
That matter was fixed by Justice Bharadwaj, my lord, on 2 occasions, my lord, at 10:30 am. But Justice Bharadwaj, my lord, did not sat, my lord. I am waiting for my last.
If I knew, I would not have said.
Last 15 days,
No.
my lord. Kindly, my lord, tomorrow is the auction.
Sorry,
sale,
no,
my lord.
yes.
Malad, 19th of this month, Malad, a notice has been served for taking over possession of my residential building. I am not a borrower. My vendor, Malad, has also cleared the order.
The DRT, Mr. Bhattacharya.
But DRT has not passed the order against me, my lord. DRT has settled the issue. Bank has, Malad, given a no claim
These are
certificate.
frivolous matters, Mr. Bhattacharya. You have to go before the DRT. This is not the forum.
Malad, it is the recovery officer's only order against my erstwhile owner. Erstwhile owner paid the entire sum.
So relief lies before the DRT, Mr. Bhattacharya. Please go there. Mr. Badi, yes.
My lord, your lordship's pursuant to your lordship's pleasure, my lord, I'm mentioning the circuit bench matter which has already been marked as a part.
Please give over the slip.
Yes.
We'll
My lord, 668 of the combined list. It was mentioned on notice upon the other side. Lordship was kind enough to include that in the supplementary list. It has gone to the combined list. Matter relates to the appointment compulsion.
Not right now, Mr. Badi.
I
Not
tell
right.
your lordship,
No.
marriage officer's compulsion appointment is going to be filled up. It will be infractuous if your lordship, my lord.
No, Mr. Badi. Not right. Yes.
My lord, in spite of receiving the quotation money, the electricity authority is not giving electricity.
Please wait for electricity matter. Hand over. Electricity gulo kalke opore diye to electricity gulo namiye do. Yes.
My lord, I'm appearing behalf of the petitioner for the restoration application. The matter was disposed of through 11th.
Is restoration application?
Yes, my lord.
Hand over. Give the slip.
new connection electricity, I deposited them.
Electricity matter. Hand over. Please hand over. No urgency. No. Yes. Please be a bit louder. Louder. Calcutta University is still recognized. What is your urgency? Hand over it. Kalke opor dike upgrade diye di. Yes. No, Mr. Dotto, I cannot. This cannot add matters further. No, not right.
Lord, not there, my lord. That is the difficulty.
Next.
We have filed our
No, Mr.
application, Miller.
I cannot include right now these matters. Yes. Not so urgent. Yes, please, Mr. Shan.
Against the look of notice, my lord, 3rd October, the petitioner is going to, my lord, the forest. But my lord, it is against the date covered by your lordship judgment. Completely covered by your lordship judgment. I was right 3 years. ago.
Lookout circle, you can wait for something.
3rd October is the turning. 3rd October.
No.
May I come next week, lord?
Next week come.
I am paying for a leave for an RTL multiple of your fee. Yet it will base to your apple for past September. After tomorrow, my poison will be taken over by the bank. But kindly have me. But otherwise, I will be ousted from my.
The RT matters I cannot take up.
But because my lord, the sale was effected on 29th August. Immediately I filed an I application. From past
So
September.
that I have refused others, don't come with the RT matters. Next.
No, I will be No, I will be ousted.
File in due course. No. No.
Your lordship, this matter as appearing as item number 140. Your lordship, but I had mentioned it 2 weeks earlier. Lordship, when lordship was sitting, your lordship asked me to come back after 2 weeks. Your lordship, is the urgency of your lordship? We have been ousted from our property, and your lordship, we are organizing various social welfare activities. One of them is the Durga Puja. Now your lordship, if you are not given a land, allocated a land, your lordship.
No further Durga Puja, please. Please. I'm fed up with Durga Puja. Yes.
461 of my lordship monthly list.
Please be a bit louder.
My lordship, this matter was taken up by my lords in the month of July. My lordship,
All right, I'll take Mr. Mukherjee and yes. Mr. Mitra, please. Yes.
This is a double defaulter. His entry order is there. I paid the full due. I've got the no due certificate. I can withdraw the decision. I think it's recorded. Otherwise, I can't. Otherwise,
This for withdrawal. It have to be mentioned at the
after recording that I've paid the no due, I've got the other side's consent.
to be mentioned at the Yes.
item number 461 of my lordship's monthly list. This matter was taken up in the month of July when the state appeared and took an adjournment. My lordship, now they are my lordship, not allowing me to run my heart, my lordship, in the land, my lordship, which I have. My lordship, very urgent matter. My lordship,
Wait for some time. Yes.
Any day next week.
No.
Extension of interim order, my lord.
My lord, item number 829 of your lordship's monthly list. A 4-year-old child has 2 birth certificates, 2 names and 2 addresses. Her name has been changed at the behest of the private respondent. Dehoves the provisions of law by the NKD, your lordship.
Hand over.
I'm deeply obliged.
Upgraded. Yes.
Lordship, it's an upgradation matter. Lordship, the petitioner is a COVID warrior. During the pandemic, SDO Kolani floated a tender for supplying some materials regarding computers. The petitioner has supplied all the materials, but till date, she has not got any payment. The payment she has invested her hard-earned money, sum of amount more than 15 lakhs. Presently, she is suffering from neurological problem, but she is not getting proper treatment due to scarcity of money.
Hand over. It upgrade.
My lordship, I'm praying for restoration of 2 matters.
Restoration application.
Restoration application.
Hand over.
Your lordship, this pertains to an adoption matter, your lordship. The prospective adoptive parents, your lordship, had received 2 children, but because of some adjustment issues, your lordship, they had to return back the children. But your lordship, the younger child is willing to be with the parents, your lordship, but in the meantime, your lordship, the HSR had also expired, and also your lordship, the parents had also applied for the new adoption.
In the list.
Yes, my lordship. Monthly list of 841, your lordship. But
This is
your
an
lordship,
upgraded matter.
your lordship, the interim order extending in this 30th of September, your lordship.
Expiring.
Yes.
Hell extension of interim order.
Grateful, your lordship.
My lord, may I
Raising this matter for non-prosecution.
My lord, for withdrawal of a matter, my lord.
Restate
It any no withdraw.
the restate motion for into next month. And another matter for non-prosecution, item number 220.
Non-prosecution, please hand over.
Item number 220.
Please just hand over a slip so that we can.
My lord, I'm-
Item number 196 of your lordship's monthly list, my lord. My lord, in this matter, I have come up with order passed by the NCDRC. My lord, in the single member bench of the NCDRC has passed a blanket order of stay for an indefinite period of time, my lord, against the proceedings of pending before the state commission.
Not right now.
petitioner 85 years old and suffering by cancer. Lordship, petitioner want to sell his property for his medical treatment. Petitioner assurance to Kolkata registry. Petitioner to sell out the property. That is why the petitioner.
Set up.
Registered assurance to restrict petitioner to sell out the property. So there is a basic question on transfer. But where the petitioner owner by virtue of the lease deed were allotted for 990 years.
It is appearing in the list.
Yes, Lord.
Hand over. It upgraded you. Yes. Wait for some time. No. Yes. Group 1 land. It had to be mentioned for release. Good. You're wanting what, a gag order sort of?
Yes.
148.
148, you cannot make the public application about something.
Please hand over it upgrade opor diye di. Yes, you. You. Here. Electricity, please hand over. Hand over. Yes, you. Not you. You. Sorry, no. Only 4 months. Sorry. Yes. Yes, Mr. Chakraborty.
State
Hand over.
Very unusual circumstances that I'm mentioning this matter on behalf of the respondent to the bank. Surface action initiated. Section 14 order obtained from the concerned district magistrate, who has said that within 30th of September you have to take possession. I have deposited the money. Now the writ petitioner has the borrower has filed the writ petition, which is due to appear on 28th. The police is saying that without the writ petition being disposed of, they will not take any step. I have deposited the money. 30th is the last date, my lord, to take possession in terms of the order of the district magistrate, my lord. I will be 28th has been declared a holiday.
Thank God. Next.
Will not be
No, bank, no. No, not at all. No.
Bank has made that.
Very well. I appreciate fully. I empathize with the bank, but no, not right now. Next person, please. Yes. No, I said.
This is a matter of violation of Article 21. The accused is suffering from custody, and the Armed Forces Tribunal is not taking up the matter. He's been in custody for the it's actually not set up as of now. It's been in custody for a very long time.
Very long means what?
It's good 17 years, despite
17 years.
17
Hello. It is in the list. এটা তুমি আপগ্রেডই দিয়ে দিও ডাইরেক্ট yes electricity please hand
Lordship, it's a victim compensation.
please take the microphone yes
Lordship, this is a victim compensation matter. The petitioner lost her husband, who is the sole earning member of the family.
please hand over
Item number 492. Petitioner is almost in dying condition.
electricity
No, other than registration of the deed, and the matter will be in practice, my lord.
why dying condition
Because of age, my lord.
what is the age
My lord, can you take this matter
No.
in?
if you can't say the age I can't take it
Age 75, my lord.
no sorry yes next
What happened? I
I have taken loan from the bank. I have already paid the, when I made a representation for return the deed, they have, my lord, they again they are deducting from my account as well. That's why this is.
Wait for some time. Yeah.
Your Lordship, monthly list serial 838. Your Lordship, this is for the upgradation. Petitioner is the auction purchaser. This was heard before Your Lordship, affidavit, and the respondent bank has already filed the affidavit in reply, and the subsequently reply has been filed, Your Lordship.
No, no.
Your Lordship, point is fixed for hearing. It is
No,
fixed.
no.
Obliged.
Mentioning for upgradation, my lord, the unauthorized construction of on the highway, blocking by egress and ingress. This is the urgency.
Hand over.
Item number 1007 of the monthly list matter. But the fact is that, my lord, there is an order of the honorable one of the coordinate bench of this honorable High Court that there is a conditional stay was there.
Take the mic towards you. Yes. Conditional stay.
There is a conditional stay passed by a honorable coordinate bench. Now, the fact is that stay condition is that you have to pay within 7 days. But the fact is that they have not paid, my lord, but the stay is they are enjoying, my lord, the private respondent.
Not you. No.
But it's a nursing home, my lord, running in my home without the order of CMOH. CMOH order was stayed.
No, sorry. Yes.
New condition, my lord, the submersible pump.
Hand over.
Item 744, my lord, also
Well, submersible.
for urgency, man. The petitioners are land losers, man. They are, land was taken, but they are intended to get it as exempt category. 100 candidates, 80 are already. I don't know why they are doing it. Some in this state, the advertising is very cheap. Only recently, Panchayat appointment has come in the manner, but they cannot get any application for this manner.
It is in the list.
It is in the list.
No upgradation now.
Only is most argument because
Next.
they are losing.
We cannot upgrade so many matters.
One electricity matter with application.
Yes. Please be a bit louder. Hey, এটা সরাও তো ক্যালেন্ডারটা সামনে থেকে সাইড করে দাও। Can't hear you, ma'am. Can't hear you. Yes, Miss Ghosh, please help her. What is?
And where is the petitioner's permission? Section 17 of the Circuit Act within 48 hours from the date of the last update.
Sorry, no. No, sorry. Yes.
That is also to mention but you had mentioned before until this. The matters were called in the heard and by a one-line order, matters were directed to the regular bench on 25th July.
No, Miss Ghosh, not right now. No, sorry. Extremely sorry. No, cannot do that. Yes, next matter.
Because the respondent was directed by order by your honorable court because the accidental benefits in favor of the petitioner. But
Accident by what? Accident. How was the accident?
Industrial cause.
This is for compensation. Hand over.
Because my lord, you should notice that it's valid from 29 May 2020 but in the petition of participating in the tender for the base 4 years. I have filed immediately after the opening of the summer petition.
Not
But
right
I have
now.
never called on, my lord.
Sorry, no.
Completely out of
Next matter, yes.
my lord, kindly consider it. He is completely out of business, my lord.
Yes, next matter.
From me for the next 4 years.
Will also be mentioning for the extension of the
8,50,000 has been accepted by the KMD authority for installation. Now, Lordship, and we execute the agreement with the certificate. I repeatedly requested them to execute the order. In the meantime, they have wrote a letter that this money will be refunded. Your agreement is cancelled.
What is the cause of action, Mr. Mukherjee?
The installation of body, I have paid.
Your relief advice lies in damages. No urgency. Yes.
The inclusion
Inclusion for? Sorry, no. Next. How long? Custody in for how many years? Hand over. Hand over. Victim compensation hand over. Well, this is the last line of mentioning. I won't take any further mention. Yes. Continue. Can't hear you. Please use the microphone.
He was issued the letter of acceptance, my lord, and he has deposited earnest money, 12 lakh rupees. Despite handing over the site, another new e-tender notice has been issued by the.
Not now. Yes.
Lordship, the petitioners did. I have mentioned the matter. Lordship, the urgency.
You switched off the microphone.
The petitioners, they are
They
not
cannot go on
getting.
switching on.
They are not getting the draft copy of their deed on the because of the reason that the provider, that is the West Bengal Housing Board, they are not giving it upon being vindictive because of our complaint which was lodged before the Competition Commission of India. Now we only seek the draft deed to be examined. It should be handed over to us and registration to be completed. If it is not completed by September 23, we'll lose another chance of reduction, that is 2 lakhs rupees. Almost
September
we have
23 has gone by. We are on 25th. So then we have lost.
Lordship, this some urgency, Lordship. Let it be upgraded, Lordship. 4 times, Lordship.
My lord, even after receiving the entire loan dues, my lord, from the petitioner, my lord, the original deed is not handing over to the petitioner, my lord.
Chatterjee, how many times you mention it is not important. You should be lucky that you are being permitted to mention for so long. From now on, I think if these sort of mentionings are made, that I have mentioned 4 times, 5, if you mention ridiculous things, so many people are out of their homes without electricity, and your ridiculous matter that has to be given precedence just because we are mentioning it for 4 times. This has to go from your mind, Mr. Chatterjee. Don't mention these things. 4 times, 5 times, 6 times, then don't mention. If you are fed up with the mentioning, don't mention.
I understand.
Who cares whether you mention it 4 times or 8 times or 10 times?
I'm very sorry.
If it's not urgent, don't mention. Why do you waste the time of court? Yes.
My lord, even after receiving the entire full due loan amount, my lord, from the petitioner, my lord, the original deed is not handing over to the petitioner by the LIC department, my lord. My lord,
My lord, may I be permitted to seek leave, your lordship, of your lordship? My lord, this petitioner has completed his sentence. My lord, on July, my lord, still he is in custody. My lord, the jail authority is saying that you have to suffer another 10 months because, my lord, the fact is that I was convicted in three matters. So 3 into 3, they are calculating like 3 into 3, you have to serve 9 months. My lord, whereas it's settled that I have to suffer.
There is no relief before the criminal court.
No, my lord, there is no relief, my lord.
Leave the other.
My lord, may I,
urgent is upgraded.
my lord, may I do permit to mention this is the unauthorized construction in the PWD in front of the house of the petitioner.
My lord, same matter, my lord, can I hand over?
May I be permitted to get electric connection before my application filed already before.
Application?
Application filed regarding the disconnection.
Please stand straight and mention it properly first.
Yes.
So,
Please repeat.
Oh, application, my lord, regarding the submersible disconnection or connection. Dispute
electricity.
Electricity.
Hand over.
Lord, may I be permitted to mention a matter for contempt, my lord? This is an electricity application which was disposed of by your lordship's order dated 15/5/2020.
Contempt for inclusion in the list. Hand over.
My lord, I'm bringing for application, my lord. My lord, 20 families suffering from without electricity, my lord.
Electricity, please hand over. Yes.
My lord, this is an application for substitution. Earlier, my lord had allowed the my lord mentioning
My lord, what happened because of non-finding of and one application, it has not been listed.
Substitution application. Please hand over.
Section 5.
My lord, for observation, my lord, the hearing is not passing order under section 14.
Hand over.
May I not record? Under compelling circumstances mentioning matter, my lord. The urgency is that the financial bid will be open tomorrow, my lord. We have moved this matter with leave before my lord Justice Shopal of the call on last week, my lord. My lord Justice Paul was pleased to direct the matter appear today, my lord. The financial bid will open.
I'm nothing doing. Now cannot help you.
The compelling circumstances. I would not have troubled your lordship, my lord. I can.
কালকে দিয়ে দিতে হবে টপে
Grateful, lord. Grateful.
My lord.
Yes. No, sorry.
Two matters, one for no prosecution and another for upgradation electricity.
Electricity matter, yes, both hand over. Contempt hand over.
Your lordship, it's a non-prosecution, my senior.
Non-prosecution hand over.
Banking matter auction on 28th, no alternate remedy.
Two matters, one matter for individual. Another one is urgent motion for Durga Puja permission.
Urgent motion for
Durga Puja permission, my lord. I'm saying. Durga Puja permission, my lord.
Hand over the content matter.
Take stamp paper, I'll pay the money and take it.
My lord, may I be permitted, my lord? This matter, I am senior citizen, I am suffering serious ailments, my lord. I want to cancel my power of attorney. Someone is selling my properties, my lord.
What can the writ court do?
My lord, I have made party to register authority, my lord.
Anyway, hand over, yes.
My lord, may I permit
Your
to
lordship.
mention the respondent bank issued e-auction notice for sale of the mortgage property of the petitioner without issuing notice under section 13(2), 13(4) of the SABYASACHI Act.
Go before the Death Recovery Tribunal under section 17, no.
Your lordship.
Yes, sir.
The petitioner is not a borrower. Still, the property is being illegally being sold by the recovery officer, and DRT 2 Kolkata is absent for a pretty long.
DRT matters I'm not.
My lord, these matter are in.
Yes, you.
My lord.
Your lordship.
Electricity, please hand over. What is the matter regarding?
Railway siding. Railway siding.
Pardon?
Railway siding.
Not right.
Lordship, the matter.
Your lordship.
I have purchased a house on e-auction. So with proper consideration from a bank. Now all of a sudden, next bank, different bank is claiming that it is their property. I have purchased from e-auction. It is properly registered under the proper authority with proper consideration. Now after 3.
Sorry, not right now. Yes.
Your lordship.
Oh, I'm sorry. He's there.
Your lordship, I am praying for upgradation. This matter is appeared on monthly register 192. It is a service matter which was heard by Justice Mosumi Bhattacharya few months ago. She passed an order to place a reason order. The reason order was came and we are challenging the reason order.
Which authority?
Food Director of Employment, Food Service.
What is the dispute regarding?
Dispute regarding is that the petitioner is working as the enumerators and he applied for EC card, exempted category card, but
Yes,
the card was
please,
not
Please
issued.
hand over the slip. It upgraded you. Yes.
Lordship, electricity matter, lordship, for upgradation.
My lord, may I be permitted to mention that your lordship heard
Electricity
regarding
গুলো সব update করে দিও. Yes.
regarding the professional volleyball player, my lord, the matter was taken up by lord.
What is your urgency?
My lord, this is the same matter, my lord, where the professional volleyball player has not been selected in the open selection. My lord, I had heard this matter on Friday.
When is the next date, next competition?
My lord, it is this month only, my lord. The players would be leaving on 28th. My lord, it was heard by.
No. Yes, hand over. এটা দিয়ে দিও উপরে লিস্টে একদম উপর দিয়ে টপে দিকে। Yes.
But I'm seeking leave to file this.
Please take the microphone.
But I'm seeking leave to file this writ petition, my lord. 5,38,000, my lord. This is a senior citizen who used to previously work as a decorator in various elections, my lord. 5,38,000 is an admitted claim, admitted by the respondent. He is presently in dire need of money for his medical expenses, my lord. He is not getting that money. Several representations made, my lord.
So why are you seeking a leave?
My lord, I'm seeking my leave. They can be urgently moved, my lord.
File it in the department and hand over the slip. It will whenever. এটা নিয়ে নিয়ে তো উনি দিলে এটা Please hand over your son.
I'm deeply obliged. I'm deeply obliged. Your Lordship, the petitioner herein has been given a charge to develop the 5 years perspective.
I cannot go on taking mentioning. This
Your
is the
Lordship,
last mention.
yes, sir. Perspective development plan, but the DMs of different districts are illegal order is holding the plan to be sanctioned of the petitioner. The petitioner is also a senior citizen and suffering for the pretty long.
Cannot take it right now. Let me dispose of some matters. Yes.
Deeply.
Further mention.
Milord, may I mention one matter, Milord? I'm so sorry. I've been waiting, Milord. Only one matter, Milord. Not one matter, Milord. I beg to mention, Milord.
Why don't you mention? But at least the mentioning has to be physically.
Milord, my advocate on record was there, Milord. Somehow he had to go, Milord. It's a very earnest request, Milord. Your Lordship had directed, Milord, the matter to be fairly at the top, Milord, and given a date, Milord. Anytime next week, Milord, because it's now showing 8:37 in the monthly list, Milord. It's a very earnest request, Milord. Your Lordship's last order indicated fairly at the top.
I have told I'm not taking up any further mentioning, so let us wait for the next week. Yes.
Greatly obliged.
For judgment, item number 1.
It's a longish ordering portion. I'm just reading it out. Accordingly, WPA 25626 of 2022 and the can are disposed of with the following observations. The impugned office order dated July 28, 2022 is set aside. The WBACDCL shall remain restrained from taking any penal action of blacklisting against the petitioners and the other WBACDCL enlisted contractors in terms of the impugned office orders of the WBACDCL dated May 17, 2023 and May 12, 2017 till a report is filed by the committee to be formed in terms of the meeting dated October 5, 2018 held between the WBACDCL officials and the contractors associations. Such committee shall be constituted if not already done within a fortnight from date, and it shall file its report as contemplated in the meeting dated October 5th, 2018 within 4 weeks thereafter. Both before and after the filing of such report, the WBACDCL shall ensure that an inquiry is undertaken in case of each accident which happens due to improper shutdown of high tension lines and gadgets at the work sites of the WBACDCL. Such inquiry shall be concluded, including submissions of the consequent report within an outer limit of 4 weeks for each accident. The WBACDCL shall, upon such report being submitted, be at liberty to take appropriate action against the concerned contractor as well as its own officers in accordance with law and as per the terms and conditions of their own guidelines. However, till such report is filed, the contractors shall not be blacklisted and or debarred from undertaking further work for the WBACDCL. In the event the WBACDCL proposes blacklisting the concerned contractors, including the petitioners, on the basis of such report, a show cause notice and a hearing shall be given to the concerned contractor upon service of advance copies of the report and any other document if sought to be relied on by the WBACDCL to the accused contractor, nor as to cause urgency. So the plinth of this is the 5th October 2018, that meeting was there. In terms of that, a committee has to be formed within a fortnight and that has to file a report within 4 weeks. Urgent? Yes, that is all. It will be on the server also immediately. Pardon? Oh, yes.
For judgment, item number 2.
Hence, WPA 9943 of 2023 is dismissed without any order as to costs. Nothing in this order, however, shall prevent the petitioners, if they so choose, to approach the concerned district judge having territorial jurisdiction over the area for adequate compensation commensurate with the rights of the petitioners after the work in question is complete. If such an approach is made, the district judge shall decide the same in accordance with law upon giving adequate opportunity without being influenced on merit in any manner by observations above. Urgent certificate.
We mention item number 1 for non-prosecution.
Lord, I am for the petitioner, Lord.
Don't want to proceed?
Yes. Issue is this, my lord. The dispute regarding the parties has resolved out of court, my lord. This is a letter which I have received.
Dispute has been settled.
Settled, my lord. thing is that, my lord, this is the first time the matter is appearing, my lord. I just want to reduce the affidavit of service, my lord, be kept with the record.
Affidavit of service filed today be kept on record. Full stop. Learned counsel for the petitioner submits that the petitioner does not want to proceed any further with the matter since the matter has been resolved out of court. Full stop. Next para. Accordingly, WPA 1285 of 2023 is dismissed for non-prosecution without any orders to cost. The written instruction filed by learned counsel for the petitioner be kept on record.
Top item 4.
My lord, I appear for the petition. I apologize, lordship. I was seeking for a 2 weeks extension for filing my affidavit in reply, my lord.
Who mentioned for this was for upgradation?
This was upgraded at the top, my lord.
Upgrade at who your instance? Learned counsel for the petitioner seeks an adjournment, seeks
I'm
an extension of time for filing the reply. Full stop. Next para. Accordingly, the petitioners, the time for filing affidavit in reply by the petitioners is extended for a fortnight from date. Full stop. The matter shall be listed next in the monthly list of November 2023.
My lord, another same heading. If it is in the monthly list, my lordship kindly keeps it on other than the monthly list any day. Lordship kindly. My lord, I was in some difficulty today, my lord. On the top, it was there. Lordship, I'll tell you, lordship, this is the trustees of the KOPT.
No. Next.
Lordship kindly keeps it on the top. No. Lordship kindly.
Item 5. Item 5.
None appears. You're appearing. None appears for the parties at the time of call. Full stop. Let the matter be listed in normal course. It are a upgrade থাকবে না এগুলো কোনটা।
Item 6.
Your Lordship, in this matter, and for the petitioner.
Yeah, for the respondent.
I'm for the respondent number 4.
On the last occasion, on Friday, only received the affidavit in opposition. We have to file, we need reply in this meantime. Due to the shortage of time.
Opposition filed affidavit in opposition filed today kept on record. Full stop. Time for filing reply is extended for a week from date. Full stop. Let the matter be listed next week. Let the matter be listed on October 16, 2023.
My lord, I'm beseech, my lord, they are enjoying stay, but I am raising a question of maintainability in this
Your
matter.
Lordship,
My lord, let it
the
be-
matter.
When it is taken up for hearing. Yeah.
Item 7.
Lordship would recall, it is that matter where the Prachi Cinema, your Lordship had directed us to find out whether the probate has been taken or not. We have filed the inspection slip, but it is because the matter was dismissed in the higher court. My junior says that it is not available. It has not been up in the e-court. It has not been uploaded, and we seek further. We have applied manually also. We are awaiting. Lordship, in the meantime, may I just hand over to your Lordships the will of Jitendranath Basu. I know it is not probated as yet, but your Lordship will see from the will that he had wanted a trust to be formed where my client and 2 other persons were asked to be
Please, Mr. I
trusted.
cannot rely on this. So
I
you
know.
use taking it on record and returning it to you just whenever it is the whether it is probated, that is crucial.
That
এটা
is
ফেরত দিয়ে
crucial.
দাও।
That is crucial.
Learned counsel, when should I keep it?
Lordship keeps it in the October
Learned counsel for the
fairly
petitioner.
at the top.
Learned counsel for the petitioner submits that the information could not be obtained as yet, despite the best efforts of the petitioner, as to whether the concerned will of Jitendranath Bose has been probated. Full stop. Next para. Hence, on the prayer of the petitioner, the matter is
Lordship, not on the monthly list the next day.
is adjourned till October 16, 2023, when it will be listed under the same heading.
I'm grateful to you, Lordship.
Item 8.
May it please the Lordship, Lord.
Yes, Mr. Koti, what is the matter?
Lord, this is that warehouse corporation matter, Lord, where the payment, Lord, was to be made. My lord, on the last occasion asked for a further report from the FCI. My lord, may kindly have a look at your lordship last order, 30th August. And for your lordship's recollection, security deposit was to be returned, supervision charges, and my lord, the billed amount.
As per the last order, my lord, I am submitting my supplementary report, my lord. I was directed to file the report, my lord.
Lord, there was a first report submitted by FCI. My lord may take the first report, my lord, and the italic portion your lordship mentioned in your lordship's order that your lordship wanted a clarification on that.
Yes, what is your explanation regarding this? No. You sought to attribute that portion to them.
Yes.
What is the explanation of that italics portion?
May I read the report?
No.
In this regard, it is to state that the payment to the CWC was reduced due to various factors like excess payment.
Which paragraph?
The report, my lord, page number 5.
Payment of the yes to the
It is
reduced.
pertinent to last but the least paragraph, my lord. It is pertinent to mention that the supervision charges as well as certification of H&TC bills by the CWC as required as per the mandate of ministry is a matter between the FCI and CWC. And the H&TC has directly nothing to do or no relation with FCI.
Yes, Mr. Chakraborty, remind me the matter.
Yes, Lord, now kindly take the first report for a second. First report. Now, 3 documents your lordship will take side by side, page 193 of the writ petition, first report, and my lord, first report page 6, and my lord, second report page 5.
First report, which page? 6.
Page 6.
This is one.
This
What are
is
the
one.
others?
Second, the page shown by my management right now, page 5, and 193 of the writ petition. Lord, till such time I'll tell you lordship the facts, Lord. Lord, তোমার রিপোর্টটাও তো পুরো ক্লিয়ার। Lord,
page what of the writ?
Page 193.
Yes.
Lord, FCI, Lord, for successfully running the public distribution system, they take rent the godowns run by Central Warehousing Corporation. Lord, CWC, Lord, grants tender to private individuals for handling and Lord, transportation. Suppose Lord, they have a godown at Lord Kharagpur. FCI sends some Lord wheat or whatever it is Lord to Kharagpur railway siding. Our job is to pick it up from the railway siding, drop it to the godown, then again Lord load it to the trucks of the persons, individuals or the dealers to whom it is to be distributed. Tender was issued. Lord, I have done the job. Your lordship will find that 190.
Contract is with the CWC.
Yes, I have no contract with FCI directly. Lord, kindly have a look at 193. Your lordship will find 2 charts. Lord, first, my lord will see CWC Sarul. Lord, with regard to our writ petition was moved, your lordship directed them. They said they will release the payment. On the same order, your lordship directed them to file a report on the second column. Kindly see the second column, my claim, security money of 4328, 43 lakhs 28. Supervision charges of 38,81,000, then bill of 61 lakhs and height withheld and 2 other charges. Lord, when the matter was first moved for Justice Mosumi Bhattacharya, CWC took a plea that they have not received the money from FCI, so they cannot pay. Lord, we filed an application before your lordships annexing documents, which is an answer from RTI that they have been paid by FCI. On that, your lordship asked for a further report from FCI because my learned friend from CWC said, let the FCI disclose under which head what they have. Then the first report came. Now kindly allow me to place the first report, page 6. Or my lord, from page 5, last paragraph of the first report.
Yes.
In case FCI hires go down from CWC directly, go down rent for space hired is being paid as per the ministry approved rates. Apart from that, handling and transport contractor HNTC is being appointed by CWC through open tender following the rules and regulation of both the organization. The work of HNTC is to transport stocks from unloading point, railway siding specified, and to the go down, and the stacking and destacking, etc., following the terms and conditions specified on the tender document. As per the procedure in vogue, the bill raised by HNTC to CWC, being the employer of HNTC, preferably on the monthly basis, are being scrutinized at CWC, and CWC submit the bill to FCI for reimbursement to them. CWC also raised another bill of 8% supervision charge. Not whatever our bill, they add 8% as their charge, as supervision charge. Supervision charge on the whole HNT bill amount to FCI. FCI then, after statutory deduction, reimburse, pay the bill to CWC, not to the HNTC. In case of non-following of any of the instruction in overall operation conducted by CWC for storing the FCI stock through their appointed HNTC, FCI deducts corresponding amount from the bills which are duly informed to CWC. Any dispute raises in between being resolved through meeting between the two organizations at different level from time to time. However, it is not the liability of FCI to inform all the details of payment and deduction made from the bills of HNTC, and CWC being the employer of HNTC, it is their duty to justify the payment released by them to HNTC. Hence, the payment of HNTC bills by CWC to the contractor in no way related to non-payment of any amount of HNTC bills and the supervision charges by FCI to CWC for one reason or another, as far as the same are justified or under examination, reconciliation between the organization through laid down procedure. CWC should take the whole liability in case of non-settlement of any amount of HNTC. So, my lord, I had claim on the amount of security. Kindly see what is the remark of security with regard to FCI. FCI says security deposit being deposited by the HNTC to CWC being a contract obligation between them, and FCI has no role on it. Lord, on the last occasion, I have shown your lordship the clause of security deposit, that what they are doing is they are asking for an unconditional no due certificate. So I have to give a no due certificate when I have other claims against them. So they are coercing me that unless I file the no due certificate, if I file a no due, I lose the other claim. So then they will not release the security.
It's down to the other claim. Let us come to the other claim.
Yes. Now, with regard to the absolute boils down. With regard to the second claim, which is February 20 to March 20, August 21 to January 22, supervision charges. Lord, what happens is whatever bill we raise, they add 8% on my bill and send it to FCI. FCI has not paid them their supervision charges for their fault. What they have done from our bill, they have deducted that money. Kindly see what the FCI said. Supervision charges are already mentioned above. 8% supervision charges are claimed by CWC on the whole HNTC billed amount for their supervision on the operation done during transportation, storage, maintenance of stocks as such. This amount is not a direct claim of HNTC to CWC. However, it is to inform that said amount for the corresponding months were not released to CWC due to lapses on supervision made by CWC. So it is their lapse, and due to reduction in the HNT bill amount, which were claimed beyond specified operation, which results in reduction in corresponding supervision charges. But on this, from due to till supervision charges, you lordship wanted a further clarification as to why this was done.
Not see whether it has an excess with you.
With me. Kindly see the second report, page 5, filed by them. Let me get over this issue, Lord, first. Then I'll take your lordship the other issue. I'll take the second report that filed by my learned friend today. My lord has kindly got it, not page 5. Kindly see, I'm reading the entire one. First paragraph is not very, your lordship's order is quoted. Second paragraph, in this regard, it is to state that the payment to the CWC was reduced due to various factors, excess payment in previous period, I cannot be related. Deduction of charges for lack of supervision required to be exercised, I cannot be held responsible. Curtailment restriction of to inflated bills of HNTC and certified subsequently by CWC, etc. It is pertinent to mention that
How do you explain this curtailment stroke restriction to inflated bills of
Yes.
HNTC?
Yes,
HNTC is you.
HNTC is me. They are saying that there may be some curtailment on my bill. Lord, the FCI should have indicated the amount that would have solved the problem. Now kindly see what they are saying on the second last paragraph. It is pertinent to mention that the supervision charges as well as certification of HNTC bill by CWC as required as per the mandate of ministry is a matter between FCI and CWC. They are saying HTC is
Whatever
directly
they may say, Mr. Chakraborty, regarding the last portion, they are still being vague. Curtailment restriction if the bills were inflated by you and was certified wrongly by CWC. If on that ground FCI withholds, that
is one of the ground.
that is related to
That
you.
is one of the
If
ground.
you inflated, they certify, both of you are responsible, you and CWC.
That is one of the ground. Let them disclose that particular amount. If that is 1 lakh, I will not get. If that is 2 lakh, I will not get. If that is 3 lakhs, I will not get. But the rest of the amount, CWC should pay me.
Yes, why are you not
Yes, it is
disclosing the
vague.
other portion?
Yes.
What is the curtailment
Yes,
restriction to inflated bills?
As per the direction of this honorable court, they
This honorable was directed you to give specifications. You have not specified, you are playing with the code. You have just stated excess payment for previous period, deduction of charges for lack of proper supervision. This much was indicated in the previous report also. So what about this? I specifically asked you on this due to reduction in H&T billed amount, which were claimed beyond specified operation, which results in reduction in corresponding supervision charges. I sought a clarification on this. On this, you have repeated it. You have said curtailment stroke restriction to inflated bills of HNTC and certified subsequently by CWC. If you carry on like this, then I'll have to direct you to pay directly to them.
Well, on this issue, my lord, I can. My lord.
Only the quantum of this. Come back tomorrow with the quantum.
Only 1 week, my lord. May I-
Learned counsel for the petitioner points out that the petitioner raised a dispute as to non-payment of amounts due to the petitioner due to work done by the petitioner by the CWC. Full stop, next para. The CWC had taken a defense that the FCI, comma, which was the authority for which the CWC rents the godowns, comma, had not paid the due amounts, which was the reason for non-disbursal to the petitioner. Full stop. In a report submitted by the FCI on a prior occasion, comma, the FCI had given certain grounds for non-disbursal of the amounts to the CWC by the FCI. Full stop. This court, comma, being unable to understand a portion of the clarification sought to be given by this FCI, comma, had sought a further clarification. Full stop. The portion which was not intelligible to the court was a ground given by the FCI for non-disbursal to CWC that within double inverted due to reduction in H and T billed amount which were claimed beyond specified operation, which results in reduction in corresponding S capital supervision, C capital charges of double inverted close certain points. Full stop. In its clarification, comma, the FCI is as vague as possible by stating that the curtailment stroke restriction to inflated bills of H and TC and certified subsequently by CWC, comma, was one of the reasons for non-disbursal of the amount. Full stop. It is unfortunate that despite being given an opportunity, comma, the FCI still does not disclose the exact amount which has been withheld by the FCI to the CWC in lieu of curtailment stroke restriction to inflated bills of HNTC and certified subsequently by the CWC. Full stop. The vagueness and suppression by the FCI on such score, comma, unfortunately delays the disposal of the present matter further, comma, since the court cannot fix the exact liability of the CWC vis-a-vis the petitioner if the FCI goes on suppressing its actual claims against the CWC. Full stop. Next para. Hence, the FCI is directed to disclose specifically the exact amount which has been withheld by them from the CWC on account of alleged curtailment stroke restriction to inflated bills of HNTC and certified subsequently by CWC, as indicated in the supplementary report filed today. Full stop, next para. The learned counsel for the FCI shall indicate to the court such amount tomorrow when the matter shall be listed again under the same hearing. Full stop. The supplementary affidavit filed today by the FCI, the supplementary report filed today by the FCI be kept on record.
Instead of tomorrow,
Tomorrow.
2, 3, this week only, this week, they may take further time to get
ঠিক আছে, tomorrow না করে day after tomorrow করুন। Day after tomorrow ডেটটা দিয়ে দিতে হবে। Today we are on September 27. September 27.
Lord,
Prior
29
report may be given to us, my lord. A prior report may be given to us. The report that they are filing, my lord, a prior copy may be given to us.
Copies of the report, add line add করেন, copies of the report filed today, copies of the supplementary report filed today be circulated among the CWC and the petitioner, if not already circulated.
Lord, may I make one request? For 27th, I would have some difficulty, Lord.
When?
Tomorrow it is fine, or Lord, next Tuesday, my Lord, may keep it on 3rd, Lord, because I'm so sorry, Lord.
Third, then not as a top matter. তাহলে ওটা যেটা বললাম returnable date on October 3, 2023 under the regular heading, not as a top matter.
Then let it be on.
No, we cannot bargain. You call on it.
I will not appear, someone else will appear, my client will suffer.
No,
kindly.
Item 9.
Yes.
Item number 9, Lordship, item number 9, I am led by Mr. Shatru Banerjee, Lordship. But the respondent, Lordship, may kindly pass it over for it.
But I'm for the petitioner, my lord. I'm led by the learned advocate general, my lord. He is on his legs. I was also praying for if a matter can be passed over.
Both sides ask for a passover stroke adjournment, full stop, since the matter is appearing under the heading top, depriving other matters of similar urgency, let the matter stand adjourned for the day and shall next be listed tomorrow under the regular heading. Call the next.
Item 10.
Please, Lordship, I am for the CSC also. My Lord, CSC authority disconnected my line without notice, without outstanding.
On the last occasion, there was direction for filing affidavits, Lordship.
My Lord, I am reply also. My Lord, allegation, there is a suit, but against me, no suit has been filed, and my premises is just separated as per corporation record. That is now 3 by 3 by 1. And original premises was 3 by 3. And no order against me is pending, no belief come for. I am absolute possession of that premises. Maybe shifting.
What are you wanting now? New
But
connection?
they disconnected my line without any dues, without any.
Yes, Mr. Nayak, why disconnected? Sorry.
My lord, we respectfully submit, my lord, the petitioners, they were ousted by the order of eviction passed with the civil court. So, my lord, landlady and her son, my lord, filed one affidavit that I have annexed here also, stating all these facts and also giving some of the decree and others. In the decree, my lord, his name is appearing. And my lord, they have been ousted. The bailiff's report is also there. We have submitted it. And my lord, with that, against that, my lord, no specific reply has been given. But he has said there might be one case and might be my brother has been ousted. I have not been. It was a
separate bailiff report you have annexed here.
Lordship.
Show me that bailiff's report.
Lordship. Before that, Lordship, kindly say, come
no,
to
first show the bailiff's report.
Lordship. That is that, my lord. That is that, my lord. Page start from page, my lord, 24, 25. 25, the settled property. And Lordship kindly sees the bottom portions. Settled property identified by the landlady's and son. And Deni said Somor Pal, so and so, received vacant position. My lord, last, and that has been submitted.
HON'BLE is a different premise.
Scheduled premises is there.
3/3.
That is what we are saying. The landlady is saying 3/3.
This report has been accepted.
Yes, my lord. I have also that.
Now they are saying in 3/3/1. They can make
I am absolutely.
they can make an application, and CS will consider that and give connection.
So this is a report. There is any order of court accepting this report?
Yes.
My lord,
এটা ফেরত দিন।
that epic, my lord, execution, title execution case was.
তুমি দিন। No, Mr. Haldan, no.
No.
Any reply? Because I'll dismiss your matter.
Well, before dismissing, my lord, the usually originally the premises was 3/3, and after that it was duly mutated. Now 3/3/1. I am there, my lord. Will kindly see the reply. My lord, I have annexed. My lord, kindly see the reply. I have one letter of the that is page 4. R1. The premises is 3/3/1. And my lord, where I am absolute in possession. No eviction, no suit has been filed against me. This is the order of the corporation. My premises is 3/3/1 after partition. I am there in possession, my lord. For shifting, that is another story. But I am in that premises.
You say 3/3 and 3/3/1 are different premises.
Now it is a different premises. If it is shifting is necessary, that is another story. But premises is now divided 3/3/1, and I am absolute in possession of
Meter is in 3/3.
But meter
It is in 3/3, and mother and son requested.
Kindly see the
And-
annexure, which has been annexed by my learned.
And he
My
used to
No,
derive
all the decree and the other documents refer to 3/3.
3/3.
Meter
if you're-
was installed in 3/3.
That has been disconnected.
If
Below on
you
the
can
This
see
issue we
the
cannot decide here. No, Mr. Haldan. Issue at all.
My lord,
Senate counsel for the petitioner submit that the petitioner is a tenant in respect of the disputed property. However, his electricity connection was cut off by the WBSC
CSC.
by the CSC without giving any notice to the petition. Push up next para. Learned counsel for the CSC Limited places reliance on the affidavit in opposition filed by the CSC Limited and submits that an eviction decree was passed at the behest of the private respondent stroke landlord against the petitioner. Pursuant to the said decree, the bailiff has given possession to the private respondent. A bailiff report is also relied on by the CSC Limited. Next para. Learned counsel for the private respondent also corroborates the contention of the CSC Limited and submits that the executing court has itself recorded that the execution case is disposed of with full satisfaction. Next para. Learned counsel for the petitioner seeks to argue that the petitioner is in possession of premises number 3/3/1, Ramkrishna Mandir Path, Howrah, whereas the decree was obtained in respect of 3/3. Next para. However, the petitioner, the private respondent, as well as the CSC Limited point out that the electricity connection was obtained by the petitioner and was standing in the name of the petitioner in respect of premises number 3/3 and not 3/3/1. Next para. It transpires from the records that the petitioner's electricity connection, which has now been severed, stood at premises number 3/3, Ramkrishna Mandir Path, Howrah, Full stop. Although the petitioner seeks to argue that the present number of the portion of the petitioner is premises number 3/3/1, comma, we find that there is nothing on record to justify such claim. Full stop. In fact, comma, the eviction decree was obtained against the petitioner by the private respondent in due course of law. Full stop. As per the direction of a competent civil court, comma, the execution took place and the bailiff filed a report whereby dispossession from the premises is indicated. Full stop. Although the person from whom such possession was taken is not the petitioner, comma, the same is a proper disconnection in same is a proper disposition stroke eviction in due course of law in terms of the relevant legal provisions. Full stop. Moreover, comma, since the executing court itself has recorded with a order dated September 26, 2022, that the bailiff submitted his report, and from the same it appears that the writ of possession was executed and the execution case was disposed of with full satisfaction, comma, there is no scope of reopening the same by the writ court. Full stop. Hence, comma, the petitioner having failed to prove that the petitioner is in settled occupation of the property, comma, the petitioner is not entitled to get electricity connection. Full stop. By the same logic, comma, the CSC Limited was justified in disconnecting the electricity supply in respect of a premises where the petitioner is no longer in possession. Full stop. Hence, comma, WPA 16646 of 2023 is dismissed without an orders to cost.
Grateful Lordship.
Yes.
I am paying the shifting of the meter in my premises, my lord.
Apply for that.
My lord.
Grateful.
11.
My lord, I am for the respondent number 2.
Wait, please. But this is that matter where guardian is appointed to be appointed for a comatose patient, my lord. I hope the report has come from the medical board, my lord.
From the medical report, it's evident that he's not capable of taking care of it himself. But you had taken a point of maintainability on Order 32 rule, Order 32A of the Code of Civil Procedure. The report I'll keep on record. It clearly shows that you are the respondent number 2. How is he or she related? Who are they?
No, Union of India and the
Union of India, Secretary, Ministry of Health.
Oh.
Union of
You
India,
had cited certain judgments
Secretary,
also.
Ministry of Health.
Well, I'll conclude the arguments and pass my judgment. I'll look into the judgments. I'll see whether this writ petition is maintainable and pass my order. Because I'll have to deal with your point of maintainability also. For that only I'm reserving judgment. Otherwise, the report clearly shows I'll record that. I'll keep note of the record and close arguments on this.
But the report has been also submitted to us.
It has been given to you?
Yes, to the advocate.
The state learned counsel for the state files a report as per previous direction regarding the physical and medical condition of the patient, for whom the petitioner seeks to be appointed as legal guardian for all practical purposes. Full stop. A copy of the report has also been handed over to the petitioner in advance. Full stop. I find from the report that the medical board has come to a unanimous conclusion that the present physical, mental and neurological condition make the patient incapable of taking care of himself and perform day-to-day activities at present. Full stop. The said patient, what is the name of the patient?
Rajesh Kumar Osatwal.
The said patient, namely Rajesh Kumar Osatwal, OSATWAL, is presently bedridden, unable to comprehend and communicate and not in a state of taking any decision. Full stop. Since the report, in no uncertain terms, indicates the present debilitated condition of the patient, the only thing which remains to be decided is whether the writ petition is maintainable for the relief as claimed. Full stop. Hence, judgment is reserved in the matter. Full stop. The matter be listed on October 5, 2023 for passing judgments.
Oblige.
5th October.
12.
Your Lordship, for the
Lord, I'm for SABY, my lord. On the last occasion when this matter was taken up, my lord, I was given a leave to file a supplementary affidavit, filing a report.
Lordship, kindly seize your Lordship, page 98, your Lordship, for my satisfaction, your Lordship. Page 98.
Yes.
Your Lordship, page 98, for property B3, your Lordship, description. Your Lordship, it is shown as vacant land, your Lordship. But there is a premise, there is a building lying over it, your Lordship. So even if your Lordship, they proceed with this list, your Lordship, it will be like the intending purchasers will be bidding, your Lordship, for the vacant land, but actually it is not a vacant land, your Lordship. For that, they need to, your Lordship, come with a new list, your Lordship.
What do you disclose in this report?
My lord, in this report, my lord, when first time the matter was taken up, my lord, a meeting was called by the recovery officer to say what documents they have. And my lord, in the second auction time, my lord, they were given the opportunity to produce the documents to show any registered deeds or anything which they have in their name, the petitioners. My lord, in this report, my lord, it's a detailed report wherein SABY has stated that what has happened in the two meetings and what are the documents they have actually given to us to satisfy us with the ownership of the properties, my lord.
What are you appearing for?
Well, I am for SABY.
Yes.
So, my lord, in this report, my lord can come to page number 7 and 8, my lord.
Yes.
My lord, there is a list given in the table 1, my lord, of the number with the name of the petitioners and what the documents which they have given, my lord. Out of this, my lord, only serial number 3, my lord, Chaitali De, and my lord, serial number 6, Kanai Chand Banerjee is able to produce a registered conveyance deed, my lord. Others, my lord, they have not given any documents except some bills and my lord, notarized agreements and all, my lord. Now, my lord, with notarized agreements, we cannot prove ownership of our property, my lord. So, my lord, as per this report, my lord, if my lord sees paragraph number 8 and 9, my lord, it has been made clear by SABY that if they can produce a registered document, my lord, the ownership will be to show their ownership, my lord, SABY will not interfere with their ownership. And my lord, with regards to the vacant land, my lord, that is a mistake on part of the government authorities that they have showed it in Porcha, my lord, and SABY cannot investigate on the vacant land and non-vacant land, my lord. Now, since they are saying that there is a flat
SEBI understands it, but my lord, they have to show the ownership of the flat. My lord, there are, I think, 20 flats as they have said in the whole building.
Even if
my
they don't show the ownership of the flat, the vacant land remains, does not remain a
Lordship.
vacant land.
Lordship.
Then the entire notice goes.
So my lord, that
You
my
cannot
lord,
sell a flat, a structured property by saying that it is a vacant land.
And
How can this notice survive?
and
No.
you
Even if these people are not the owners, suppose they are not the owners, even then they have brought it to the notice of the court. The SEBI is holding an auction sale of one of the properties, at least has been shown to be a vacant land, but admittedly it's not a vacant land. It has a multi-storied building on it. You're
Lordship.
admitting that.
kindly sees 1, 2.
so my lord, in that case, my lord, we will issue a fresh notice if required, my lord, because my lord, we can't
Minus B3 at least.
at with B3, my lord, some has to satisfy us with the ownership. My lord, B3 only in any case, my lord, the ownership.
Suppose they are not the owners, we cannot direct you to hand over possession to them or do whatever. I mean, that they have a remedy in law before a different forum. They have to explore that.
Lordship.
We cannot go on that at all. And will not even hold that these persons are the owners. A writ court cannot conclusively do that.
Lordship.
My lord, may I just say, my lord, this e-auction has already been done, my lord. As per my lordship's order, this B2 property has not been touched even in the e-auction and has not been put in auction. my
Oh, the
lord.
auction has gone through
Yes,
without
my lord.
B3.
Yes, my lord. There was an injunction by this court, my lord. So we have not done it. And my lord, as per my instructions from my client, there are no buyers of this B3 property even. So my lord, in any case, they are safe. But my lord, the question arises is in the future, my lord,
Acha.
what would be the status of this property? Because my lord, this is the actual
No, in the future, I can, subject to hearing him, on this I will hear him. I can clarify in my order that you will be at liberty to hold an auction regarding this property. If otherwise in law you are entitled. I mean, I'll keep it at that. If I keep it at that, you can describe it properly and hold the auction
my
sale.
lord,
If they have a right in law, yes.
in the meantime, my lord, they can provide us with the registered documents if they have. If they will
That
get
if
some
they
time
choose,
also.
that will be an extra liberty to them, in fact.
So,
Yes.
But
Lordship.
SEBI has no, my lord, intention to push them out
Obviously,
of their house.
you're-
So, my lord, if they can just give it, we will settle. In fact,
See,
the-
I cannot create any right which you do not have in the property.
Lordship.
Now, the fact is that this land is not a vacant land. They have gone through this, they've gone
Lordship.
ahead with the sale.
Lordship.
That has been held without this land.
Lordship.
So this land remains as it is.
Lordship.
So I'll just clarify that this matter has become infructuous because the
Lordship.
auction has been held.
Lordship.
Regarding this property, I'll give them liberty to describe it properly and hold an e-auction.
Proper
subject to-
inspection, your lordship, they need to do that
subject to, in accordance with law, they will be entitled to hold an auction describing the property properly.
properly.
And in law, if you or any
Lordship.
other person has any right, you can take your recourse in law.
Lordship. Lordship, we do not have any problem. Lord, there are total 20 flats, your lordship. They have to do proper inspection and then your lordship, they need to.
Learned counsel for the petitioner, learned counsel for the SEBI files a supplemented affidavit where it is indicated by the SEBI that the property described as a vacant land at Mousa number 155, which is serial number B3 in the description of immovable properties, which is a part of the public sale notice, which is challenged here, it is indicated that the same consists of not a vacant land, but a property with a multi-storied building thereupon. Full stop, next para. However, despite having been given opportunities, only some of the owners of the flats situated in the said building have been able to come up with satisfactory documents to show their ownership. Full stop, next para. It is submitted that the SEBI has already gone ahead with auction of the rest of the property, leaving aside serial number B3 in terms of the injunction passed by the court. Full stop, next para. It is submitted, however, that in the absence of any proper document being produced by any person to establish ownership in the property, there is no restriction on the SEBI to go ahead with sale of the said B3 property as well. Full stop, learned counsel for the petitioner submits that the SEBI ought to hold such sale in respect of the serial number B3 property only upon holding proper inspection and upon ascertaining the ownership of the property. Full stop, next para. Upon perusing the documents on record, comma, what is evident is that the property shown at serial number B3 in the impugned e-auction notice is not a vacant property as described therein, but comprises of a building standing on the land. Full stop, next para. As such, comma, since the SEBI has already gone ahead and concluded the e-auction proceedings regarding the other properties, comma, leaving aside serial number B3, comma, no further relief can be granted to the petitioner at this juncture. Full stop, next para. Hence, comma, WPA 18967 of 2023 is disposed of with liberty to the SEBI to issue a fresh e-auction notice, comma, including serial number B3 as described in the impugned e-auction notice, comma, that is the property at Mauza number 155, comma, Thana and Sub-Registry Ranaghat, comma, Municipality, comma, Ranaghat, comma, District Nodia, comma, upon properly describing the same in the proposed e-auction notice regarding such property. Full stop, next para. However, comma, it is expected that the SEBI shall ascertain before putting the said property on auction, comma, that the property actually falls within the contemplation of the secured assets of the SEBI. Full stop. In any event, comma, if any third party, including the present petitioners, comma, have a right to the property comprised in the same, comma, it will be open to the petitioners and such third parties, comma, to approach the SEBI with proper ownership documents in order for the SEBI to consider such aspect of the matter before going ahead with the sale. Full stop. No rest to cause.
Much correct. Much correct. Much correct.
Upgraded matter, item 13.
Pay for the petition.
My lord, I am appearing for the state.
Yes, Your Lordship, I have served twice.
I am appearing for the state, my lord.
Section 14.
Lordship, my application pending since 4th December 2020. Your Lordship.
No challenge you have stated somewhere in your application.
Lordship, it was filed. There is no surface application.
But you should mention it in on affidavit in the application itself.
Your Lordship, it was filed in 2021. Since then, it is pending. But there is nothing within our knowledge. Nothing has been served.
Learned counsel for the petitioner bank submits that there is no encumbrance on going ahead with the proceeding under section 14 of the SARFAESI Act. Full stop. It is further submitted on instruction that the borrower the borrower has not taken out any challenge before the debts recovery tribunal in connection with the proceeding. Full stop. Next para. It is argued that the bank's application under section 14 of the said act is pending for an inordinately long period, comma, despite the statute stipulating 60 days as an outer limit thereof. Full stop. Heard learned counsel for the petitioner and the state. Full stop. The petitioner is justified that the matter could not have been kept pending for so long as per law. Full stop. Next para. Accordingly, WPA 13477 of 2021 is disposed of by directing the concerned district magistrate, that is
Paschim Mednipur, Your Lordship.
Respondent 2.
That is the respondent number 2, comma, the district magistrate, comma, Paschim Medinipur, comma, to dispose of the pending application of the petitioner bank under section 14 of the SARFAESI Act, comma, against the private respondents, comma, as expeditiously as possible, comma, positively within 3 weeks from the date of communication of this order to the respondent number 2. No orders to cause.
Lordship, my affidavit service be kept.
Service kept to be kept. 3 weeks from communication.
Lordship.
14.
Lordship, similar matter here, the district magistrate Purva Bardhawan. I have served twice in this matter also. Initially the writ petition and thereafter a notice.
Learned counsel for the petitioner bank submits that no application has been filed by the private respondents in connection with the pending proceeding under section 14 of the SARFAESI Act. full stop. It is further submitted that there is no encumbrance in the section 14 application being decided expeditiously. Full stop. I find from the records that the application of the petitioner bank under section 14 of the SABYASACHI Act is pending much beyond the outer limit of 60 days as stipulated in law. Full stop. Accordingly, WPA 19318 of 2020, this 2021
2021.
of 2021 is allowed, comma, thereby directing the respondent number 2, that is the district magistrate Purbo Bardhaman, comma, to dispose of the pending application of the petitioner bank under section 14 of the SABYASACHI Act against the private respondents as expeditiously as possible, comma, positively within 3 weeks from the date of communication of this order to the respondent number 2. Notice.
I am for the appearing on behalf of the widow mother of the respondent number 5.
Right.
In this case, we for protection of life and property.
You are
and
for the
maintenance.
petitioner. You are for
Yes,
the
under Senior Citizens Act, my lord.
right.
My lord, this widow's husband was carrying business, stamp bending business at the Saraswat of Sriampur sub-district office under license number 8 of 1956. My lord.
Yes.
Since then, he has been carrying the business there, my lord. Due to old age, he was unable to maintain the business. Then he applied to the authority to transfer that license in favor of the respondent 5 who was unemployed at that time. My lord. Then, my lord, thereafter, after taking consent from the mother and another elder brother, my lord, transferred the license.
Was carrying on initially, respondent 6 was carrying on.
Yes,
Yes.
that's what I think.
Very well.
Then, my lord, I made a prayer before the district magistrate, who is a competent authority, and casted with the duty to look after the interest and protect the life of the property of the senior citizens.
No.
Then, my lord, he replied.
You are the mother.
Mother, my lord. And that my lord business, thereafter, that license has been transferred in the name of the second son, my lord. And after 3 years, my lord, he started to be with the mother, parents, and brothers, my lord. And he separated himself, started married himself. And he started, my lord. Thereafter, due to the my father died. Thereafter, she stopped the maintenance from the income from the business.
You are the mother.
I am the mother, my lord.
What is your cause of action for the writ petition?
Yes, my lord. My cause of action, my lord, after the death of the husband, this respondent number 5 was carrying business in the capital with the capital of the father. He stopped the payment because this is the source
You
of
have a
income.
right of maintenance. You go under the before the appropriate forum under the senior
Yes, my
citizen.
lord, the tribunal is no
Maintenance
jurisdiction, my lord. Tribunal only
Terms of the-
10,000 has been there. But my
Can't get you. Can't understand you.
tribunal constituted by the West Bengal government, my lord, pecuniary jurisdiction has been given only 10,000 maximum. Thereafter, my lord, my claim is that from income, my lord, that business, she's earning 1 lakh per month. We have given the
10,000 is the outer limit.
Yes, outer limit. And
If-
second thing,
My lord, may I submit? We are private respondent. The transfer of the license was sometime in 2015. There is no dispute, my lord. It is admitted fact. After the demise of the father, my lord, of the respondent number 5 herein, my lord, the petitioner respondent number 5 was ousted. Entire property which was the left out by the demise of the father of the such and such, my lord, and they have invested all the money which was acquired from the bank and the LIC and such and such. I will produce your lordship, my lord, the maintenance, whether maintenance, the grievance of the petitioners for maintenance of a senior citizen maintenance. That is absolutely, my lord, that is the other forum.
No, your learned friend is saying that the forum, the outer limit, pecuniary limit of that forum which has
your
been
lordship, can you
constituted is
see?
10,000.
10,000. Then approach. If, my lord, it is the 10,000, all limit is there, my lord, 10,000. If they claim, my lord, they have to approach, then they will
refuse the maintenance application is not maintainable, or the limit is
No, no,
there,
if their claim is more than 10,000, how can they approach that forum?
then this forum is wrong.
Then they don't have the forum. That's why they've come
Then
in. a
125, but here is not. Here, my lord, he cannot claim, my lord, your logical is seized. I'm coming to that, my lord. They have.
It's happening for the state.
I am here for the state.
What is your stand? The outer limit is 10,000.
Your logically seized.
10,000, he can approach before the criminal code under section 125.
That is there. That is there.
You see, but this writ application is not made.
May disturb.
Have you got a copy of that act, Senior Citizen Act?
Yes, your logically seized.
She made an application, that application is pending before the authorities.
Before the?
Before the authorities concerned, she.
Your logically seized, your logical.
Maintenance and welfare parents and senior citizen. Before the district magistrate, and that is.
Maintenance tribunal, your logically seized the maintenance tribunal.
No, why have you given an upper limit of 10,000? Is that sanctioned by law?
Yes, that is the rules.
That is the rules.
Your logically seized rule 16. In terms of the section.
He has to challenge the virus of the, my lord.
Then if it is invalidate, my lord, then they can challenge in other forum.
Yes, you're right.
I am not.
Why can't you? Why shouldn't you go before the? Because there's a competing claim. This is a factual question which you have to decide how far you are entitled. So why don't you go to the criminal court under 125? Or as a dependent, even you can go to the civil court.
Maintenance tribunal.
I made a prayer, district magistrate made a order. Thereafter, I made a appeal to the secretary to the department, to the social department. He directed, department, my lord, they have remained tight. Because.
Then appellate forum is there.
Have you ordered any have you challenged any particular order?
Yes,
No.
Your lordship, the inaction. He must honor the order of the superior authority. He cannot remain tight about the matter, slept about the matter. Page 46, my lord.
The petitioner.
Where is your claim? Before the authority, where is your claim?
Yes, my lord.
Give me the page number.
Yes, page 39, my lord. First claim is that annexure P4. Thereafter, we made, my lord, annexure.
Starts from page 34.
34.
What is the prayer portion of that?
Yes, my lord, page 39.
What is the quantum you have claimed? Alimony?
30% of the profit.
30% of the profits of the business, which minimum income, monthly income is more than 1 lakh.
Johnson.
Your lordship kindly.
Under section.
You have already filed an application before a forum. Either that has to be decided, or if you waive that, you can go before the other forums.
No, my lord, my lord,
Your
order,
lordship, this is the
estimate
section
state
5
because
sorry, my lord.
estimate state is boasted with the power and he is casted with the duty to look after and to take steps.
Not beyond 10,000. Your claim is beyond 10,000. How can it decide?
No, district magistrate, because my lord, kindly, no decision has been given, despite of direction given by the secretary.
So I can give a direction on the district magistrate to give a
A time bound direction may be given, my lord.
No, your lordship
Kindly.
kindly.
And he should.
They have filed an application before the district magistrate,
No,
which is pending.
not in proper form.
Not in
Section
proper-
5, your logically seized the section 5. What is the section 5 says?
It's been responded, an order was passed.
What is the section 5?
41.
And what for she has been.
Section
claiming?
5.
District
That is
magistrate passed an order on page
Section 5.
Of the writ to
On my
application. It is his statement.
Application for
maintain.
maintenance, section 5.
Yes. What do you want to say on section 5?
Then application for maintenance under 5?
They have not made.
They're not. They have not done. They have not complied. Let them show.
You have not filed any application under the Senior Citizen Act.
Here filed, my lord,
Where-
we did not mention because
I'm not understanding, Mr. Chakraborty, please. I'm not understanding what he's saying. Have you filed or have you filed? Not
filed.
So that one.
Page 34.
Order has been passed in page 41.
Ota application.
Without
On the prayer made by me on the annexure, my lord, they passed the order at page 46, secretary to the department.
46 की वाला है?
46 is not an order.
No.
41,
Where is the order passed?
page 41. On maintenance silent.
That has been rejected.
On maintenance silent.
Your compassionate application has been rejected.
That is
Second alternative prayer rejected, but main prayer for maintenance not.
And thereafter,
Appellate forum.
petitioner
approach before the honorable court, this honorable court, your lordship kindly come to page 32. The order passed by my lord,
Main
Mr.
prayer
Justice
aspects are
Bosak.
not considered.
32, page 32.
That is alternative prayer.
That has been rejected. And your lordship kindly come to para 7 of the writ petition.
That is not rejected, my lord. They only
His son has
expressly
not got
repeated to
the
transfer.
appointment on compassionate ground. This is a fresh appointment
First prayer.
he got.
At page 39, first prayer has not been considered at all.
Para 7, a fresh stamp pending license has been given to the second son on Animesh Rokhit.
Sir, page 39 main prayer consider করিনি।
This is not a compassionate appointment. It is harsh statement.
The petitioner is the mother of respondent number 5.
Respondent number 5.
Of respondent number 5.
Yes.
Full stop. It is submitted that on the demise of the petitioner's husband, comma, who was a stamp vendor, comma, you wanted the elder son to get it,
No, my lord. Elder son is my lord. We
comma, যা বললাম সেখান থেকে, comma, despite the wishes of the petitioner, comma, petitioner stroke widow, comma, the stamp vending license was given to the respondent number 5. Full stop. Next para. It is argued that from the said stamp vending business, comma, the respondent number 5, comma, one of the sons of the petitioner, comma, is earning a huge amount but is not disbursing alimony to the petitioner. Full stop. Next para. It is submitted by learned counsel for the private respondent that the stamp vending license was duly given to the respondent number to the private respondent. Full stop. If the petitioner has a right of maintenance, comma, it is submitted that the petitioner ought to approach the appropriate forum for such remedy. Full stop. By placing reliance on section 5 of the Maintenance and Welfare of Parents and Senior Citizens Act, comma, 2007, comma, it is argued that the present writ petition is not maintainable. Full stop. Learned counsel for the state points out to a previous order of a coordinate bench, comma, annexed to the writ petition itself, comma, whereby an application of the petitioner's other son, comma, for compassionate appointment as a stamp vendor, comma, was refused by the coordinate bench. Full stop. It is submitted that in terms of Rule 16 of the rules framed under the 2007 Act, comma, the upper limit of maintenance to be awarded under the 2007 Act is rupees 10,000, comma, for which a tribunal has been formed. Full stop. Accordingly, the petitioner ought to approach the appropriate forum. Full stop. Next para. We find that the petitioner's claim is above rupees 10,000 per month, comma, with regard to alimony. Full stop. Insofar as the claim of compassionate appointment is concerned, comma, the same has already been dealt with and dismissed by a coordinate bench. Full stop. Hence, comma, the present relief of the petitioner does not lie in respect of the stamp vending business, comma, which is not a hereditary property of the petitioner's deceased husband, but one of alimony from the private respondent. Full stop. Next para. Since the petitioner's claim is admittedly beyond rupees 10,000, comma, the proceeding pending before the concerned authority under the 2007 Act, comma, in any event, comma, is not maintainable. Full stop. Hence, comma, WPA 21565 of 2022 is disposed of by directing the concerned district magistrate, comma, that is respondent number 3, comma, to decide the petitioner's application for maintenance as expeditiously as possible. Full stop. Next para. It is made clear that in the event the said application is dismissed as not maintainable on the ground of pecuniary jurisdiction, comma, the petitioner would be at liberty to approach the appropriate criminal stroke civil forum, comma, either under section 125 of the Code of Criminal Procedure or under any of the maintenance statutes available before the civil court, comma, claiming alimony as paid for in the present writ petition. Full stop. Nothing in this order shall prevent the petitioner from so approaching. Full stop. If so approached, comma, the appropriate forum shall grant appropriate relief to the petitioner as the petitioner is entitled in law. Full stop. একটা জায়গায় যেখানে disposal করলাম writ petitionটা direction দিলাম respondent to dispose of as expeditiously as possible, positively within 3 weeks from the date of communication of this order to the said respondent.
My lord, instead of 3 weeks, make it 4 weeks, my lord.
1 week is necessary. It will be rejected as not maintainable after my observation.
My lord, since we have not used any affidavit in opposition, my lord, the
I'm
claim has
grateful.
not been admitted.
Since affidavits have not been directed, comma, it is deemed that none of the allegations made in the writ petition are admitted by any of the respondents.
Grateful.
I'll take up the next matter after 10.
was a question of maintainability kept open, my lord. If your lordship kindly goes to, my lord, the order dated 15 December 2020.
I'll address your lordship on one point.
Despite exchange
coming
of
up for
affidavit,
final-
my lord,
Correct. Coming up for final hearing after exchange of affidavits. So I'll.
Mr. Banerjee, what is the urgency? Why? Because I'm not being able to take up so many urgent
I
matters.
understand, my lord, that-
Hearing matters, if I get fixed up, that is what is happening here. Because I'm getting blocked in some of these hearing matters and the other matters are not being taken up. If you're enjoying an interim order, Mr. Banerjee,
I'm
why
not, my
shouldn't
lord. I'll indicate what has happened. My lord, even on the last occasion we had appeared, there was an adjournment that was taken. My lord, the urgency is that there are certain amounts that are to be disbursed to me under the scheme. That money that I use gets pumped back into the process for students to be trained and placed. Now, this money has not been refunded, not been given to me under the scheme on two grounds. Again, I don't want to make the thing that I'll take 10-15 minutes. It will require a little examination of certain documents, but there is an urgency. But if your lordship feel that we can come back on a certain day at 2 o'clock and do the matter, because I'm aware of the pressure that your lordship is under in this
thinking
determination.
about that, yes.
No, there are about 830 students. Their lives are stuck because I am here and the payments have not been made. I run a center. So at any day, if your lordship keeps it at 2 o'clock and gives us, at least gives me 25 minutes.
What is your matter? I mean, give me your main points. Can it be done? I think some time will be taken for this.
Yes.
as because, my lord, release of the second installment depends upon the compliance of the terms and condition of the first installment.
That I'll be able to
But we find from inspection there are violations. That's why, my lord, the second installment, my lord, could not be, my lord, released.
That is their case. I'll probably be able to show that there is not a bar, but that is the
I'll
content.
keep it on 10th of October, 2 p.m. Let the matter be listed for final hearing on.
Could I pray for slightly more advanced time?
Let the matter be listed for hearing on October 5, 2023 at 2 p.m.
October 5.
Number 2.
5th October.
Great.
17.
My lord, item number 17, I beg to appear for the petitioner. My lord, this is my petition challenging the impugned order dated 5th August 2022 passed by the District Magistrate Murshidabad. My lord, while passing the order, no representation taken from me. I wanted to make a representation, but I was not there at the time of hearing. At the district, when the matter was called for hearing on 2nd of August, pursuing to the order of this honorable court, if my lord gives me 10 minutes, I will take you, my lord, through the brief facts of this case. My lord, there was an earlier writ petition challenging the arbitrary action done by the respondent number 4. Respondent number 4 is Adani Powers Limited. They have set up high capacity overhead wares over my land. That is situated in the district of Murshidabad. I am a cultivator. I do cultivation works. I have mango trees, lychee trees, and all those trees were cut when the high capacity wares were set up. Then I had made my representation before the Adani Powers Limited as well as the competent authorities, district magistrate and all the authorities, but all my representation went in vain. Then I came before this Honorable High Court and my lord has passed an order dated July 5th, 2022, directing me to my lord, that order has been annexed in the writ petition that will appear at page number 18, my lord. My lord, in that order, this honorable court has directed me to take my representation to the district magistrate and also directed that district magistrate will hear me and hear all the parties concerned and pass a reasonable order. My lord has also directed the district magistrate will compute the amount of compensation. My lord, I had made my representation on August 2nd, but that the district magistrate was, as I have been instructed by my client, that the district magistrate was not available. That after that, on 5th of August, district magistrate had passed an order without even giving me an opportunity to give a reply to the reports that had been submitted by the opposite parties, also without giving me an opportunity to hear whatever case I have. And meager amount of 4 lakhs as a compensation. My lord will come to page number 27. Only rupees 4 lakhs that was ordered, that I am entitled to, and that was ordered on munificent ground. My lord will come to the last paragraph, just over the paragraph, rupees 4 lakhs on munificent ground.
But the difficulty is in this, it's not an acquisition in the proper sense. You won't get the entire value of the land.
No, my lord.
It has to be for diminution as the
My lord, whatever value,
diminution of value.
whatever value I will have, that has to be computed after taking my representation, my lord.
But the district magistrate says, in compliance with such and such order, a date of second hearing has been fixed on August 2.
My lord, second hearing was on August 2nd. The first hearing was on 25th of July. That,
so you say this order was passed without hearing you?
Without hearing me, my lord.
Then I'll have to remand it back.
My lord, kindly, my lord, takes, my lord, the order. My lord, will come to my page number 24.
Yes.
My lord will see the observation part. The case record is put up today and the matter is heard. From the report as advanced by Block Land and Land Reforms Officer Farakka, Murshidabad, it is revealed that on 27/7, that's after the order of this court, 27/7, the revenue officer of the concerned Gram Panchayat personally went to Lutfur Rahman, who's a petitioner, house to serve notice of inquiry on 29/7/2022. But Lutfur Rahman refused to receive the notice, though he had been apprised of the inquiry, which will be conducted on 29/7/2022 in connection with the above matter. But he then, my lord, refuses to appear before the or receive the notice. And then, my lord, the district magistrate, my lord, has, my lord, on basis of the materials available before.
So that refusal was at the juncture of inquiry.
Never participated, my lord. Also, my lord, I have instructions, my lord, that, my lord, he has received the compensation.
No, he had to have a copy of that report. Even if he was not available at the time of the inquiry being held, he had to have a copy of the report. His argument had to be heard on that.
My lord,
My
lord friend submits that his objections were not recorded, not considered, my lord. But perhaps on 2nd of August.
What is the scope of his giving an objection if the copy of the report was not given to him? The magistrate proceeds only on the premise of that report.
My lord, may I, my lord, humbly submit to this, my lord. Although, my lord, this is beyond the scope of the relief, because here, my lord friend says that there has to be an order, my lord. Oh, so, my lord, one more aspect of the matter. I just wanted to, my lord, make this court apprised of. My lord, this was, my lord, transmission line, my lord, between the government of India had entered into an agreement with government of Bangladesh, my lord. Pursuant to that, my lord, the government of India had empowered the respondent number 4 to act as a telegraph authority under the Telegraph Act, my lord. There are notifications, my lord. Now, my lord, pursuant to that, my lord, they have taken steps, my lord. My lord friend, my lord, have appeared, have taken compensation also. They have also accepted the compensation. Yes. And now, my lord, I just do not have the papers today, my lord. Kindly give me 1 day's time, my lord. I shall bring on record.
My lord,
may I just come? Not only that, they have taken the compensation, my lord, they have also preferred a public interest litigation which is pending before court number 1. It's appearing today, my lord. So he is one of the petitioner in the self-same matter, my lord.
Public interest litigation regarding what?
Well, that this the entire exercise is dehoves the provisions of law and it has been arbitrarily done, my lord. With no reference, that I have all the documents to show that, my lord.
That is a different aspect.
That's a different, but there also, my lord, they have alleged that they have not given any compensation. Their cases, nothing has been given, but they have accepted compensation, my lord. May I only want, my lord, I wanted to show these documents to demonstrate that they have accepted it, my lord.
Yes, what do you say on acceptance?
My lord, I have instruction from my client. We have not accepted one single penny.
Very well, my lord. In that way, my lord, he may be correct.
After tomorrow, give him a copy.
Yes, I'll give him a copy. If he is correct, my lord, I should stand corrected, my lord.
File a written instruction on that.
I shall file a written.
Yes.
Union of India, I don't think Union of India is a necessary party in this.
Union of India is respondent number 1.
Respondent number 1.
And the project, my lord, has been completed and it has been handed over to the Bangladesh government.
No, you have been implemented probably as a sister concern of Adani.
Minister.
Learned counsel for the respondent number 4 submits that the petitioner, despite having challenged the compensation, has already received the compensation. Full stop. In order to furnish proper documents in that regard, learned counsel for the respondent number 4 seeks an adjournment. Full stop. Accordingly, for such limited purpose, the matter is adjourned till September 27, 2023, when it will be listed under the same heading.
My lord, I am submitting the affidavit of service.
Affidavit of service filed today be kept on.
I'm deeply aware.
Grateful.
I appear for the petition.
My lord, on behalf of the all respondent, Mr. Tilok Mitra is appearing, but he is suffering from dengue. Kindly adjourn the matter for 2 weeks.
No, 2 weeks cannot. For 2 weeks, no. Make alternative arrangements. Come back next week. Yes. What do you have? What is the urgency here?
My lord, this is an application. My appeal under right to information at first appeal is kept pending for an indefinite period of time. I want a disposal only.
Mr. Tilok Mitra is not required for this. I'll dispose it off right now.
My lord, kindly adjourn the matter.
No. Since when is it pending?
It is pending since it was filed.
Are you sure Mr. Tilok Mitra is appearing in this matter? For whom?
For all the respondents. Over the phone, he just informed me.
It is appearing before the first appellate authority.
First appellate authority.
Which respondent?
Respondent number. Respondent number 9, I think. The deputy director. No, my lord, this is.
My lord, kindly adjourn the matter for a week only. Kindly for a week.
Yes.
Addressed to deputy first appellate authority come deputy secretary investigation 3.
Which respondent? You are seeking an order against the first appellate authority. You have not implemented him, Mr. Chakraborty.
I find this, my lord, actually Mr. HON'BLE Kumar Banerjee is the advocate on record. Due to his illness, I have been requested to appear for him. I did not
counsel for the respondent seeks a fortnight's adjournment. Full stop. Let the matter be listed in the monthly list of October 2023 under the normal heading, not as an upgraded matter.
My lord, liberty may be granted to at the appropriate authority.
Which appropriate authority? You are not even sure about that.
No, the deputy secretary, the appellate authority, I find he is not made a part.
So, act line add kar dao. The leave is granted to the learned advocate for the petitioner to implead the appropriate appellate authority and carry out the necessary corrections in the cause title of the writ petition in the meantime, as well as to serve a copy of the writ petition on the said added authority and file affidavit of service on the next date of hearing.
May I present affidavit of service may be filed?
Affidavit of service filed today be kept on prothom line add kar. Be grateful to him.
19.
Yes.
My lord, I am for the petitioner, my lord. On the last occasion, my lord, the respondent seek for time, my lord, adjournment, my lord.
You move your matter. I'll take up the matter.
My lord,
I am appearing for the respondent number 2 and 3.
my lord, kindly comes to page 12, my lord. The ESI authority, my lord, by a notice, my lord. Page 12, my lord.
Yes.
My lord, they have stated that under 212, my factory falls under, my lord, Factories Act, my lord. As such, my lord, ESI is, my lord.
This is 212 of Factories Act.
Yes, 212 of Factories Act, my lord. Comes to, my lord, para 4 of the notice at page 12, my lord. On the basis of the particulars in respect of the factories, as per the report of the inspection conducted by the insurance inspector who inspected your factory establishment on 7/2/2013, your factory falls within the purview of section 212 of the Act with effect from 7/2/2013, my lord.
Not the ESI Act.
No, not the ESI Act. Hence, under ESI Act, my lord.
Not Factories Act, it's ESI Act.
Yes, ESI Act, my lord. As it is designated as a factory under section 212, it is under ESI Act. My lord, now, my lord, this inspection was never been conducted, my lord. I'll show, my lord, when the inspection is conducted, my lord. My lord, page 14, my lord. My lord, now they raise a demand, my lord, without specifying the demand. On scrutiny of the records, your factory maintained in the office, it has been observed that no compliance has been made in respect of the employees employed for wages during the period during 6/6/2013 from 7/2/2013. This is somehow reverse, my lord. My lord, kindly takes the next page, my lord, 15, page 15, annexure P2, my lord. Now they are conducting an inspection, my lord. My lord, kindly sees Eastern Confectionery. My lord, I make breads, my lord. Amit Biswas is the staff. My lord, kindly sees, my lord, in the right hand in bottom, my lord, not known, my lord. Number of coverable employees as on date. Number of EFS for which TIC granted. My lord, not known, my lord. Kindly sees. My lord, before, my lord, inspection, they say we have conducted an inquiry that has not been conducted. Inquiry was conducted on 23rd.
What are you challenging now?
My lord, I am challenging 3 notices, my lord. Kindly comes to next page, my lord. Page 16, my lord. This is the first notice, my lord. Kindly sees of 47,054. My lord, it's for October 2013 to September 2014, my lord. Kindly see paragraph number 3.
This is an application to the recovery officer.
Recovery officer.
Yes.
My lord, next page, my lord, kindly sees. My lord, I went to the office. I said does not fall because I have less than 5 employees, my lord. Is a bread factory, my lord, making 200 breads, my lord, per day. My lord, it's less than 5 employees, my lord. I have attendance register.
So why are you challenging the notice? You must have appeared in pursuance of that.
My lord, in pursuance, my lord, I am not a factory, my lord.
That will be decided in the hearing.
My lord, kindly, my lord, send me back to the hearing, my lord. There are 3 notices, my lord. 31st August 2022.
These are 2013 notices. Why are you preferring the challenge in 2020?
My lord, I have challenged the last notice, my lord. 31st August 2022, my lord. Kindly sees.
What is the page number?
Page number is 18, my lord. Now, my lord, they have not stated the earlier claim. They must have.
But what happened to the earlier claims?
Nothing, my lord. I went to the office. They said we have made a mistake, my lord. It was.
So they did not proceed with the previous claim?
No, nothing done. 13 and 16, they have done nothing. 18th August 2016.
On what ground are you challenging 31st August? Because you did not challenge the previous order still for so long.
So, my lord, I am not a factory under the Factories Act. I have five employees, my lord. Kindly sees, my lord, next, my lord, page 20, my lord.
Yes, why didn't you proceed on the basis of your previous notices?
My lord, may I submit one thing, my lord, that this writ petition is not maintainable in this sense, my lord, because there is provision in the Act, my lord, section 75, if your lordship kindly have a look.
Against any order, if passed against them.
If there is any dispute against the Employee State Insurance Corporation relating to coverage or against the payable contributions, they will have to approach If they are
That would be premature in this case because they've just challenged the notice. I'll relegate them to you, the recovery officer, where he'll give a hearing to you and them and they will pass an order. If he has a challenge against that, let him prefer the change.
as because there is employees insurance code for this purpose.
Right.
Alternative remedy is available.
Learned counsel for the respondent number 4, comma, at the outset, comma, takes an objection as to maintainability. You are for respondent number 4.
2 and 3.
Sorry. Respondent number 2 and 3, comma, at the outset, comma, takes an objection as to maintainability, comma, since a specific provision is there in the Employees State Insurance Act, comma, providing an alternative forum for any challenge of the sort as preferred herein. Push up next para. Learned counsel for the petitioner submits that the petitioner has challenged the notice of the respondent authorities dated August 31, 2022, comma, on the ground that the petitioner does not falls within the rigors of the ESI Act, comma, 1948. Push up next para. Be that as it may, comma, insofar as the objection is concerned, comma, the petitioner has not challenged any final adjudication of any compensation payable by the petitioner, but has merely challenged the issuance of a notice. Full stop, next para. Since the petitioner has not made out any palpable ground for interference at the stage of issuance of the notice and has an opportunity before the recovery officer to ventilate the grievances as sought to be made out in the writ petition, comma, no interference is required by the writ court at this stage, full stop. Accordingly, WPA 3386 of 2023 is disposed of by directing the petitioner to approach the recovery officer and ventilate its grievances, comma, pertaining to the issues raised in the present writ petition and or otherwise, comma, before the recovery officer. Full stop. The recovery officer, comma, before coming to any final conclusion as to the amounts due and payable by the petitioner, comma, if any, comma, shall give an opportunity of hearing to the petitioner and pass a reasoned order thereafter in accordance with law, comma, without being influenced in any manner on the merits on the basis of any of the observations made here. Address to cause,
Get pulled.
20.
May it please your lordship. Lord, I am appearing for respondent number 5 in the matter.
My lord, I'm appearing for the petitioner.
Yes.
My lord, before my learned friend starts, may I indicate, my lord, on the last occasion we were directed to file an affidavit, my lord, bringing on record our stand, my lord, with regard to the documents and whether, my lord, this document which is being, my lord, requested for by the petitioner is with us. My lord, we have filed, my lord, we are ready with the affidavit. My lord, this affidavit, if your lordship kindly takes up page 11, there was an application.
Have you given a copy to them?
Yes, my lord, we have. Yes. My lord, there was an application before, my lord, the district judge at Alipur, my lord, under section 10 and 26 of the Guardian and Wards Act. My lord, there, after considering the application, an order was passed by the learned court, my lord. That order of 29th March 1988 is at page 11. The reason I'm submitting this is, my lord, this document is really not missing. It is with the court. And my lord, I'll indicate from the records how so.
Document disclosing the identity of the parents.
Yes, my lord. My lord, there is a deed of, it's called a declaration. It's a relinquishment deed, my lord. That document has been
surrendered the baby.
Yes, my lord. I'll indicate from page 11, my lord, this page 12 is the application. This application is under section 10 and 26 of the Guardians and Wards Act. This was considered, the order is
this was filed by the present petitioner.
This was filed, my lord, by the, my lord, the adoptive parents of the present petitioner.
The biological parents?
No, my lord, the adoptive parents. They
On
wanted
behalf,
to, my lord,
on his behalf.
They wanted to adopt him. For that, my lord, they had filed this application. While considering this application, my lord, the first order is at page 11. It's dated 29th March. Kindly see, my lord, the second paragraph. The petitioner also relies on 2 sets of documents along with a copy of the application. Let, my lord, this is very important, let West Bengal Council for Child Welfare 42, this is the address, be appointed as a scrutinizing agency who will scrutinize the application and documents and make necessary inquiries
the scrutinizing agency is directed as per observation of the Honorable Supreme Court in its different judgments to scrutinize the application as also the home study report, child study report, and other.
Sir, Bhatt, this is not even a judicial order. It
The
has
reason-
been held time and again. This is virtual and administrative
Milord,
order.
the reason is, I will indicate, Milord, kindly take up page 7. This is the reason why I'm indicating this. This is a scrutiny report, Milord.
You are appearing for the Kara.
But I'm appearing for respondent number 5, Milord, Indian Society for Rehabilitation of Children.
You are that agency.
Dear
Milord, I am not the agency.
Kara is not a party here.
No, Milord, I am not.
Sarah is a party, my lord. Sarah has been made a party, my lord. My lord, may I make a small submission before this continues?
Yes. What is the submission?
My lord, if I can take you to your lordship's the last order, the order was fairly simple, my lord, and it was that your lordship had recognized that this was not yet adversarial in nature and hence had requested the respondent number 5, being the private respondent here, to file a report on the next returnable date indicating whether the records of the adoption of the petitioner could be traced out.
This is the very report, Milord.
In the said report, in the event that the said records are traced out, the respondent number 5 shall also indicate as to whether there is any specific clause in the surrender deed or other connected documents where the biological parents had specifically requested their privacy to be protected.
That's exactly what I'm coming to,
my
Milord.
lord,
If my
I do
lordship
not
just
see.
allows me 2 minutes.
I
Just
will
2
allow
minutes.
more than 2 minutes. It's not me allowing. It's a convenience of the bench. My lord, there is no deed. The surrender deed has not been attached with the report.
That's what I'm submitting, Milord. Why
The
so? I
report,
just
it
indicated
is
2 minutes.
argumentative. It is full of conjectures on what could have been.
Finish.
Surely, my lord.
Very grateful, Milord. Page 7 is
Be
the
short,
scrutiny
Mr.
report.
Bhatt, come to a point,
Only
right?
1 point, Milord. Page 7 is the scrutiny report. Kindly take the next page, the first line. This is the scrutiny report. Background of the child. Kindly see the first line. Confidential, not to be disclosed. This is upon, Milord, considering the deed. The relinquishment deed, Milord. This is the scrutiny. This has been taken cognizance of by the learned court in the next order. Milord, I've shown the March order. Milord, kindly take up the next order, which is at page, Milord, 18. This is the reason, Milord, I have indicated, because that document is with the court now. So, Milord, kindly see page 18. This is the order of 9th May 1988. Kindly see the second line. Milord, I'm sorry, the second paragraph. It is stated that so far, no Indian parents could be made available for adopting the minor and no one else would be available during several months to claim the minor. The unmarried mother of the minor has relinquished all the claim of the child. The minor is now free for adoption. This is, Milord, it was in custody of the court. We did not get it back. Milord, what they are now praying for, that document is not with us. That is the reason, Milord, we have filed the report, and that is why I've placed that reliance on the scrutiny report. And the next paragraph, Milord, I'm not troubling your lordship. That is where, Milord, the other agency has now, Milord, they have also submitted their scrutiny report before the court. After considering it, Milord, this application was allowed.
My lord.
For leaving jurisdiction, this was the
And in your report, have you stated it is still lying with the court? Please show me that paragraph.
My lord. Paragraph 3. Milord, paragraph 3. Second line, submitted to respondent number 5, 1987, was submitted to the appropriate authorities. Authorities, including the West Bengal Council for Child Welfare, have analyzed this. So, Milord, it is with this authority. It is not with us. If at all, it is with this authority or perhaps with the court, Milord. Because this authority has analyzed that deed and prepared the scrutiny report, which has been now considered by the court. Milord, the next page, the first paragraph, last 2 lines, we've indicated that, Milord, the names of the biological parents were confidential and not to be disclosed. And also, Milord, paragraph 5, where the 5th line we indicate that, Milord, respondent number 6 was to scrutinize the application and all the other documents. This was scrutinized by them.
My lord, may I
The
make
respondent number 6 is the West Bengal Council for Child Welfare, who have prepared the scrutiny report. They are represented, Milord.
Yes, what do you say?
My lord, there is a distinction to be made between a scrutiny report and a relinquishment deed. A relinquishment deed.
Don't you understand what is said? He says that the relinquishment, obviously the scrutiny report cannot be said to be the relinquishment deed.
Indeed.
He says the scrutiny report is based on the relinquishment deed, which says not disclosed. Now, that is lying either with the district judge or with the scrutinizing authority, he's saying. Now, impede the district judge, I'll direct the district judge to put it in a sealed envelope to the court.
Certainly, my lord. I just want to make a very small submission that we had procured the entire certified copy of the entire records. This is available from page 66 to 75, and this was done after perusing the entire records. There is no relinquishment deed or scrutiny report available there. Whatever has been available has been placed before your lordship.
According to you, then what should be done?
My
It's
lord,
not with the adoption agency, which must have given it to the scrutinizing authority. Now, what can be done according?
my lord, with my most humble submission is there is the report. We are actually a little taken aback by the report that has been filed. It is because the understanding was that this was not something to be considered in adversarial nature.
Still not, my lord. I have not made any submission on
Not
merits.
adversarial. They're just indicating that they are just indicating that it is not with them.
My lord, may I make a reply to this? May I be permitted to make a reply to this?
To the report.
To the report.
How will that help?
My
They have
lord,
not pleaded anything anything regarding law. They have said it's not with them. It's either with the agency, either with the scrutinizing agency or the court. That is their stand. You're saying it's not with the court.
no. In that event, my lord, kindly allow us to implead the two agencies, the scrutinizing
That will be
agencies.
easier for you.
My lord, it is respondent number 6 before your lordship.
It is already there.
My lord. They are represented. No? Lord, my learned friends, I believe, are appearing for respondent number 6.
Yes, what is your stand in the matter?
First of all, my submission would be Kara would be necessary party.
Turned down. What next? Turned down. What next? It has been turned down. What next?
Secondly, your lordship kindly consider the.
Is the document with you or not?
No, I don't have any document. Because we have to submit all the documents before the court.
It is with the court. It does not exclusive certified copy because it is one election.
Correct.
Please come to page 72 of your writ petition. This is a part of the records you have annexed.
Yes.
Now, if it's a surrendered baby, there's a stigma, maybe stigma attached with it. And now please come to page 72. Please come to the background.
My lord, I had placed this before your lordship on the previous
Yes,
occasion.
if that be so, how can we compel somebody to even produce the document? I mean,
My lord,
argue on that first.
my lord,
You may have a fundamental right to know your parents, definitely, but that is
My-
subject to somebody else's privacy.
indeed. My lord, my submission is that we don't know. This was done 30 years or 40 years, or more than 30 years ago.
Absolutely, and I
Things-
empathize with your client that he is willing to know his parents, definitely, legitimate.
My lord, that is why this petition has been filed through a power of attorney, and the constituted attorney, my lord, I had placed this before your lordship on the previous occasion, has an expertise in doing this. She has been tracing, and she does this discreetly. It is not, my lord, it is not my submission, not my case that the child, now the older adoptee is going to land up at the doorstep of the biological parents. That would be inhuman, and that is something certainly that he doesn't want. So there is a method, there is a process in which this is done, and root search, that is why root search, the right to root search has been identified. It is a search, my lord. It is a search for one's biological roots.
I appreciate the search, but what do you propose next? Because both the agencies are saying they don't have the copy of that. Now, what next do you propose?
My lord, the copy has to be somewhere. The copy has to be somewhere.
What sort of inquiry are you proposing for that?
My
Because it has been put on oath by the respondent number 5
And-
that it is not with them. They are not being able to trace out. That's in their paragraph 3 probably.
Indeed. My lord, if the respondent number 6, the scrutinizing agency is agreeable, because the scrutinizing agency is agreeable to put this affirm this on oath that it is not available with them, and maybe your lordship could direct the district judge to be made a party of the to this, and try to.
I think I'll do both, because give you liberty to impute the district judge as a party here, and as well as direct them to file a report also, whether it's lying with them. For the time being, let us do that first.
Indeed. Just my lord, there is this is what I apologize in advance if I had irritated or annoyed your lordship, but
That's not in advance then. If you use the past tense, that cannot be in advance. You are apologizing now. If you have irritated or annoyed me,
no, I'm apologizing.
you have not irritated or annoyed me, and your apologies in any event accepted.
My lord, there is I have a slight grievance with the report. It is disarmingly put as report, but it is not a report. It is very much adversarial in nature. It is full of conjectures. It draws conjectures that this is perhaps what the biological mother would have thought of. This is perhaps what the learned district judiciary.
It's argumentative also.
It's very argumentative, my lord, and it completely misunderstands and misstates the legal position by stating that there is no right, there is absolutely no legal requirement to preserve records. That's I have a little misgiving about that.
We are not accepting their arguments at all.
But we have
I
not
understand.
argued
You
on,
need a report to be
merits
filed.
at all.
I wanted to trace out where the document is, the relinquishment deed. That's all I'll look into this for. That is the only purpose I'm looking into this report, only for the purpose of locating it. I mean, we are trying to locate the document first. If we can get hold of the document, then we can take further decisions. Even if there was a wish, we could maybe perhaps discover some instrumentality by which the identity would not be disclosed to public, but to you. We can think about that. But unless we get that deed, we cannot do anything.
Absolutely.
So let us try for that first.
Gratefully, lord.
A report filed by the respondent number 5 today be kept on record. Full of learned counsel for the petitioner argues that the same is argumentative, which is contrary to the spirit of the order pursuant to which it was filed. Full stop, next para. Learned counsel for the respondent number 5 submits that as per the report, the relinquishment deed regarding surrender of the petitioner by his biological parents is not lying with the respondent number 5, full stop. It is submitted that the said deed might be lying either with the concerned district judge, before which the formal order of adoption was passed, or the respondent number 6, which was the scrutinizing agency. Full stop, next para. By placing reliance on the scrutiny report annexed to the report, it is pointed out by learned counsel for the respondent number 5 that the name of the biological parents, it was disclosed, it was recorded, was confidential and not to be disclosed. Full stop. Learned counsel for the respondent number 6 also submits that the respondent number 6 does not have a copy of the report. Full stop. However, such submission of the respondent number 6 through counsel seems more to be a knee-jerk reaction than a result of an actual scrutiny of the records. Full stop. Accordingly, the respondent number 5, respondent number 6 is also directed to file a report as to whether the relinquishment deed regarding the petitioner by the petitioner's biological parents is lying with the said authorities. Full stop. In the event the respondent number 6 is able to locate the said deed, the respondent number 6 shall produce a copy of the same before this court on the next date of hearing, along with the report, in a sealed envelope. Full stop, next para. It may be made clear here that the respondent number 5 has sought to insinuate that the confidentiality indicated in the scrutiny report binds the petitioner. Full stop. However, the remark within double inverted confidential not to be disclosed, double inverted clause, was only insofar as the respondent number 6 was concerned, which rightly did not disclose the identity of the biological parents of the petitioner in the scrutiny report, and does not, in any manner, bind the petitioner for all time to come. Full stop, next para, in any event, comma, since it has been indicated in the report filed today that the report might also be lying with the District Judge South 24 Parganas.
South 24 Parganas.
District Judge South 24 Parganas at Alipur, comma, learned counsel, the petitioner is granted leave to implead the District Judge, comma, South 24 Parganas at Alipur as a party respondent to the present writ petition. Full stop. The necessary consequential amendment to the cause title of the writ petition shall be carried out during the course of the day. During the course of the day by the learned advocate on record for the petitioner, and a copy of the writ petition along with the gist of this order shall also be communicated to the added party, indicating that the matter shall next be listed on October 17, 2023, comma, under the heading top.
Deeply obliged.
The respondent number 6 shall also file its report, comma, along with the copy of the relinquishment deed, comma, if available, comma, on the said returnable date, comma, with an advance copy of the report to the petitioner.
My lord, may I be permitted to make a reply? A written submission, a written response to both the reports.
Very well. The petitioner, comma, if the petitioner is so willing, comma, is also at liberty to file a rejoinder to the reports which has already been filed by the respondent number 5 and which is proposed to be filed by the
Great.
respondent number 6.
Great.
Very deeply obliged.
21.
This is my writ petition. Primarily, first issue has been filed because there is no court, my lord, for the last 1 year and till 2 years, and my lord, till December even, my lord, it has been declared there will be no court. So that's the first. If they raise that
Court means this is surface. What?
Yes, my lord, State Administrative Tribunal. So that's first preliminary issue that they may raise, my lord. So, my lord, that is the reason I mentioned and lordship allowed it. Firstly, my lord. Secondly, my lord, 22. My lord, these are two. I'll just explain, my lord. These are two, my lord, applications filed, my lord, for the wife and the husband. Both, my lord, are rendering services in the police. My lord, disciplinary proceedings made. From the records, it is apparent, my lord, that has not been considered. The final order passed by the disciplinary committee, my lord, is, my lord, dehost, my lord, the records. The appeal court, my lord, the appellate tribunal has just, my lord, reiterated what is there in the order of the, my lord, disciplinary, my lord, proceedings. And, my lord, we preferred an application against that, but of course the court is not there. This is the sum and substance, my lord. And, my lord, the punishment is, my lord, I would say harsher than, my lord, even my lord, somebody who kills, my lord. 4 years, no increments, 4 categories, and, my lord, in fact for life. I'll show, my lord, the wordings are such, in fact for life. So, my lord, I was only beseeching if your lordship takes the next matter first, 22, and then, my lord, 21, because 22, my lord, is more, my lord, grievous than, my lord, 21. And 21, obviously, if 22 succeeds, 21 means as it is succeed. So, my lord, may I just, my lord, indicate 22 first, my lord.
Before my learned friend plays the case, my lord, there is no scope of any interim order, my lord. I will file affidavit.
Direct affidavit.
Only thing is that, my lord, for 2 years there has been no hearing. I am not standing against the affidavit. Affidavit কোথায় কেন? না ওখানে না, my lord. Only thing is that, my lord, fixes a date, my lord. My lord, my lord, fixes a date, my lord, of the returnable. That is only I'm saying, my lord. For 2 years, my lord, we have been running from pillar to post, my lord.
These writ petitions are taken up together for hearing, comma, in view of identity of the causes of action. Full stop. The respondents seek to file an affidavit affidavits in opposition to controvert the allegations made in the writ petitions on facts. Full stop. Accordingly, the respondents are directed to file their affidavits in opposition within a fortnight.
That will take us again to the pujas. That is
Within 3 weeks from date, footstep reply, if any, shall be filed.
1 week, my lord. I will only take 1 week.
Filed within 1 week thereafter, footstep, the matter shall be listed on November 17, 2023, fairly at the top of the list.
Grateful. Grateful. But same order in both the matters, 21 and 20.
I've taken up both together.
Yes.
Affidavits, separate affidavits in both.
Grateful. Grateful.
23.
I beg to appear on behalf of the petition.
Yes, Mr. Mukherjee.
The petitioner is a practicing advocate. There was an advertisement.
My lord, in this matter, Mr. HON'BLE is appearing for the state, my lord. Can you take it up to 2 p.m., my lord?
No, ma'am, you have to be there then. You're also on the state panel. Yes.
There is a advertisement, my lord, for appointment of notary, my lord, under the Notaries Act. My lord, that, my lord, my client has applied for. My lord, initially, my lord, there was a provision, my lord, for issuance of, my lord, after verification, issuance of admit card. The admit card, my lord, I have, my lord, given. I participated in the interview. Thereafter, the selected candidate, my lord, list was being published where, my lord, my client's name was there. My lord, suddenly, my lord, thereafter, kindly once looks at, my lord, page 40. My lord, the initial rejection that was, my lord, assailed by filing a previous round of writ petition. Page 40, my lord.
Yes.
But may I read, my lord, 3 lines? I am to state that your application dated 29th of September 2020 has been rejected on the ground of lack of required qualification as per Notaries Act 1952 and its corresponding Notaries Rules of 1956. No, nothing is being spelled out. What is the requirement? Next is due to interpolation of the experience certificate as submitted by you. So this experience certificate, your lordship will get, my lord, straight away, my lord, to page 32, capital A. My lord, it's a certificate of my practice that was given by the Additional Chief Judicial Magistrate Kontai Purbo Midnapur.
Yes, there is handwritten something.
Yes, this handwritten portion is written by, my lord, that judicial officer itself.
No signature.
No, my lord, I am coming to that. But here, my lord, at the end, my lord, the judicial officer has made the signature. Now, my lord, I approach this honorable court. My lord, if your lordship takes up page 41, taking into the provision, my lord, straight away, my lord, page 42. 42 is the operating portion, my lord, taking into consideration of Rule 8.3 of the Notaries Rule 1956, which gives rise, my lord, to a right of, my lord, make review. My lord, the writ petition was not being entertained, leaving me, my lord, free to approach that provision. It kindly takes up, my lord, the page 43. I applied for review. Only the relevant paragraph is at page 49, paragraph 16. This is the certificate issued by a judicial officer. If they are not suggesting that some interpolation, they can very well not clarify it from that officer itself, whether that has been done by him, by him or itself or not, or something is being put in by me. These are my kindly now takes up the order. Pass page 56 is the impugned order. The order under review by the authority, exercising Rule 8.3. Page 57, has your lordship got it? Your lordship has noticed the initial 2 grounds of rejection.
Where? No.
The initial 3-line rejection that I have shown before your lordship, page 40.
Oh, that, yes.
Yes. First, that is not required qualification, I have not fulfilled. Second, the interpolation. My lord kindly takes up the decision with reasons.
This is a decision on the review.
Review. Filed by me. Page 57, may I read decision with reason? Had the present applicant peruse the record lying in the files, after perusal of the main file initiated by the district Purbo Midnapur, a defect was found with regard to the document submitted by the present applicant, since he did not submit self-attested copy of the document of law decree. This is for the first time in review, they are giving, rather clarifying their position with regard to rejection, which was not there in the initial order. For that reason, the Joint Secretary of this department had no scope to ascertain anything with regard to the qualification of LLB of the present applicant, and accordingly observed that the present applicant was lacking required qualification. It may be mentioned that though the 3 photocopies was annexed in the earlier writ petition being such and such, the said photocopies of the law degree, but out of those 2 are not legible. Not at all legible. It is further appears that even the subsequent writ petition in such and such also the copies of are not legible. However, the photocopies of LLB decree are found legible for the first time in the review application for the present applicant. Pages not is being mentioned, but at the time several discrepancies are detected in the name of the present applicant in the different document. Now your lordship will get from the BSc examination, certificate of Madhyamik examination and BSc examination, the name is Shumil Kumar Pradhan. This name is correct, this I follow. Kindly turns over the page 58. They said that the preliminary examination, it's Pradhan Sunil Kumar. Now, again, from the intermediate examination of law, Sunil Kumar Pradhan. Correct. That is my name. It appears from the mark sheet of the final examination of law, Sunil Pradhan. So, it's same and identical person. They are disputing for the time being this. It appears from the PAN card, such and such, Sunil Kumar Pradhan. Again, it is right.
You had lost your Kumarhood between intermediate and final.
Yes. That is their defect. That is they found. Kindly now, without disturbing your lordship, last paragraph. The second ground. Now, regarding the insertion of the handwritten portion of the certificate of experience, it can be said that the same cannot be verified at this stage. Verification of a document can only be possible by way of comparing with the other supportive documents. But in case of experience certificate, there is virtually no scope of comparing with the other supportive document, and it is completely impossible when the author of the said certificate is no more available in his erstwhile posting. Maybe he is a judicial officer. His posting may be changed. Thus, in the case there was no scope for removal of the doubt about the experience certificate by way of verification as claimed by the present applicant, since the handwritten part inserted in the printed experience certificate is completely unusual, the same creates all sort of doubt, and thus the same cannot be treated to be a legally valid certificate. Kindly turns back, what is the handwritten portion? The learned.
Let us suppose for the timing, Mr. Mukherjee, the other handwritten portion is irrelevant. The date is also handwritten. I mean, it can be date of that certificate itself.
That is yes, that is the blank portion. The judicial officer has written the date and thereafter signed it.
Yes, but the other portion may be irrelevant as per available. Even without that.
Yes, without that, he is certifying something, and he was I was a practicing advocate of that bar.
That has been stated by him.
Yes. So this cannot be a ground when otherwise I am eligible. They have published. After interview, they have published.
And he has also wished you success in future. So that is more important. Yes, what do you say?
Then I file affidavit, my lord. The last paragraph, my lord, the appropriate government cannot appoint such applicant as a notary whose several documents are full of discrepancy. And one valid vital document is not legally valid. In such situation, in view of Rule 81 of the notary rules, an appropriate government can reject the application of the candidate recommended by the interview.
I'll say this, let him become a notary. Learned counsel for the petitioner contends that initially the petitioner's application for being appointed as a notary was rejected, which was subsequently on a review, pursuant to a liberty granted by a coordinate bench, the same decision was reiterated, giving reasons. Challenging the said order of rejection dated April 20, 2023, learned counsel submits that both the grounds of refusal are not tenable in the eye of law, First, it has been held that there are discrepancies in the name of the present application in the different documents. Learned counsel, from placing various portions of the impugned order itself, submits that there is substantial corroboration of the fact that the petitioner's name is actually Sunil Kumar Pradhan. Next para, the other ground of refusal, it is submitted is also not acceptable, since it was alleged that the certificate produced in favor of the petitioner by the additional chief judicial magistrate, is substantially relevant, even without the portion inserted by hand. It is argued, that even if the allegedly interpolated portion of the said certificate is ignored, comma, the petitioner's credentials are sufficiently supported. Full stop, next para. Learned counsel for the state contends that in view of the patent discrepancies in the documents produced by the petitioner, comma, the respondent authority, that is the Principal Secretary, Law Department, Government of West Bengal, was justified in rejecting the petitioner's application. Full stop, next para. Upon considering learned counsel, upon considering the submissions of learned counsel, comma, let us take up for scrutiny the decision which is impugned herein. Full stop. Even as per the observations in the impugned order, comma, there are at least 3 documents which clearly show that the petitioner's name is Sunil Kumar Pradhan. Full stop. 3 na kore 4 documents hoye jabe. 4 documents which show. Full stop. The said documents are the Madhyamik examination and BSc examination certificates respectively issued in favor of the petitioner, comma, the mark sheet of the intermediate examination of law taken by the petitioner, as well as the PAN card of the petitioner. Full stop. Even a 5th document, comma, that is the certificate of enrollment issued by the Bar Council of West Bengal, comma, which is all important, all hyphen important, to establish the petitioner's credentials of practicing as an advocate, comma, shows that the petitioner's name is Sunil Kumar Pradhan. Full stop. The preliminary examination mark sheet of the law examinations of the petitioner, comma, which apparently mentions the name of the petitioner as Pradhan Sunil Kumar, is merely a reiteration of the intermediate examination mark sheet, comma, since the first name, the middle name, and the surname of the petitioner have merely been exchanged with each other insofar as the placement is concerned. Full stop. Next para. Taken in such context, comma, there cannot be any iota of doubt that the petitioner has produced at least 5 or 6 documents to substantiate his real name. Full stop. Next para. Insofar as the alleged interpolation in the certificate issued by the additional chief judicial magistrate, comma, Contai is concerned, comma, I do not find any major discrepancy therein. Full stop. The allegedly interpolated portion, comma, which is an insertion by hand, comma, mentions within double inverted as per available record produced by the S capital secretary, comma, Contai Criminal Bar Association. Full stop, double inverted close. Full stop. Even apart from the said phrase, comma, the certificate clearly mentions that the petitioner, comma, Sunil Kumar Pradhan, apostrophe S enrollment number under the Bar Council of West Bengal, and that he is a member of the Contai Criminal Bar Association since April 15, 1999, and has been practicing in civil and criminal court at Contai, comma, since that date. Full stop. Next para. It is also mentioned therein that the certificate was issued for fulfilling his eligibility for appointment as a notary under the Notaries Act 1952. Full stop. As such, comma, nothing turns around the allegedly inserted portion, comma, as regards the credentials of the petitioner vis-a-vis the examination for becoming a notary is concerned. Full stop. Thus, comma, this court is of the opinion that the rejection of the petitioner's application for being permitted to take the examination for becoming a notary under the Notaries Act is palpably dehorts the law and perverse. Full stop. Hence, comma, WPA 12981 of 2023 is allowed on contest, comma, thereby setting aside the impugned order dated April 20, 2023, passed by the Principal Secretary, comma, Law Department, comma, Government of West Bengal. Full stop. The respondent authorities shall permit the petitioner to participate in the interview for the purpose.
Interview has been done. Panel prepared. So they will now just.
Achha, very well.
Pair B,
The respondents are hereby directed to
Pair B, page 22.
issue a letter of appointment in favor of the petitioner for the post of notary. Notarized to cost.
Extremely.
Before your lordship rises, my lord, may I be permitted to mention my lord, item number 9?
Yes.
The restoration of the fairly at the top position, not, I could not have
appear for
addressed your
the
lordship for the
Union of
15
India,
minutes
my
because
lord.
of an
Mr.
ill health.
Majumdar, the difficulties in all the matters consistently because so many matters are mentioned. Because if I do that in your favor, a floodgate will be open. Many other
Lord,
persons.
I'm the respondent. I'm just saying, my lord, it will take just 2 minutes, my lord. I will, in fact, half of it, I will concede. So it will just take 2 minutes, my lord, to
ঠিক আছে,
dispose of the
ওই
writ, my lord.
item 9
Yes, my lord.
item 9 টা যে অর্ডার পাস করেছি
Not
টু
today.
বি
I said.
টু বি মেনশন কালকে রাখার জন্য বলেছি
Oh,
normal thing to be mentioned. To be mentioned, it will appear as to be mentioned.
Yes.
Convince me that it is doable within 2 minutes. Then I'll
Absolutely, my lord, in 2 minutes time.
to be mentioned tomorrow.
Writ.
24.
My lord, I am beseeching your lordship's indulgence.
At a
for-
cooking fixture?
No.
Yes, sir.
For listing of fresh matter, my lord, the unfortunate part is, my lord, the matter was filed on 10th of February, despite the lapse of good span of time of.
No, this is not the mentioning hour.
Pardon?
This is not the mentioning hour, sir.
That's right, my lord. I was told that the mentioning will take place at court 2, my lord. And I mentioned over there, then the lordship told me that only the selective matters have been assigned to me. And
Yes,
the mentioning roster lies with your lordship. That's why, my lord, your indulgence, your lordship may give any date, my lord, before the ensuing puja holidays.
It has been, in the morning I took up mentioning matters.
No. I was advised that you make a mention before court 2. When I mentioned, the court 2 told me that no, selective matters have been assigned to that court, the regular matter.
No, you have to mention in the regular mentioning hours, sir. I'm sorry. Please, yes.
I beg to appear on behalf of the
Your lordship may give liberty to mention tomorrow. My local advocate on record will tomorrow, my lord.
Not tomorrow, on next Monday.
Next Monday. I am grateful.
I beg to appear on behalf of the petitioner. Just like the previous matter, not prior to recess, your lordship has took up. But here also, for the notary, for the post of notary, the petitioner is being selected. Page 38, initial rejection. I am to state that your application dated such and such has been rejected on the ground of non-submission of required document as per the Notaries Act and the corresponding rules, and there is discrepancy of your name in the document submitted by you. Similarly, my lord, I approach this honorable court. This honorable court, in view of 8.3, provision of rule 8.3, my lord, relegated to the review authority. The order is at page 53 of my lord's brief. Kindly takes up page 54, my lord, the decision with reasons. My lord, the Aadhaar card enrollment issued, PAN card, bar council. This is my name, Pradeep Kumar Shamol. This is, my lord, the correct name. Thereafter, my lord, your lordship will get in the Madhyamik, my lord, the Pradeep, instead of PRA, it is PRO. Next, my lord, kindly turns over the page 55. My lord, here your lordship will get LLB examination. The Pradeep Kumar, there is no gap in between Pradeep and Kumar. And thereafter, my lord, the Pradeep Kumar Shamol.
There was no interpolation here?
No.
Then you are less qualified in this matter.
Lord, that, my lord, I say additional ground over there. But here, my lord, only in this, in respect to the discrepancy in the name. But
yes,
my lord,
what about this?
My lord, kindly appreciate only one thing. What is the job of a notary? My lord, as far as my little understanding, the job of a notary is to verify document. So, my lord, am I to understand that this is the case of the petitioner, that assuming that he is assigned the job of a notary, if any document is placed for verification, that is for notarial certificate, if any document is placed before him for verification, with this kind of discrepancies, my lord, he will overlook and grant notarial certificate.
He'll be more cautious.
My
He'll
lord,
be more cautious.
my lord,
because
he
he
will,
faced
my
this,
lord, kindly,
he faced this from you, he'll be more cautious.
my lord, kindly appreciate this. A person who is assigned the job of a notary, my lord.
You have to have something in your mind.
My
This
lord.
was not the fault of the petitioner alone. It was the authority's fault who issued these sort of certificates.
My lord.
It is not his fault alone.
My
So
lord.
he was not the author of these documents.
My lord.
Now the notary will check only these things, these discrepancies only. So he's the best. I mean, these discrepancies, he's not in any way responsible.
My
for
lord,
it. How
kindly
to attribute
appreciate
that to
my
him?
lord, kindly appreciate this subject to correction. This is a very common practice. My lord, kindly overlook the other documents. A person's name in an Aadhaar card varies with his name in a certificate of school final certificate. My lord, he will not try or make any effort to rectify those mistakes, and he will agitate this cause that I am same and identical person. He is an advocate. He is an aspiring notary. Even then, my lord, subject to correction, my lord, the onus lies
He
upon
did not
him.
aspire to be a notary, Mr. He might not have aspired to be a notary
My
when
lord.
he got this Madhyamik certificate or the BA examination certificate
my lord,
or the
there is-
LLB certificate.
My lord,
He might not have.
my lord, appreciate. My lord, kindly appreciate one thing, but my lord, aspiring notary, that part even your lordship may be overlooked. But what is the reason that he didn't took any steps for rectification of his name, which what is lying in the Aadhaar card or in the Madhyamik certificate, my lord? My lord, after all, he will be, my lord, assigned the job of a verification of a document of some persons with such discrepancies. What kind of seal he will use? My lord, there are 5 names. Pradeep Kumar Shamol, at least my lord, 5 names are there.
The spelling is different only. No.
Yeah. My lord, kindly no.
Yeah,
My lord,
oh,
kindly
yes.
cease. My lord, kindly cease. Page
The others are only lack of space.
Yes.
One SH, yes. Regarding SH, there is a discrepancy.
Yes, my lord, kindly sees. SH, there is a, my lord, kindly sees 2 discrepancies subject to correction. Pradeep Kumar Shamol, original name in a certificate of school final. Pradeep PRO, then another thing, my lord, this certificate issued by the judicial officer, my lord, in page 30 of the writ petition, then there is Shamol, SHY. So, my lord, in a case, my lord, his name varies, his title varies. This is for your lordship's kind consideration, my lord. This is my respectful submission.
Lord Counsel for the petitioner submits that initially the petitioner's application for being appointed as a notary under the Notaries Act 1952 was rejected. Full stop. Upon the petitioner challenging the same comma, a coordinate bench had directed the matter to be revisited by granting relief to the petitioner. By granting liberty to the petitioner to approach the appropriate forum. Full stop. Next para. Subsequently, a review having been applied for by the petitioner, comma, the respondent authority rejected the same on April 20, 2023 on the ground that there was a discrepancy. There were multiple discrepancies in the name of the petitioner in the various documents produced by the petitioner in support of his name. Full stop. Next para. Learned Counsel for the state alleges that the instances of discrepancies are serious. Full stop. Next para. It is submitted that a person who will be entrusted with the responsible job of verifying documents as a notary ought to have been more careful before the appropriate authorities. Full stop. In the absence of any attempt by the petitioner to have his name changed and corrected before the said authorities, comma, it is to be presumed that the petitioner is not fit to be a notary. Full stop. Hence, comma, the errors concerned are required to be taken in such context. Full stop. A perusal of the impugned order itself indicates that in substance, comma, the name of the petitioner is Pradeep Kumar Shamol, SYAMAL. এটাতে ভুল জানো না, এটা 6th হবে। SYAMAL. Full stop. Next para. Whereas the petitioner's name, please take your seats. Whereas the petitioner's name appeared correctly in the Madhyamik examination as Pradeep Kumar Shamol, comma, the name of the petitioner apparently appeared in the certificate of the BA examination issued by the appropriate authorities as PRODIP without space KUMAR. Tapos Shamol, SYAMAL. Full stop. Again, in the mark sheet of the LLB examination, comma, the petitioner's name appeared correctly in consonance with the Madhyamik examination certificate, comma, but without there being any space between the first name and the middle name of the petitioner. Full stop. Thereafter, comma, in the certificate of experience issued by the additional chief judicial magistrate, comma, Kontai, comma, the name of the petitioner appeared as Pradeep Kumar, তারপর শ্যামলটা SHYAMAL. Full stop. Next para. একটা ভুল হয়েছে, একবার আসুন। প্রথমে যেটা বললাম না, কোথায় ছিল মাধ্যমিক সার্টিফিকেট? মাধ্যমিক এটা না বাবু, এটা কেটে দিতে হবে, ডকুমেন্ট গুলো ভুল বলেছি, পুরোটা কেটে আমি শর্ট করে দিচ্ছি। কোথা থেকে কাটতে হবে সেটা বলছি। এটা কি বলো? রেসপন্ডেন্ট শেষ হলো যখন, না রেসপন্ডেন্টটা পুরোটা হয়ে যাক। এই পেরুজাল থেকে এটা কেটে দিয়ে আমি একটু করে দিই। A perusal of the impugned order shows that the petitioner's name correctly appears in his PAN card, Aadhaar card and certificate of enrollment issued by the Odisha State Bar Council, Cuttack as Pradeep Kumar Syamal, SYAMAL. Full stop. However, the same name, although repeated in the BA examination certificate of the petitioner, there is no space between Pradeep and Kumar. That is the first name and middle name of the petitioner. Full stop. Again, in the LLB mark sheet of the petitioner, the middle name was used as an abbreviation, being double inverted KR full stop, double inverted close. Full stop. Next para. The discrepancies, as such, between the said documents, there is no serious discrepancy as such, the petitioner's name having appeared substantially correctly in all the said documents. Full stop. The discrepancy arose in the Madhyamik examination certificate of the petitioner, where the petitioner's name was depicted as PRODIP, তারপর টানা চলছে Kumar Syamal. Full stop. Again, in the certificate of experience issued by the additional chief judicial magistrate Kontai, the name appeared as Pradeep Kumar, SHYAMAL. Full stop. Next para. Although the petitioner, as rightly pointed out by learned counsel for the state, ought to have been more cautious regarding correction of the discrepancies between the said documents, since the petitioner's PAN card, Aadhaar card, certificate of enrollment issued by the Odisha State Bar Council all tally with each other, and the BA examination certificate is also substantially the same, as is the LLB mark sheet, I do not find that there was sufficient justification in the outright rejection of the petitioner's application for being appointed as a notary. Full stop. In such view of the matter, the discrepancies which were blown out of proportion by the respondent authorities, in particular the principal secretary, law department, in the impugned order, ought to have been read in appropriate and correct perspective, giving benefit of doubt for responsibility regarding such mistakes to the petitioner and attributing the said mistakes to the respective authorities which issued the erroneous certificates. Full stop. Accordingly, WPA 12985 of 2023 is allowed, thereby setting aside the impugned order passed by the principal secretary, law department on April 20, 2023. Full stop. The petitioner shall be given appointment as a notary under the Notaries Act by the respondent authorities at the earliest.
But subject to correction, only one thing: before joining, at least he may be directed to rectify his school final certificate, to take steps for rectification of the school final.
PAN is there, Aadhaar is there, Bar Council certificate is there, the other documents are there. Rely on those.
My
25.
Mr. Vajpayee, you're for the petitioner?
I am for the petitioner, my lord.
Yes.
But on the last occasion, your lordship pleasure was to direct that since nobody appeared on behalf of the National Commission, so to make a further service over the issue.
You have served.
So I have served, and this is the affidavit of service.
Not delivered? Not delivered.
Delivered.
You ought to have checked up.
After that, it is delivered.
Oh. Anyway. Yes, one is not delivered and other is delivered. So I'll take the delivered. Yes. What is the matter?
So, my lord, this petition is primarily assailing the order of the National Commission over the question of their powers and functions and duties, whether they are exercising the excessive jurisdiction or within the power that they derive from Article 338 as was incorporated in 2003 for the purpose of scheduled castes and their benefits and welfare. So, my lord, the subject matter of challenge is page 60. This is the order whereby, my lord, the commission is directing the Chittaranjan locomotive works that a mandatory order that should be, the respondent should be promoted as JE, whether they can step into the service jurisdiction as commission and what is their authority to move into such action. So, my lord, on this point, my lord, my answer is no, because of the provisions as enumerated in Article 338. Lordship, kindly see the powers and functions of the commission.
Constitution. Is there any other statute, Mr. Bajpayee, which you will cite?
No.
Only constitution?
This is constitutional provision, and, my lord, the Article 338, my lord, 8, sub-rule 8, sub-article 8.
Yes.
The commission shall, while investigating any matter referred to in subclause A or inquiring into any complaint referred to in subclause B of clause 5, have all the powers of civil court trying a suit, and in particular in respect of the following matters, namely summoning and enforcing the attendance of any person or part of India, examining him on oath, requiring the discovery or production of documents, receiving evidence on affidavits, requisitioning any public record or copy thereof from any court of office, issuing commission for the examination of witness and documents, any other matter which the president may by rule determine. My lord, on this context, my lord, my submission is that they have the summoning power, but not to misuse the question of summoning, my lord. Why I am telling this, my lord, because your lordship may kindly come to the there are many number of litigations that have come up on the issue of their powers and functions, and lordship kindly come to page 70. It is the mother judgment of the Supreme Court on this
Mr.
issue.
Bajpayee, apparently as per apparently as per this article, they have a recommendatory power.
Recommended.
They can recommend after doing this.
I'm
thing.
grateful.
So there is no sanction provided to them. They're toothless in the sense that they
Yes.
cannot direct anything to be done as such.
What they are doing, my lord, they are doing this, and subsequently, my lord, they are giving a phone call that we are not proceeding with the matter. So in the earlier occasion, my lord, we filed an application, and on their advice, my lord, we withdrew the same. Yes.
I saw that you withdrew
Yes.
against the same order.
Same order, my lord. The question is that
after withdrawing, Mr. Bajpayee,
immediately after withdrawal, then again they started harassing the senior officers of the company, my lord. And what they are asking today is the revision of the ACR or the appraisal report of 2012-13, and the person who is to be against whom they are asking, he is the union leader. Lordship, kindly see the my lord, page 48. Page 48, this is the complaint. With profound regard, I would like to inform you that SC Brahma, technical assistant such and such, zonal president of this association. And Lordship will find that in the penultimate paragraph, I therefore request your good self to kindly make necessary arrangement to review the ACR of a particular issue that had happened in 2012, 13, and 14. And Lordship will come to kindly, Lordship will find.
But Mr. Bajpayee, if you please come to page 61, the one which you have here, it's only a recommendation. Here it is said that after hearing commission recommends that such and such be done, should be promoted. Action taken report should be reached to this commission office after receiving this minute. So the last paragraph you say is beyond this.
Yes. So on the one hand, they are
no, they are saying action taken report should be reached to this commission office after receiving these minutes within 7 days.
And
if the order is not complied, then commission may recommend to invoke section 4 under Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act. So it's all a recommendation. They're not going overboard. They're not exceeding that.
So that is, they are exceeding. They are stepping into the power and functions.
Clause 7 of Article 338 is their power. Now clause 7 and clause 4b. Now clause 4, sub-article 4, you may say, Article 338(4), that says the commission shall have the power to leave it. 5. It shall be the duty of the commission, A says, to investigate and monitor all matters relating to the safeguards. That is general.
That is general.
Please come to B, to inquire into specific complaints with regard to deprivation of rights and safeguards of the scheduled caste. This is a specific instance of that. What they can do is under 7, where any such report or any part thereof relates to any matter with which the state government is concerned, a copy of the report.
They will refer the matter to
this is not state government.
No, this is central government. So they will refer the matter to the state government for inquiry, but without caring anything. Lordship, kindly see the article subclause 8 of 338.
8 is the powers of the commission.
Powers of the
while inquiry.
Why they can.
That is different. This is not the authority of the commission, final authority of the commission.
That's why, my lord, the Supreme Court in a very unequivocal term, my lord, has reiterated in page 72, the last paragraph. Page 72. I have annulled the judgment. My lord, last paragraph. Interestingly, here in clause 8, article 138 of it should be 338. The words used are the commission shall have all the power of civil court trying a suit. But the words all the powers of civil court have to be exercised while investigating any matter referred to in subclause A or inquiring into any complaint referred to in subclause B of clause 5. All the procedural powers of civil court are given to the commission for the purpose of investigating and inquiring into these matters, and that too for that limited purpose only. The powers of civil court of granting injunctions, temporary or permanent, do not inhere in the commission. So, my lord, they can summon, and they are, by summoning the senior officers of the company, my lord, they are harassing them and they are asking them to implement the order. On the one hand, they are saying that it is recommendatory in nature. And on the other hand, my lord, they are, lordship, kindly see the page 60, it is almost a mandatory order that you promote him as J after a lapse of around 14 years. So, my lord, whether they are having, they can invoke this power within the meaning of Article 338. This is the
Mr.
moot
Bajpayee,
question.
according to you, suppose they act under Article 338(5)(b). Now, there is a specific complaint. They inquire into it. Shall be the duty of the commission to inquire into specific complaints with regard to deprivation of. Here, there is a specific complaint. May he be the president of a particular.
There is a specific complaint.
To inquire into specific complaints with respect. After that, what does the commission do according to you?
Yes.
What does it do with that
My lord,
complaint?
I am
Suppose
showing
it inquires. After that, what is the role of the commission? Show me from 338.
Yes. What they are doing, my lord, after the commission, lordship, kindly see. My lord, they are calling us. It is page 66, my lord, to some extent.
No, yes, let us come to that.
Page 66. So they are asking us to join the to appear before the commission, and they are preparing these minutes of hearing.
They're giving you an opportunity, yes.
Yes, opportunity.
That's
After
fine.
that, my lord, what they are doing, my lord,
Oh, acha, acha.
now after this, they are passing this order. And my lord, Guwahati High Court, I will submit before your lordship. The Guwahati High Court Honorable Justice specifically observed that once they are doing this and immediately it is over, then they are again trying to pressurize the authority.
That
to,
I can appreciate, Mr.
Yes.
Bajpayee, but
Yes.
under the law, what can they do? That is my question to
My
you.
lord,
What is the power of the commission then? Ultimately, suppose they make this inquiry under 5B.
Yes.
It shall be the duty of the commission to inquire into specific complaints. After inquiring into that, what do they do? What is their role?
Their role is to look, firstly, they should refer this to the state authority for inquiry. They will not take any steps. Secondly, if they themselves take the course, then, my lord, they are calling the officers. They are asking the inside story, what has happened in the complaint, why this has not been done. And thirdly, my lord, if they are not satisfied with the answer of the commission authority, in that event, my lord, they will recommend the issue. But here, my lord, they are
adjudicating the issue as if.
Yes. And the exhaustive, lordship, kindly see this against this order, this authority, my lord, in an exhaustive manner, my lord, answered the queries.
Acha, Mr. Bajpayee, according to under the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act, which is the forum which has to be approached?
That is the criminal penal actions. That is to be.
So you say if any action has to be taken, that has to be taken under that act.
Yes.
But this commission does not have that right.
That does not have.
Oh, what is your impugned order? This
Impugned order is
page
page 60.
66?
Page 60.
60.
Yes.
That is the only impugned order here.
That is the only impugned order here, because after the minutes of the hearing, my lord, they have passed this order. The minutes of the hearing, my lord, that was passed in on lordship. That was on 17 June 2023.
Bajpayee, allow your application. Let's set aside this.
My lord.
Learned counsel for the petitioner contends that under that the National Commission for Scheduled Castes derives its powers under Article 338 of the Constitution of India, despite such power being restricted to making recommendation before the appropriate government, the commission in the present case, has been harassing the officers of the petitioner number 2 by repeatedly summoning them, and after giving purported hearing, making directions, dehors the provisions of Article 338 of the Constitution of India. In the present specific instance, the petitioners challenge such an order dated March 27, 2023, annexed at page 60 of the writ petition, whereby the commission, in the garb of a recommendation, directed the petitioners to promote a particular employee as JE on the commitment of action taken report. It was further observed by the commission that the action taken report should be reached to the commission office after receiving the minutes within 7 days. If the order is not complied, then the commission may recommend to invoke Section 4 under the appropriate act. Next para. It is argued that such exercise of powers is dehors the provisions of Article 338. Learned counsel, in support of his propositions, cites several Supreme Court judgments, including the case of All India Indian Overseas Bank SC and ST Employees Welfare Association and others versus Union of India and others. In the said judgment, the Supreme Court observed, while adjudicating upon Article 338 within bracket 8 of the Constitution, comma, that under the said provision, comma, all the procedural powers of a civil court are given to the commission for the purpose of investigating and inquiring into the matters, and that too for that limited purpose only. Full stop. The powers of a civil court of granting injunction, comma, temporary or permanent, comma, do not inhere, inhere, in the commission, nor can such a power be inferred or derived from a reading of clause 8 of Article 338 of the Constitution of India, comma, it was observed. Full stop. Next para. Despite service, comma, none appears for the respondents. Full stop. Affidavit of service filed to be kept on record. Full stop. The limited compass of the present adjudication is the scope and powers of the commission under Article 338 of the Constitution of India. Full stop. The said provision is set forth here in below. 338 page 149, 150. 338 পুরোটা. Next para. On a perusal of the said provision, comma, it is seen that the duty of the commission, comma, inter alia, comma, pertains to inquire into specific complaints with respect to the deprivation of rights and safeguards of the scheduled castes, comma, to investigate and monitor all matters relating to the safeguards provided for the scheduled castes under the Constitution or any other law, comma, to participate and advise on the planning process of socio-economic development of the scheduled castes, etc. Full stop. The powers of the commission also envisage presentation to the president, comma, annually and at such other times as the commission may deem fit, comma, reports upon the working of those safeguards, comma, etc. Full stop. Thus, comma, a perusal of the provisions of the of Article 338 shows that the powers of the commission pertain to certain duties of the commission to ensure that the safeguards are in place. Full stop. However, comma, the commission does not have any powers akin to a judicial forum, comma, or anything to show that it has sanction behind the recommendations made by it by enforcing such recommendations. Full stop. The power of the commission is essentially recommendatory. Full stop. The commission cannot enforce its powers by any process of law. Full stop. For such enforcement, comma, the parties concerned are to resort to the appropriate provisions of law. Full stop. Next para. Clause 6 of Article 338 provides that the president shall cause all such reports, comma, filed by the commission, comma, to be laid before each house of parliament along with a memorandum explaining the action taken or proposed to be taken on the recommendations relating to the union and the reasons for the non-acceptance, comma, if any, comma, of any of such recommendations. Full stop. Next para. In clause 8 of Article 338, comma, the commission's powers, comma, akin to a civil court on certain aspects, comma, while investigating any matter referred to in subclauses small a or small b of clause 5 have been enumerated, comma, including the power to summon, comma, discovery, comma, receiving evidence on affidavits, comma, etc. Full stop. Next para. However, comma, the powers under clause 8 are to be performed within the limited conspectus of clause 5 ব্র্যাকেটের মধ্যে, comma, subclauses small a and small b ব্র্যাকেটের মধ্যে. Full stop. Subclause small a provides that the commission may investigate and monitor all matters relating to safeguards provided for the scheduled castes under the Constitution or any law, and to evaluate the working of such safeguards, full stop, subclause B pertains to inquiry into specific complaints with respect to the deprivation of rights and safeguards of the scheduled castes. Full stop. Such duties, comma, regarding which powers have been conferred in clause 8, comma, all are of a general nature and do not confer any power on the commission to exercise jurisdiction in passing directions and or enforcing the same on any particular employer or authority. Full stop. Next para. Hence, comma, the exercise sought to be undertaken by the commission in the impugned order dated March 27, 2023 is palpably dehots the law, the provisions of the Constitution, and the authority conferred on the commission by the Constitution. Full stop. The commission, comma, by the said order, comma, specifically directed the petitioners to comply with its recommendations, and in the event such order is not complied with, comma, the commission issued a threat of making recommendations to invoke section 4 of the 1989 Act. Full stop. Such exercise of the commission is palpably dehots the law and is arbitrary, comma, being not sanctioned by Article 338 of the Constitution, comma, which is the repository of power of the commission. Full stop. Next para. In any event, comma, if any particular person is aggrieved by any action of its employer, comma, he or she is at liberty to take appropriate measures under the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act, comma, 1989. Full stop. The commission is not an authority contemplated under the said act. Full stop. Hence, comma, the impugned order is required to be set aside. Accordingly, WPA 13474 of 2023 is allowed, comma, thereby setting aside the order of the National Commission for Scheduled Castes dated March 27, 2023, comma, annexed as Annexure P6 at page 60 of the writ petition. Full stop. It is expected that the commission shall not undertake any such endeavor in future, which is palpably dehots its powers, and leave it open to the aggrieved parties to take recourse to the 1989 Act or any other governing statute enacted by the legislature in that regard. No rest of us.
I am extremely concerned.
26.
I am appearing for the respondent, Bank Your Lordship.
Lord Mr. Chatterjee is appearing for the petitioner. He is engaged in courtroom number 650.
Move the matter or I'll dismiss it for default.
Lord, I am not briefed in this matter. My lord, this is the affidavit in reply. And my lord,
My
the
affidavit in opposition.
supplementary
to kept
affidavit
on
I'm
record.
filing.
File it. Affidavits in opposition and reply filed today be kept on record. Full stop. An adjournment is sought on behalf of the petitioner. Full stop. It is seen that the matter is appearing under the heading within double inverted upgraded matters, double inverted close, on the prayer of the petitioner. Full stop. Since other matters are not, now other matters are being deprived from being upgraded due to pendency of matters such as these, comma, in view of the adjournment sought by the petitioners themselves, comma, the matter is adjourned and shall next be listed in the next monthly list under the regular heading.
Lord, I have filed a supplementary affidavit, my lord.
You did not file the report today? Reply today?
Yes, my lord. Along with a supplementary affidavit.
আচ্ছা আরেকটা লাইন লিখে দিও affidavit in opposition, reply and supplementary affidavit.
Lord, this is the service.
Next one.
27.
I appear for the respondents. Lordship, I'm seeking an extension of time for filing the affidavit in opposition. There's been a change of guard in officers. I could only track down the person.
Ms. Alam, I'll give you one more week.
Lordship, 1 week will not suffice. Lordship,
Long
I've got
back,
a
it was
long
directed long
Yeah,
back.
it's in June, I know that. But then because of,
No, no, Baba,
we lost, I mean, It's just that recently I could establish contact. I've sent a mail, I've sent WhatsApp.
No,
but
Ms. Alam,
Lordship-
time was granted
I-
long back.
Long back. I don't
No,
deny that.
no
Lordship.
further
That is
time.
because of
I can give you
Lordship-
1 week at best. No.
Lordship, make it a fortnight, please, Lordship, because it's got to come from Delhi. That's why.
Then I'll impose cost on the petitioner, on the,
Lordship,
you are for
can you-
respondent number, for the Union of India, I'll impose cost on the Union.
Lordship, I'll try 1 week, Lordship. I
Learned
think
Counsel for the Union of India seeks an extension of time for filing affidavit in opposition, full stop. It is seen from the records that the direction for filing affidavit in opposition was given as long back as on June 21, 2023, which is more than 3 months back. Full stop. However, since the Union of India, since the affidavit in opposition might be required to substantially decide the issue on merits, as a last chance to the Union of India, the time for filing affidavit in opposition is extended till, I'll give it 2 weeks, Mr. Extended till October 9, 2023. Full stop. Reply, if any, shall be filed within 3 days.
3 days.
Reply, if any, shall be filed within October 12, 2023. The matter shall be listed under the same heading on October 13.
13.
Can it be some upgradation?
This is already upgraded.
Upgrade.
Twenty-eight.
28 on behalf of the petitioner, I am paying for short pass over. Your
Either
Lordship.
move the matter or I'll send it in the next monthly list.
No, Mr. Sanjeev Bandyopadhyay is in a busy matter.
An adjournment is sought by the petitioner, full stop, since the matter is appearing as an upgraded matter, such prayer is refused, full stop. Since learned counsel for the petitioner is not prepared to move the matter, let the matter stand adjourned till next monthly list. Next.
29.
29, I am very. I have been interested to appear on behalf of the CSC, but no copy has been given by the.
Copy has been file the yourselves.
Yes, sir, please. Kota sir.
Yes, move the matter.
Sir, may I receive a copy? Let matter will appear.
No, no, take it up right now.
Take it up
You
tomorrow.
have been served long back.
My lord, I have not yet received, my lord.
Maybe that's your problem. Yes, move the matter.
My lord, I am authorized to prepare of the property where I am for short for a new connection.
I can't get you. New connection, yes.
New connection. But unfortunately, they have refused after verification of the area that on the ground that I have, there are more than one application. More than one application is a.
An adjournment is sought at the outset on behalf of the WBSCDCL, full stop. It is unfortunate.
CSC, my.
On behalf of the CSC Limited, full stop. It is unfortunate that although service has been effected long back, the CSC is not prepared with the matter. Full stop. In any event, to give a last chance to the CSC Limited, the matter is adjourned till day after tomorrow when it will be listed under the same heading. Affidavit of service filed to be kept on day after tomorrow.
Your lordship kindly direct this
You
copy,
will
sir,
get
copy.
it on.
Give a copy if you want your matter to be heard. Please give a copy.
I will make it here. And you will get it in Sarthak also. The state of West Bengal is.
30.
Yes, my lord, I'm the petitioner, my lord, in this petition.
Yes,
My
Dr.
lord, yes, I have come before your lordship because this West Bengal Medical Council is functioning clearly unlawfully. I will show how. The background is, your lordship, remember, last year in WPA 8041, your lordship passed an order to hold election and form a functioning medical council. The page 35 of my writ petition, which is your lordship's order, just paragraph 60, says, very last para, that due notifications will be made and steps taken for adherence to the above time frame so that the newly elected council can start functioning effectively on and from November 1, 2022. Now, what happened after that election held in October, end of October, and in order to keep this deadline, November 1, I moved another CPAN 1293, which is on page 39, that observation of your lordship about that election of West Bengal Medical Council on page 39, my lord. And that just penultimate paragraph, it says, so I raised several allegations at that time in that CPAN. Accordingly, CPAN so and so are disposed of by granting liberty to the petitioner to take appropriate steps before the appropriate forum. And
That's why you filed this writ petition. That's why you have filed this writ petition. Dr. Shah, what is your main allegation? What is the illegality committed by them?
Yes, I will show you. So we sought information under RTI Act that how they maintained the deadline or how it happened. So which is Annexure P4, their response, the Medical Council's response. Annexure P4, page 43. And that single page will tell you all, my lord, that how blatantly they violated law and they conspired to form this thing. So the RTI answer 4, if your lordship sees that, so I asked a question that when you are informed by the health department about the newly nominated and elected members. So that answer, it says, WBC officials were informed about the names of nominated and elected members dated 1st November. So that's the deadline of that court order. So they say on that day, they were informed by the state government. I questioned how, they did not answer how. And the next question I asked, which is answer 5, the official gazette as per section 7 of the Act 1914 was published on November 3rd. And this is very important because your lordship knows, and I have the gazette here, and I have the law, the Bengal Medical Act 1914. So the law 11.1, I will take you on page 56 of my writ petition, which is the Act, Bengal Medical Act. Page 56, 11.1, your lordship got that?
Yes.
So the term of office of a member of the council nominated or elected under section 4 or section 5 shall commence on such date as may be notified on this behalf by the state government in the official gazette. So that's the day it starts, November 3rd, which admittedly that the gazette is there, page 48. Your lordship see that official gazette on page 48. Date is November 3rd. So the term of the newly elected and nominated member starts on November 3rd. Now, what they said, then my question 5, coming back to my RTI response, that so that next section is 11A on that same page, page 56. What happens? How they form precedent, that process. 11A1. The members of the council shall meet on their first meeting after notification referred to subsection 1 of section 11, recommend to such manner as may be prescribed by rule made in the behalf, in this behalf under section 33, the names of 3 persons for the purpose of the subsection, and the state government shall nominate one of such persons to be the president of the council. So that's the law, my lord. So what they have now admittedly claimed, on November 1st, they met, the day they got the names of the new members. Now, how did they meet? These members are all over West Bengal, so they had to come, but they're claiming on the very same day, all members were notified somehow. They didn't provide anything, how they were notified. And they came, they met, they recommended 3 names for president under subsection 11A to be president. And the new president was subsequently elected, who is still running as the president. So even if I take their face value, none of them were member till November 3rd, the date of publication in the official gazette. But in their rush, they met, they're claiming this. This is concocted, my lord. That's why I have prayed here, an interim prayer and a prayer for CBI investigation, because we have information that this is nothing of this happened. They just made it up, that everything, it's a doctrine of impossibility, cannot happen. On November 1, they were informed for the first time who are the newly members. On that day, they somehow inform all the members. On that very day, they somehow met and then recommended 3 people to be, one of them to be president, and then that was sent back to the health department, everything on the same day, which is impossible, physically
Dr.
impossible.
Shah, the interim in this matter, we have to hear it on affidavits. The interim order you asked for, that the suspension of the committee, that would lead to anarchy because the medical council won't be functioning. You know the effect of that. I mean, being a doctor, you know best. So we'll direct short affidavits in this matter. We'll take up the matter.
I have a pair, then can I, at least in the minimum, admittedly, this president is illegitimate. So he may not be functioning anymore than right at this moment as the president, because none of them are members, my lord. They are admitting it till November 3rd, but he was elected on November 1st. So at least remove him. He cannot. That will be illegitimate act. I have brought it to your lordship attention.
What you said to this, they were not members till
appear for the medical council, madam, led by Mr. Sen, but my lord, some
Difficulty, my lord, I do not know, my lord. 15 years back, my lord,
Mr. Sen, please use the microphone so that Dr.
I do not know whether my learned friend on the other side will remember, but 15 years back, I had appeared in a matter of the petitioner. So if he has an objection later, so I will. One particular.
Dr. Shah, 15 years ago, Mr. Shah.
No objection. Anybody can appear. No. Yes, he did appear for me long ago. I have no objection.
He's fair enough on that. I mean, he's alleging about your client's unfairness.
Yes, but
Mr. Sen, what about this? They were not members till 3rd of November. They were elected on 1st of November.
notification date, it was published on 3rd November, but the meeting.
I will show from their petition itself that they
Dated 1st of November, published on.
the notification, if your lordship sees at page 48, it is dated 1st November. Publication was made on 3rd of November.
That's
Kindly
Right.
see at the top.
Yes, 3rd of November.
3rd November. So on the date of the date of the issuance of the notification, they were already there. It is not that it is on 3rd November, but they have become members or so. But I would use a very short affidavit, my lord, if your lordship will permit.
Mr. Sen, how soon can you file that affidavit? Be short. I mean,
10 days.
fair enough. Dr. Shah, 10 days is fair enough.
And
For the
I
state,
will only
I think
question
the president should not make any decision.
pardon?
maintainability as to the locus of the petitioner may be kept open.
Dr. Shah, they're challenging the maintainability and your locus. I'll keep that open for being heard along with the merits. No,
Yeah,
I'll
that-
hear that along with the merits. And Mr. Sen is, very fair because he's saying within 10 days he'll file that affidavit. I'll give you 3 days to file your reply.
Yes, kindly send it by email because I'm appearing in person. I'm in US now.
Please provide
So-
your email. I mean, the email in which you have, email is given with the petition now.
Yes, it's given with the petition.
And
Yes.
an email ID is given. They'll send you the copy of the opposition there.
Yes, I will.
AOL.
One which is mentioned at the top.
Even then, this is the service that.
It's ANKU@AOL.
Yes.
Yes. That's
Very
it.
An arguable point has been made out for the writ petition being heard on merits. Full-stop. Learned counsel appearing for the medical council raises an objection as to maintainability and locus standi at the outset, apart from refuting the allegations made in the writ petition. Full-stop. In view of the nature of the allegations made, affidavits are the matter is required to be decided on affidavits. Accordingly, the respondents are directed to file their affidavits in opposition within 10 days. Full-stop. Reply, if any, shall be filed within 3 days thereafter. Full-stop. The matter shall be listed on October 16, 2023, fairly at the top of the list for final hearing. Full-stop. The question of locus standi and maintainability is kept open for being heard at the time of final hearing of the writ petition. Full-stop. It is made clear that any action taken in the meantime by the newly constituted West Bengal Medical Council, the veracity of which is the legality of which is challenged in the writ petition shall abide by the result of the writ
That
petition.
is always there. But if it is, that may, a constituted body is operating since November.
That is why let there be some fetter, Mr. Sen.
But this
Obviously, the major decisions we won't interfere with. But if I find that something has been taken, I mean, which perpetuates his own being there in power, then we'll consider that.
Yes, your lordship, suppose the writ petition is allowed. All
Probably the
actions-
same person. Who is the president now? What is the name of the president?
Sudipto Roy, na ki?
Yes, Dr. Sudipta Roy. Yes.
Roy.
Oh, he-
Dr. Sudipto Roy. This is the question. The delay is also there. But I am not saying that because the principle is this: if the writ petition is allowed, all actions will any event go, and your lordship holds that the constitution is illegal. Then there will be no revalidation of the acts cannot remain valid once they have come into power. But kindly consider
So that
this.
rider will be there, Mr. Sen.
But why I say that body is functioning.
No, that will ensure that even if you are not there or your learned friend is not there, you are changed in the meantime. Then also the 10 days.
No, affidavit will come, my lord. The affidavit.
If
will
you
come.
are there, definitely it will come. If your learned friend is there, definitely it will come. If it is changed, the constitution is changed of the persons who are appearing, then Mr. Sen, I'm not sure. Because I've seen these matters, in these matters, this happens. It's
My
not
lord,
a-
at least in the meantime, no major action should be taken by the president, my lord. That's my humble prayer, my lord.
No,
That
no,
will be.
nothing
in
else,
the
Dr. Shah,
meantime.
this is enough. Yes.
Obliged.
31.
May I please, your lordship? Your lordship, in
May
this.
it please me, not you. It. What is before you? May it please your lordship. Yes. It may please me,
Yes.
subject to what you argue.
Your lordship, in this matter, my savings bank account.
What about service on the other
Yes,
side?
your lordship, by service, they have refused to take service. For that, your lordship.
Affidavit.
Your lordship, let me explain, your lordship. In this case, my savings bank account has been frozen. My
Where is
bank,
your affidavit of service?
they have refused, your lordship.
Ma'am, you have to come
Yes,
back
yes,
with what is this?
because the branch in which I'm having the account, your lordship, they are saying that serve on that SAM branch. I have nothing to do with that branch.
The commissioner of oath is there, available here.
Very well, your
Where is
lordship.
it?
So let's.
So have an affidavit affidavit of service affirmed, come back tomorrow morning.
Very well.
Not today. এই heading এ থাকবে।
I'm grateful.
Lord, in this matter, I am WBSC decision.
I am for the petitioner.
Yes, please.
This is my video service. So this is the land of the undivided, undemarcated land. The private respondents are enjoying the land, enjoying the electricity last 4 years. I have applied the electricity in 1917 to 2017, but they did not apply, they did not allow me the new connections. The ground settled on the let's see in annexure P4. Most probably page 17.
You have applied for a fresh connection.
Yeah, ma'am.
You are a co-owner.
Yeah, I'm the co-owner.
How are you enjoying electricity so long?
They are enjoying electricity 4 years.
How long were you
Actually, they are enjoying the electricity. At that moment, I have applied the connections in the year 2017.
Since when are you a co-owner of this property? Since
Yeah,
when?
I have got the property by law of inheritance. This is undivided, undemarcated.
When did you
unpartitioned
get the property? When did your predecessor die?
It is a RR property, my lord. I have got the property by law of inheritance.
Yes, why do you refuse?
My lord, in this matter, my lord,
My lord, one minute.
Remembered something?
Page 3-4, page 3-4.
Remembered something? No.
No, my lord.
Yes, what did you remember?
My lord, they have stated the reason for refusing the electricity. Page
my lord, strongly,
page
my lord,
17. It is not correct. Section 43 of the Indian Electricity Act. Trespasser can enjoy the electricity, my lord. So they are stating the reason. The litigation may be open with both the parties on the ground of partition or declaration.
Is there any pending litigation?
Declaration suit, my lord.
Is there any injunction there?
No injunction. There is no restraining order.
Where have you stated that in your writ petition? You should have disclosed that.
Yeah, but this is
That is a suppression of material fact
No, my lord.
otherwise. Where?
Para 6, page 6.
You have not stated there is no subsisting interim order or anything of that sort.
The SRAD order, man. I have already.
It's your suit.
Yeah, my suit for declaration.
Yes, what do you say?
No, we are ready to give electric connection, but due to the private restaurant, raise the objection. And resisted that, strongly resisted that. We have informed him, he has not taken any action.
Despite service, none appears for the private respondents.
Malad,
First up,
only
the
thing,
petitioner's
Malad, paragraph
grievance.
4.
You are for the private respondent.
No, I'm for the state. Malad, I have nothing to say except Malad, paragraph 4. Malad, he has written respondent number 6 to 8 at the relative of the petitioner. Malad, I have found Malad, the respondent number 6 is the officer in charge.
Officer in charge is a relative. He's the maternal uncle of everybody.
Nothing has Malad, written.
Maternal uncles are relatives.
Malad,
Learned
nothing has
counts.
written in there.
The পুরোটা গুলি দিল কি বলতে হবে এখানে কি বললাম বল is that despite having applied for an electricity connection, comma, being a co-owner of the property, comma, the distribution licensee has not given the same. Full stop. It is pointed out that by its letter dated August 30, 2017, comma, the WBACDCL wrote to the petitioner that there is strong objection by the private respondents and waive permission is necessary. Full stop. That apart, comma, a court case and legal obligation over the premises was cited. Full stop. Next paragraph. Learned counsel for the WBACDCL submits that there is no objection otherwise, but the private respondents are obstructing the CSC personnel from giving connection.
WBACDCL.
Oh, sorry. CSC and WBACDCL. You waited for 5 years, 6 years. Why?
Malad.
They refused in 2017. Why did you wait for so long?
Malad, my client did not communicate me. I'm just appointed.
It is seen from the annexure to the writ petition that the WBACDCL refused to give electricity connection to the petitioner as long back as in the year 2017. Full stop. Hence, comma, some doubt is cast on why the petitioner waited for so long to seek for an electricity connection from the WBACDCL. Full stop. Be that as it may, comma, since the petitioner is a co-owner of the property and, comma, by law, comma, is also deemed to be in occupation of the property, comma, the petitioner is entitled to an electricity connection from such perspective. Full stop. Moreover, comma, the need to have an electricity connection is a continuing cause of action and mere delay does not defeat equity in the present case. Hence, comma, WPA 14828 of 2023 is allowed, directing the WBACDCL to give to hold an inspection of the property to ascertain whether the petitioner is in occupation of the same and the feasibility of giving a connection in the name of the petitioner. Full stop. Upon such inspection being held, comma, the WBACDCL shall issue a quotation to the petitioner. Full stop. The entire exercise shall be completed by the WBACDCL within a fortnight from date. Full stop. Upon such quotation being raised, comma, the petitioner shall comply with the requisite formalities in law and procedure. Full stop. The WBACDCL shall, comma, thereafter, comma, give the new electricity connection to the petitioner within a fortnight from such compliance of formalities by the petitioner. Full stop. It is made clear that if, comma, on either of the occasions of holding inspection initially and giving electricity connection to the petitioner, comma, physical obstruction is raised by the private respondents or their men or agents, comma, it will be open to the WBACDCL personnel to approach the officer in charge of the Ghola police station, that is respondent number 6 herein, comma, for adequate police assistance. Full stop. If so approached, comma, the said respondent number 6 shall grant such assistance to the WBACDCL at the cost of the petitioner, comma, by acting on a server copy of this order without insisting upon prior production of certified copy. Full stop. If need be, comma, the police personnel will be at liberty to remove any hindrance or padlock, comma, if put up by the private respondents to obstruct the access of the WBACDCL personnel to the existing meter board position for giving such metered connection to the petitioner. No rest to cause.
No, side of
My lord, before your lordship note takes the original side note, note for the state note, I find note various matters note where the lawyers note on behalf of the state for not appearing. So note I have appointed Mr. Mr. Dinda, my lord, to be note in my lord's court note every day from 3 p.m. note to attend every matter note of the state note which
in the original side.
On the original side, not any matter note, your lordship finds note nobody's appearing for the state, your lordship can my lord instruct him not to take steps, and I'll
Now,
ensure not
if
that.
he is absent, Mr. Sinha, then the cost will be personal on him.
Yes, not he. That's why I'm not. I'm him not to introduce him not, and so that not we have
Thank you
better.
very much.
I'm
Thank you
grateful
very
to
much.
that.
Thank you.
Original side matters, any further mentioning? Listed matter item number 1 for judgment, Alpha Stitch Art Private Limited and Ananda versus West Bengal Small Industries Development.
Hence, WPO number 764 of 2022 is allowed, thereby setting aside the claim of the respondent number 1 to the tune of 1876,000 as transfer charges and rupees 3,37,680 as GST thereon, and directing the respondent number 1 to accept and ratify the transfer of lease in favor of the petitioner number 1 company upon acceptance of rupees 10,000 as processing fees. No address to cause, Sergeant said.
Obliged.
For the petition. Item number 2, Electro Steel Castings Limited versus the State of West Bengal and others.
Hence, WPO 2336 of 2023 is allowed, thereby setting aside the imputation of respondent number 6, whereby the amendment sought by the petitioner was rejected. Respondent number 2 shall reconsider in the light of the above observations the application for amendment of registration certificate filed by the petitioners, which was refused by the impugned decision, by taking into consideration all documents produced by the petitioner on such score. In the event the respondent number 2 has any further queries from the petitioners, the petitioners shall be given a further opportunity to produce documents, if so required, upon which the respondent number 2 shall come to a reasoned conclusion as to the application for amendment of the petitioners. It is expected that such reconsideration and consequential steps shall be concluded by the respondent at the earliest, preferably within 1 month from the date of communication of this order to the respondent number 2. No address to cause, Sergeant.
Item number 3 to 6. Item number 3 to 6 for hearing.
My lord, I am appearing for the petitioner.
Yes.
This matter was fixed today, my lord, for filing written notes of argument. My lord, may I file my writ?
Yes.
On behalf of petitioners. All 4 matters, my lord.
Your lordship also directed us to file it, my lord. Well, I should be very candid before lordship, it's ready. But Mr. Chatterjee will once vet it before submitting. Well, I'll be only seeking 3 days
That's
time.
your problem, Mr. Chatterjee. You have got 2 weeks time.
Well,
I was not.
I have prayed for that. Only it's a prayer. But it's ready. Otherwise, it's ready. With me.
File it. Learned counsel for the Learned counsel for the petitioners file the petitioners written notes of arguments in all the matters. Full stop. Learned counsel for the respondent seeks some adjournment to have the written notes of arguments settled. Full stop. However, comma, in view of the long time already granted to the parties to file the written notes of arguments, comma, such adjournment is refused. Full stop. Upon such refusal, comma, the respondent files its written notes of arguments, which is also kept on record. Hearing is concluded. Judgment is reserved.
Grateful.
Mr. Chatterjee, this is to save you from Mr. Chatterjee.
Yes.
Let's take on the save. Item number 7, Modhumita Construction Private Limited and another versus Reserve Bank.
On way of, I'm paying 2 weeks more, madam.
Pardon?
2 weeks. I couldn't make my evidence ready. I'm
No,
paying 2 weeks.
refused. Please place them, items.
Kindly give me
We got sufficient time. 2nd August probably it was directed.
Yes, my lord, the 2nd August was directed to them. And my lord, your lordship was kind enough to pass an interim order. But
interim order is still there.
Still there, my lord,
Yes,
but
sir.
bank is not acting on the issue.
Reserve Bank
Not, saying that if this is not a final order, so we will not exceed your pair. So my lord, I cannot insist upon then also, my lord. That's why I am urging.
Since you are enjoying the interim order, I'll grant them the time.
No, my lord,
Tell us.
interim order is nothing, but your lordship say, my lord, kindly have a look at this, my lord, kindly have a look at this. My lord, the bank is not acting upon this, I cannot force even to them. Because interim order is this, my lord, that my lord, accordingly issued by the Reserve Bank shall not be prejudicial and or work would not create any bar or and or impose any bar on the extension, enhancement or grant of credit facility. But bank is not saying that until there is a final order. Suppose my writ application is dismissed, what will be the fate of this? So that is the reason, my lord, I am urging for early hearing of.
You are for which bank?
I was State Bank.
What is the reason for your delay?
No,
Why have you not prepared your affidavit in opposition?
it is in draft, but not settled.
I don't get you. Yes.
We make it ready, but it is not settled by.
Why?
You
You got sufficient time. You cannot take this as a matter of course.
Yes, my lord.
Then I'll impose cost of 20,000 on you. 20,000 is the nominal for State Bank. I'll impose that cost on the officer who is responsible personally because you cannot squander public money. You are the bank. You had to file an affidavit in opposition. A message should go. You have to be careful on this, Mr. Pal Chaudhary. There is some limit to everything. No. Who is the officer who will file it?
It is not decided because.
Pardon?
It is the officer who will submit it is not decided, my lord. It is not decided who will file it, my lord. That's but I could not send it for their execution.
Chief General Manager has been the service is to Chief General Manager. He will pay from his. It will be deducted from his salary.
It will.
Why not? Give me one reason why not.
It
He is someone special.
No someone special. It will. It will hurt me personally.
I'll give you 1 week, Mr. Pal Chaudhary. 1 week. Learned Counsel for the bank, for the State Bank of India, seeks a fortnight's adjournment. Sorry, a fortnight's extension of time to file opposition. First up, it is seen from the previous orders that the direction for affidavits was given on August 2, 2023. First up, despite the lapse of almost 2 months, it is unknown as to why the State Bank of India is not yet ready with this affidavit in opposition. First up, however, as a last chance to the respondent, to the State Bank of India / respondent to file its affidavit, the time for filing affidavits is extended till October 3, 2023. First up, next para, reply if any shall be filed within a week thereafter. The matter shall be listed under the same heading on October 11, 2023.
I will take 3 days because I cannot run my business.
All the same. In the event, it is made clear that in the event the State Bank of India fails to file its affidavit in opposition within the extended time, for further extension, costs may be imposed personally on the officer of the bank responsible for the delay.
May I pray one
Item number 8 and 9.
May it appear at the top, my lord.
Item 8, yes.
8 and 9.
And I'm appearing for respondent number 4.
This matter was that Srivardhan Goenka, the willful defaulter. Mr. Om Narayan Ray was addressing your lordship. Last minute, I wanted to put in a supplementary affidavit,
He had
by Mr. Om Naran Rai from the State Bank of India. Madam, kindly extend the time for affidavit and operation for 1 week just due to some personal difficulties. My lord. Kindly consider, my lord.
personal
One-
difficulty. What?
State Bank.
State Bank of India. Madam, 1 week. We want,
What is the reason for the delay?
madam, due to some personal difficulties, my lord.
Personal difficulty of the advocate.
No, my lord, personal difficulty, my lord. He is some, he was ill, my lord. That's why,
Personal difficulty of the advocate.
my lord.
On the prayer of the State Bank of India, comma, the time for filing affidavit in opposition is extended for a week from date. Full stop. Reply finish shall be filed within
2 weeks thereafter.
2 weeks thereafter.
Opposition he'll give. I'll 10 days. 10 days.
Within 10 days thereafter. Full stop. 10 days, 2 weeks. Reply within 2 weeks thereafter. Let the matter be listed on November 22, 2023 for hearing.
Well, let the interim order be extended. my lord, kindly.
Interim order granted earlier is extended till December 15, 2023 or until further order, whichever is earlier.
Look, one request then can we make jointly, I'm sure. Will your lordship be kind enough to make it a part-heard matter? Please, your lordship has heard us. वो टाइम नहीं तो चाहिए एक्सटेंड करके 31st November 30th November which is 28 June मात्र
Item number
8-9 would be same. my lord.
8-9, same.
8-9 same.
Could I renew that prayer for that part-heard?
Refused. I renew the refusal.
Very well. No, I was being led by Mr. Sai.
Yes, obviously.
Contempt matter, item number 10, Supratik Ghosh versus Dr. Manoj Pant.
Alleged contemner.
I'll contemner, but the petitioner is not present, so I'll be requesting a copy be served on it. Because I'm not.
You have not yet got a copy.
As far I'm not, I've seen the list have come, but I'm not sure whether the copy. has
They
been
were
served.
to serve a copy. Direction was
That was the direction. There was the direction on the contempt. So I'm not sure.
none appears for the petitioner. ওখানে বসে নিতে হবে ছোট order.
Yeah.
None appears for the petitioner at the time of call. Full stop. Learned counsel for the alleged contemner submits that no copy of the contempt application
So as
has
for my information, sir, I'm not sure.
no copy of the contempt application has yet been served on him. Full stop. Before making a submission before a court, you have to be sure. Then otherwise, please
I
don't
have-
argue. Please don't submit before a court of law. This is not a playing with the court. যেটা বললাম সেটাই। Next para. The petitioner is requested to serve a copy in the meantime on the learned advocates for the parties for the alleged contemners. Full stop. Let the matter stand adjourned till the next monthly list.
Review application item number 11, Swapun Kumar Datta versus State Bank of
My
India.
lord, I appear on behalf of the petitioner. My lord, may I be permitted to file my affidavit in reply?
Lordship, I appear for the rest.
Opposition has been filed.
Lordship, it has been filed.
Yes.
Lordship, I was praying for an indulgence for today, my lord. Mr. Joy Shah is in some other court, my lord. If it can be taken up day after tomorrow, my lord.
Affidavit in reply filed today be kept on record on the prayer of the State Bank of India, comma, the matter is adjourned for the day.
Wait.
Third matter, adjournment or extension of time sought by the State Bank. Please give the appearances. Ask a learned junior to give the appearance.
My lord, may I pray for your lordship's kind indulgence? My lord will kindly take up the matter on Wednesday, my lord.
Tomorrow.
Lordship. हाँ, दीदी।
Court application item number 12, Amit Kumar Kejriwal versus RBI and others.
Lordship, I
Thank you,
appear for the
Lordship.
respondent bank. Lordship, there was a direction upon me to file a report stating the decision of the review committee. She will file the.
This is a willful defaulter.
Yes, my lord. No,
Your
this is
lordship has-
that matter where your lordship had been pleased to grant them 3 months' time because the new fraud circular was to come into
So the review
operation.
committee has taken its call.
Yes, they've declared as them as the willful defaulter after considering the representation and other materials which are on record. Lordship,
may
I
I
have to
get a-
indicate there was a direction upon me to conclude by 6th September. That was not done because we received an OTS from the Mr. Amit Kumar Kejriwal on 4th.
So the meeting was pushed till 12th, and on 12th, the review committee had taken a decision.
Can you
and
please
suspended.
hand over a copy of this to them?
Yes, Your Lordship. I
If
have to
this
wait for
writ
the
petition
liberty.
then becomes infructuous, I'll give you liberty to file afresh.
I handed
My lord, may I come back if your lordship keeps it on some other day? May I come back after observing the, apart from the declaration, my lord, if there is anything else?
What else? Whatever else is there, you have to challenge that in a fresh writ petition.
My submission will be that I have complied with every single direction passed by this honorable court. In fact, there was delay.
Obviously, they have taken care of whatever was missing in the last occasion.
Yes, my lord, but the declaration itself, in case I have to challenge the procedure.
Acha, very
Very
well.
well.
A report is filed on behalf of the respondent authorities today. The same is kept on record. Copies thereof are circulated to the learned advocate appearing for the petitioner. On the prayer of learned counsel for the petitioner to take further instructions in the matter. Let the matter stand adjourned till next week.
1 week, my lord.
Let the matter stand adjourned till October 3, 2023.
I'm grateful, my lord.
Grateful, Your Lordship. Thank you. Lordship, I have also filed my competency along with the report. The competency I have not given. I have given them a copy of the report.
Oh,
that is fine.
I have recorded only the report.
Your Lordship will also kindly record the competency.
Competency record? Need not.
Right. Lordship.
Grateful.
Grateful.
Item number 13. Vanwar Lal Jajodia versus
I
State
appear
Bank
for
of
the
India.
petitioner. My lord, this is against willful defaulter declaration. Led by an order of 24th August, my lord, they had declared me. They did not supply me a copy of the review committee's order. My lord, 24th August order, my lord, directed them to supply me a copy, my lord, because the order contained of 11 pages. They had supplied only page number 1 to it. Subsequently, after this order was passed, it's communicated, they have supplied us, my lord. But I have prepared a supplementary affidavit, my lord, to bring on record the grounds which arise out of this review committee's order. This, my lord, I will serve them, my lord, they are not appearing, my lord, I have to serve them and I have to come back, my lord, kindly give me 1 day's time to serve and come back, my lord. They have in the meantime supplied me the review committee's
When
order.
should I keep it?
Lord, day after tomorrow.
Learned counsel for the petitioner submits that in the meantime, the review committee decision has been handed over to the petitioner. However, the petitioner seeks to use a supplemented affidavit to challenge the said review committee decision as well. In order to enable learned counsel for the petitioner to serve a copy of the supplemented affidavit on his counterpart appearing for the respondent authorities, the matter is adjourned till September 27, 2023, when it will be listed under the same heading. Leave is granted to the petitioner to file a supplementary affidavit. You are filing it today?
No, my lord,
leave is granted to the petitioner to file the supplementary affidavit on the next date of hearing.
I'm deeply obliged.
Thank you.
Item number 14.
Malad,
Udvanno Association of
Yes, please.
Malad, item number 14, this GA application is my application, Malad. The application for recalling or modification of your lordship's order passed on 1st September 2023, Malad. But the application is made by the said order, your lordship was pleased to direct the West Bengal Housing Board to provide 4 tankers daily to Purbahana Housing Estate in order to cater the needs of the residents residing there. Now, my lord, my application is to the extent that my lord will kindly take the agreement, my lord, from the writ petition, my lord, once.
Page?
Housing Board.
Your Lordship, may it please your Lordship, I am led by Dr. Chapolesh Bandyopadhyay in this matter. We are appearing for the petitioner. Your Lordship, a notice has been served on us on 13th of September mentioning that the applicant respondent would mention the matter today for inclusion in the list. We are taken by surprise that it is appearing in the list.
When should I keep it? Tell me.
Yes, Your
When
Lordship.
should I keep it?
Your Lordship, first week of October, Your Lordship.
Next week?
6th or 5th October, Your Lordship.
Or 3rd or 4th?
My lord, I'm appearing for the respondent number 9, my lord. My lord, this morning I was informed with regard to the matter being taken up today, my lord. My lord, I did not have the brief as of yet, my lord. If my lord,
Which
kindly,
date suits all of you? Tell me.
1 week's time, my lord.
1 week? Keep it with you. File it on the next.
This is my maiden appearance, Your Lordship.
Oh, what is your name, please?
Attoja Bandyopadhyay.
You are the daughter of Mr. Bandyopadhyay?
Yes, Your Lordship.
On the prayer of on the prayer made by Ms. Attoja Bandyopadhyay, comma, on behalf of the petitioner, comma, the matter is adjourned till October 1 week. I'll keep it on 4th October. 4th October.
5th or 6th October, Your Lordship.
October 5, 2023. Deeply
Grateful, Your
obliged.
Lordship.
Obliged.
Please come back on that.
Appearances গুলো দিয়ে দেবেন please. Item number 15, Rituparna Ghosh and another versus the Calcutta Electric Supply
Item number 15, I beg to appear on behalf of the
What is the
petitioner, my
matter?
lord.
Lordship, Mr. Devanjan Mukherjee is appearing on behalf of the CSC, Your Lordship. He's presently on his legs before court number 25, Your Lordship.
Court number?
25, Your Lordship. For this reason, I'm praying for a day's accommodation.
No, you are there. You are sufficient. Yes.
Lordship, I am not briefed in this matter, Lordship.
My lord, there is some urgency, my lord.
You
My
will
lord,
be briefed by the end of the day. Yes.
my lord, this is the writ petition filed by challenging the order passed by the CSC refusing to grant us separate electricity meter in our tenanted premises, my lord. My lord, originally, Subhash Chandra Rampuria is the landlord of that premises, my lord. Initially, one Poritos Ghosh, Ojit Ghosh, and Shankarnath Ghosh used to run the business under the name and style of Picture and Mirror Mart jointly, my lord. Subsequently, the business got dissolved, the family business got dissolved, my lord. Thereafter, three brothers individually started their own business. Poritos Halda started his business under the name and style of Poritos Ghosh. Ajit Ghosh under the name and style of AK Ghosh and Company, and Shankarnath Ghosh under the name of Ghosh Pictures, my lord. My lord, these two brothers, my lord, they have obtained separate electric meter in their
It was a partnership firm initially.
No, my lord, joint business, my lord, joint family business, my lord. My lord, thereafter, my lord, due to dispute and differences between the family, between the brothers, my lord, these two brothers, my lord, namely Ajit Ghosh and Shankarnath Ghosh, they obtained separate electricity meter in their own name, my lord, in their shop premises, my lord. My lord, initially Shankarnath Ghosh was supplying me electricity. My lord, thereafter he is refusing now, my lord, that he is asking me to remove, he is not in a position to help us anymore. My lord, he is asking us to apply for a fresh electricity meter and obtain it, my lord. Thereafter, I made an application, my lord. Application is at page number, which I made before the CSC, P5, my lord.
Let us see their grounds of refusal.
My lord, grounds of refusal is at page number 32, the order, my lord. My lord, third paragraph. It is therefore evident that the instant application for separate supply at the above premises, despite enjoying the benefit from an existing supply, has been made with the intention of splitting the existing load, which would consequently lead to splitting of consumption of units in order to obtain the benefit of low charges, including the applicable dues. This is not permitted by Regulation 14 of the West Bengal Electricity Regulatory Commissioner Recovery, my lord, the Regulation 2013.
Rightly, they have rightly objected.
My lord, I will be without any electricity.
You are
meter, my lord.
manufacturing a separation between yourselves and asking for a new electricity.
No, my lord, a family business has been dissolved, my lord. The jointness has been dissolved.
Then I'll refer it to the grievance redressal officer. That is the authority which has to.
My lord, kindly, my lord, passes. My lord, I am
What is your
asking the
full name?
urgency, my lord.
Niruddha Ganguly, Your Lordship.
Anuruddha Ganguly.
Yes.
You are the chamber junior of Mr. Mukherjee, or you are on the panel of the CSC?
No, Your Lordship, I'm the chamber junior.
Anuruddha Ganguly.
Yes, Lordship.
I'm disposing of
But
your
if-
matter. I'll
if
relegate
any-
you to the grievance
If the
redressal.
brother who is supporting me with the electricity, if he disconnect it, I'll be nowhere, my lord. I will be without electricity, my lord. But that is the whole.
No, on facts we cannot decide here. Learned counsel for the petitioner submits that the petitioners have fallen out with the brothers of their predecessor in interest, stroke father, namely Poritos Ghosh. Footstep, as such, comma, the petitioners have sought for a new electricity connection, which has been refused by the distribution licensee on the ground that there might be splitting of load. Footstep, it is submitted that since the petitioner's interest is separate from the private respondents, comma, the said ground of refusal is not tenable in the eye of law. Full stop. Next para. Affidavit of service filed today be kept on record. Full stop. The appearance of Mr. Aniruddha Ganguly, learned advocate, be regularized to represent the CAC Limited in this particular matter only by the CAC Limited. Full stop. Next para. Heard learned counsel for the parties. Full stop. It transpires that there is a factual dispute as to whether the petitioners really represent a different interest than the private respondents, comma, who are enjoying electricity connection in the same premises. Full stop. To resolve such issue of fact, comma, it is appropriate that the competent authority under the law, that is the concerned grievance redressal officer, comma, is required to resolve the dispute. Full stop. Accordingly, WPO 1555 of 2023 is disposed of by granting liberty to the petitioners to approach the concerned grievance redressal officer with the dispute as raised in the present writ petition. Full stop. If so approached, comma, the concerned GRO shall decide the issue in accordance with law as expeditiously as possible and upon giving opportunity of hearing to all concerned, comma, preferably within 6 weeks from the date of approach being made by the petitioners. No address to cause, urgent certified cause.
My lord, deeply blessed.
I'm grateful, my lord.
একটা লাইন অ্যাড করে দেবেন যেখানে বললাম যে ফোর্থ প্যারাগ্রাফ বোধ হয় মিস্টার অনিরুদ্ধ গাঙ্গুলি বি রেগুলারাইজড, ওই লাইনটাতেই একটুখানি জাস্ট সেন্টেন্সটা এক্সটেন্ড হবে along with his senior Mr. Devanjan Mukherjee.
I'm grateful.
Item number 16, Jagdish Prasad Kundu versus the official liquidator.
My lord, I am appearing on behalf of the petitioner. My lord, I am filing affidavit of service. All are served, but my lord, only respondent number 2 company.
Respondent number
2 company. It was returned back with the abolished.
What is abolished?
I think
company is no longer there.
I think, my lord.
Abolished?
I do not know, my lord. What does it mean?
You have to serve again on respondent number 2.
Yes, my lord.
Affidavit of service filed today be kept on record. Full stop. The envelope sent to the respondent number 2 has returned with the endorsement within double inverted abolished, double inverted close, comma, whatever that means. Full stop. In any event, comma, since proper service has not yet been effected on the respondent number 2, comma, the petitioner shall serve a fresh copy of the writ petition on the respondent number 2, indicating that the matter shall be listed on October 16, 2023 under the same heading. Full stop. The petitioner shall file a fresh affidavit of service on the next date of hearing.
Obliged, lords.
Item number 17, Sanjay Prakash Bansal.
In 18 months, I was paying for not today.
Not
18 হয়ে গেল। Item number 19, Tomojit Sen versus Authorized Officer SMFG India Credit Company.
Not today.
Item number 20, Monmohan Hosiari versus CAC Limited and others.
Item number 19 ডাকেন না?
19 has been made, not today.
Oh my.
My lord, I'm for the petitioner, my lord. This is a very short case, my lord. For seeking for the electric connection, my lord.
Have you filed your affidavit of service?
Yes, my lord.
Electric connection, you sought for electric connection?
Yes, my lord.
You are for the CSC?
Yes, my lord, I have for the respondent number 4.
Oh, what about the
Yes,
haircut?
Lordship,
Haircut?
I lost my father last month.
Extremely sorry.
My lord, the fact is that the petitioner is a proprietorship firm represented by the proprietor Sri Ratan Shao
Right.
for working for the gain of 12 BK Pal Avenue for non-food items and obtaining necessary licenses or permission from the competent authority. Now, my lord, initially the petitioner firm was represented by a previous proprietor, one Shamiran Pal, who used to, Shamiran Pal was inducted by the tenants of the said premises, my lord, and the said tenant used to issue rent receipts in the name of the petitioner through the erstwhile proprietor, showing payment rent month by month by the petitioner through the erstwhile proprietor, my lord. The rent receipt has been already been annexed, my lord, as P2. Now, my lord, the dispute has been crop up between the erstwhile landlords and the erstwhile proprietor of the petitioner farm, my lord. As a result, the petitioner started depositing rent in the office of the rent controller, my lord. Now, my lord, the proprietorship farm has been taken out by the present proprietor, that is the Manmohan, under the business of Hoshiari goods under the name of Manmohan Hoshiari, is carrying on the present proprietor of the said proprietorship firm and obtained the trade license in his name from the Kolkata Municipal Corporation. My lord, the necessary trade license has been obtained for carrying on this business of Hoshiari products. My lord.
No, you had purchased the property from Somiron.
Yes, my lord.
Then
Now, my lord, since there was a long dispute, the present proprietor is also used to give rent through the rent controller, my lord. The fact is started from here, my lord. One private respondent, number 4, claimed to be one of the co-owners of the subject property, wherein the petitioner is carrying on his business, lodged one complaint to the police authorities, alleging that the present proprietor of the proprietorship firm is an unauthorized occupier, my lord. Under section, and he filed one application under
what has
section.
been done? Electricity has been disconnected.
Now, what happened, my lord? One suit is already been pending before this Honorable High Court between the landlords and the present proprietor, my lord, which is pending. And what happened?
For eviction.
The
Suit for eviction.
yes, my lord, eviction from the physical possession.
What has been done? What is the cause of action of the present writ petition?
Now,
Start from
what
there.
happened? Now, my lord, what happened? The previous proprietor of the applied for getting the new electric connection, and
How many pages left?
at page 6,
How many pages of your written instruction left?
written instruction left.
You are reading from where?
Page 6, my lord. Page 6, para 11.
Read out your writ petition. What has
Yes.
happened now? Why are you preferring the writ petition?
Yes, my lord. Kindly, my lord, kindly give me to.
You are wanting a new electricity connection?
Yes, my lord. That is the main fact under section 43.
Yes,
of
my
the-
lord. So long you have forgotten. You are narrating the entire history of the matter.
Yes,
Who
my
is
lord, but they are.
the respondent number 4 is opposing that?
Yes.
Who is appealing for the respondent number 4? Yes. Why are you opposing? How dare you oppose?
Under section 43, my lord, why they are opposing?
Lawful or awful?
Question that your lordship had asked is what I asked. If the case is that I have inherited a business, that business was done must be on electricity. What happened to that electricity connection? Number one, if an illustrate says that electric connection was never there, nothing is there on record, to show that she comes in possession. She says there was an erstwhile proprietor. Then I became a
I
new
have
proprietor.
the
How can there be a new
trade
proprietor of
license, my lord.
something which
You are the owner of the property.
No.
But you have no business with that rather. I mean, whoever is in occupation is entitled to electricity.
our special way judgment says that whoever is lawful occupation.
Settled possession.
My lord, kindly see the section 43, my lord, kindly see section 43, say or otherwise
Just
provided in
give
the
him
act.
2 minutes to finish. He'll finish in 2 minutes. I can assure for him. Yes.
All I wanted to address before your lordship is there is not a single scrap of paper in this writ petition that justifies it. That's the only thing, because I know what limited rights I have.
I want the electrical connection, my lord.
I know
Only that
very
is
well
under
you are.
section 43.
What
The
the
occupier can
satisfaction
also
of
get the
the-
electric connection. They have the right.
My lordship should have.
It will be
brought
decided
something,
in civil court, my lord.
because
under
the
civil suit.
dispute is with the civil court. My lordship
Under
now
civil suit.
says by this writ petition that she has come in possession.
What is the civil suit about?
For eviction of a.
That is the thing.
But
my
that
lord.
does not enter.
Yes.
She's coming by, I don't know how she comes, because.
So why there is no connection with the civil suit with this matter, my lord?
Madam, আপনি বলে দিন না, emotional.
My lord,
Kindly see the first paragraph of the writ petition, that is very instructive. Your petition is the proprietor was represented by the present proprietor of it. son so and so or so and so. Carrying on business review. What has happened is that your lordship experience has known that it has what happened is the tenancy has changed hands without the consent. And now my learned friend is facing difficulty with the CS because the connection was not there in the name of the old person. Now he wants the new connection. So he has to show some document to the CEC authority.
My lord,
so
I
that
have
same-
already filed.
But here,
before-
whoever is in occupation, I mean, settled occupation need not
Madam-
mean lawful occupation. That also, you know. So even if he is in settled occupation without that being lawful, I mean, they're entitled to electricity connection.
Yes.
Proprietorship is not an independent entity. That's the difficulty.
Yes, ma'am.
She is not the one who again. She is not the. Your petitioner is a proprietor firm represented by its present proprietor Ratan Shah, son of such and his character business of India. Initially, the petitioner was represented by its previous proprietor. One Shobiran Pal, son of such and such. And the said then
My lord, kindly see annexure 4, my lord. Kindly see annexure 4, my lord, page 25. Page 25. Page
Bring on record how she comes into the picture. That
My lord, I have already obtained trade license from Kolkata Municipal Corporation. My lord, kindly see page 25 at page 4. P4, my lord.
No,
And,
here
my
they have. Please take your seat. Take your seat. Take your seat. There's a specific averment and an annexure, which is annexure P4, as she was trying to point out, which says that the trade license is now in the name of the present proprietor. So she has something. She has shown something to prove that prima facie established that this person Ratan Shah is now in occupation of the property. The trade license is there.
satisfaction of the corporation authority.
That is different, but prima facie, circumstantially,
Ask them to produce the document.
they have annexed already. The trade license has been annexed.
That's what I'm on. So trade license is if I show a rent receipt, I get a trade license. If I show a rent receipt, I'm depositing rent with the rent controller, I get a trade license. Because trade license has nothing to do with entitlement. Nor is the law that is entitlement is what entitlement is.
Even if he's given a new electricity connection in the name of Ratan Shah, that won't create any right in his favor. Either tenancy, and if the right is created, then it will inure to your benefit in the suit, in fact. You'll have a better case in the suit.
I am the last person who will satisfy that electricity is something the court would be very, very hard to stop. But all I want is that all the requirements for the court to be satisfied, that she is entitled to electricity. I'm not saying that she should say that. She says that I have inherited the business or I have come in place of somebody. The previous owner, I don't know whether she had electricity or she had electricity or not. If that is shown, what was the connection? Why did it get disconnected? What will complex for learned friend? Nothing has been disclosed in the report. Some basis for the court to be satisfied.
Yes, what do you say?
Lordship,
Caught in the crossfire.
Lordship, we couldn't do the conduct the inspection because due to the objection by the private respondent. So we were stuck. We are stuck there. So until unless we were being able to do the inspection, we cannot go ahead.
In reply, you tell me what about the suit? Have you been implicated as a party in the suit?
Yes, I have been included as a party of the suit. Defendant number 4, my lord. We are going to file a written statement very soon.
You have been implicated.
Yes.
In the suit, you have been implicated in their suit.
As in defendant number 4.
They have made you party as a defendant.
Yes.
Have you got any copy of that?
At present, I have no any copy, my lord.
Have you stated that in the writ petition?
Yes, I have stated, my lord. Kindly see at page 5, para 9.
Yes. Yes, I'll direct electricity to be given. No right or equity will be created. Learned counsel for the petitioner contends that the petitioner is the present proprietor of one Monmohan Hoshiari. Full stop, next para. It is submitted that the private respondent stroke landlord has initiated an eviction suit against the erstwhile proprietor of the firm Full stop. The petitioner being one Ratan Shah, was subsequently impleaded as defendant number 4 in the said suit. Full stop. The petitioner has applied for a fresh electricity connection in the name of the petitioner as the sole proprietor of the proprietorship firm, but the CSC Limited has not yet given such connection to the petitioner, for which the present writ petition has been filed. Full stop. Learned counsel appearing for the private respondent of 4 submits that the eviction suit is pending, that an eviction suit is already pending against the erstwhile proprietor of the Monmohan Hoshiari, full stop. It is submitted that the petitioner, without proving his credentials vis-a-vis the property, is not entitled to a fresh electricity connection at the premises. Full stop. In any event, it is submitted that the petitioner seeks to establish rights in the property which the petitioner does not otherwise have in law, by way of seeking for an electricity connection. Full stop. Next parallel and counsel for the CSC Limited submits that being caught in the crossfire between the petitioner and the private respondent, the CSC Limited could not hold an inspection to ascertain feasibility of giving a connection to the petitioner. Full stop. Next para. It is found from the documents annexed to the writ petition and the averments made therein, that the petitioner Ratan Shah has been impleaded as a defendant in the eviction suit of the private respondent, thereby prima facie indicating that the petitioner is in physical occupation of the property, irrespective of the lawfulness of the same, which will be decided in the eviction suit. Full stop. Next para. However, it is well settled that a person in settled possession of a property is entitled under Section 43 of the Electricity Act 2003, to get an independent electricity connection there. Full stop. Accordingly, WPO 1589 of 2023 is disposed of by directing the CSC Limited to hold an inspection at the property in question within a week from date, upon prior notice to the petitioner as well as the private respondent, to ascertain the feasibility of giving an electricity connection to the petitioner in the name of the petitioner Ratan Shah, as in the name of the petitioner Ratan Shah. Full stop. A report in that regard shall be filed by the CSC Limited on the next returnable date, upon circulation of copies thereof among the learned advocates for the petitioner and the private respondent. Full stop. The matter shall next be listed on October 5, 2023 for passing further orders. Let us have that feasibility report after that.
I have not used any opposition. Although your lordship has not.
I have not decided finally. When I finally decide, if necessary.
Item number 21, Ayesha Ghoshi versus the CSC Limited and others.
In this matter, Your Lordship, Mr. Tariq Kasimudi is appearing as a counsel. He's not in Calcutta. He's returning tomorrow. Kindly fix the matter on Wednesday, Your Lordship. It is my humble request.
I'd like to appear on behalf of the private respondent.
On the prayer of the petitioner, the matter is adjourned till September 27, 2020.
27.
27. I'm very grateful.
Appearance to the
Come back on 5th.
Item number 22, Ashraf
My
Hadi.
application, my lord.
I'm for the CS.
Affidavit of service, my lord. My lord, we have applied for electricity, my lord. The CSC Limited had came to my premises, my lord, on 28 due to the resistance of respondent number 4, my lord. Would not
Respondent
be-
4 has been served properly.
Yes, my lord, I have checked, my lord. Through post, my lord.
Yes, what do you say?
My lord, the only difficulty is we are ready to install at the existing service position, provided we get access. The padlock has to be broken, police help has to be given to us.
Despite service, none appears for the private respondent. Full stop. Learned counsel for the petitioner contends that due to resistance of the private respondent of 4, electricity connection cannot be given to the petitioner. Full stop. Learned counsel for the CSC Limited submits that the respondent 4 is obstructing. You have held an inspection.
Yes, my lord. We have
Is
already
is
held an
obstructing
inspection.
the CSC limited personnel from giving electricity connection, and comma as such, comma, there may be a direction for adequate police assistance. Full stop, next para. In view of the above circumstances, comma, WPO 16051 of 2023. 16051 or 105 of 2023 is disposed of by directing the CSC Limited to give electricity connection to the petitioner within a week from date, full stop. In the event any obstruction is offered by the private respondent 4 and or her men and agents in doing so, comma, it will be open to the CSC Limited personnel to approach respondent 3, the officer in charge of the Ekbalpur police station, for adequate police assistance, full stop. If so approached, comma, the respondent 3 shall grant such assistance to the petitioner, comma, if necessary, breaking open any padlock or other hindrance for giving such access to the CSC personnel. Full stop. Such assistance shall be given at the cost of the petitioner, comma, by acting upon a server copy of this order. No order is to cost.
My lord, only fortnight, my lord.
প্রথম সেন্টেন্সে বলে ওটা ফর্টনাইট করে।
Grateful, your lordship.
Item number 23, Gulshan Kumar Gulati and another versus West Bengal.
My lord, I'm for the petitioner.
Yes.
My lord, I'm slightly handicapped today. I'm led by two seniors, Mr. Obrojit Mitra and
What
Mr.
is your name? You're
My lord,
Mr.
A.K. Avasthi, my lord. I'm the advocate on record.
Yes,
This
Mr. Awasi, start the matter.
My lord, I will beseech my lord. If my lord could take it up tomorrow, my lord.
I can, but I won't. I take it up right now, move the
My
matter.
lord, kindly give me a short pass over, then in that event, my lord. I'll request Mr. Banerjee to come over. My
You
lord,
will have to start.
well, the difficulty is I'm enjoying an interim order. I'll tell your lordship. The premises in question is governed under West Bengal Public Premises Tenancy Regulation Act 1976. Now, my lord, here a notice was served to me in 2012. That notice was waived. Thereafter, in purported pursuant to that notice, they are trying to evict me, and they told me that they'll be coming and taking a possession on the 15th of September. I approached my lord, taking the urgent determination of your lordship, and I got an order, my lord, of interim stay. But that was subsequently extended on 21st September. My interim order is expiring on the 28th of September, my lord. In that view of the matter, my lord, I have a leader, my lord, slightly, my lord.
When should I keep it? Tomorrow?
My lord, subject to convenience, my lord, my other side.
Sorry.
Yes.
Should I keep it tomorrow?
Please, my lord. My lord.
On the prayer of the petitioner, the matter is urgent till tomorrow.
I'm good. Interim order only 28 till 28.
Thank you, Mr. Awasi started very well. Yes.
Item number 24, Amitavo De Bhaumik.
My lord, in this matter, Mr. Abhimanyu Banerjee is for the petitioner. He is engaged in another court.
If
I'm
you can
seeking
start
for-
very well also, then I'll adjourn. Otherwise, I'll take up the matter.
I'm not aware about this matter, my lord. So I'm seeking for a short pass over.
Yes, you move the matter and give the answer also.
Yes.
Right to information matter. You move the matter and give the answer also.
No, the petitioner will have filed RTA application before the SPIO, that is the Kolkata Municipal Corporation. Some department of the Kolkata Municipal Corporations, they have provided some answers for which they are not satisfied enough. They filed an application under section 18, my lord. The only difficulty is, my lord, under section 18, when we adjudicate the section 18 applications, my lord, this is a complaint, this is not second appeal. So, my lord, in that regards, my lord, they may not get the information. Now, only we will see that why these kind of answers have been given by them.
But no first appeal has been prepared against it, whatever the
This
information.
is not second appeal, so question of
Section
first.
18, what is the language? I don't know what is section 18. I forgot. Just read it out for me, Mr. Awasi. Your senior is in court.
Oh, my lord, he is engaged in another court.
Yes.
Lord, section 18 says, my lord, that subject to the provisions of this act, it shall be the duty of the Central Information Commission or State Information Commission. Here we are State Information Commission, as the case may be, to receive an inquiry into a complaint from any person. Now, A, who has been unable to submit a request to the Central Public Information Officer or State Public Information Officer, as the case may be, either by reason that no such office, this is not applicable, A. B, who has been refused access to any information
E দিয়েছে।
E দিয়েছে।
1E.
But he has been written 18(1)(e). So I am directly coming to 18(1)(e), who believes that he or she has been given incomplete, misleading, or false information under this act. But
So register a complaint on that and decide.
no, the complaint has already been registered, my lord. The difficulty is, my lord, decision, my lord, we are taking up chronologically. A huge pendency for last 1 year, my lord, we could not function. my
What
lord.
will be a reasonable period since they have taken the
On
trouble
the
to come?
last occasion, your lordship provided us three months time. Since it is not a consideration of representation,
18 is 3 months.
my lord, kindly appreciate. We may, my lord, provide them 2-3 dates of hearing, my lord. In one shot, my lord, they will take the chance to file a report, my lord. We will consider. They will file a reply.
No, do it within, I'll give them 45 days for this, to decide this. The grievance of the petitioner is
But kindly
primary.
some more time, my lord. It may not concluded by one shot, lordship.
Period 2 months. Learned, the grievance of the petitioner is primarily that the petitioner's complaint under section 18 within bracket 1 within bracket small e of the Right to Information Act 2005 has not yet been registered by the respondent number 1 authority. Full stop. Learned counsel for the respondent number 1 submits that the complaint of the petitioner has already been registered. Full stop. However, comma, due to huge pendency of matters, comma, the respondent number 1 be given some time to dispose of the said complaint. Full stop. Keeping in view the balance of convenience and inconvenience of the parties, comma, WPO 1613 of 2023 is disposed of by directing the respondent 1 to dispose of the complaint lodged by the petitioner under section 18 within bracket 1 within bracket small e of the 2005 Act as expeditiously as possible, comma, upon giving an opportunity to the petitioner to be heard and in accordance with law, comma, preferably within 2 months from this date. No orders to cause urgency.
Automatically, it is obvious, my lord, the person who sought to give the information, he has also be asked to participate in the hearing process. Before the
Yes, upon giving an opportunity of hearing. Acha,
To all concerned.
very well. তাহলে যেখানটা বললাম না, giving opportunity of hearing to the petitioner.
This is within the procedure. We have to give.
Yes, he have to in any.
But your
Giving
lordship
opportunity of hearing
specifically
to the petitioner and all concerned. And all concerned.
বলা আছে procedure.
Okay, সবাই।
Representation consider করতে পারবো।
কোনো doubt আছে?
Grateful, lordship.
Item number 25, Griham Food and Hotel Private Limited versus Union of India and others.
My lord, I'm appearing on behalf of respondent number 3 to 5. My lord, we have received the brief just this morning. If my lord kindly takes it up.
My lord, some of the services upon the respondent has not been effected till now. My lord, kindly keep
Should I
it
take it up?
after tomorrow.
I'll keep it next week.
My lord.
Since service is not yet complete, comma, let the matter stand urgent till next week.
Grateful.
Come again.
My lord, kindly returnable date. My lord,
Kindly?
make it a returnable date, my lord.
Next week means October 3rd.
For hearing, item number 26, High Speed Logistics Private Limited and another.
For the respondent.
Yes.
Lord, before your lordship takes the trouble, I have forgotten my brief today, my lord.
Tomorrow?
Tomorrow, please.
Item number 27, Dolon's Food Products Private Limited and
This
another
is-
versus the state of West Bengal.
My writ petition.
Yes, Mr. Bhattacharya, what is the matter?
This is in. There was, my lord, a scheme of subsidy scheme for which, my lord, we had applied. We are, my lord, a manufacturer of milk and milk products. Now, there was an amendment introduced in the scheme, which pursuant to which, if any service-related activity pertaining to cold storage is carried out, then if a party has already obtained benefits under any other scheme, then that party cannot obtain benefit under the scheme. We are not, our contention is that, my lord, we are not like carrying out any service-related activity pertaining to cold storage. We are a manufacturer of milk and milk products. There is a cold storage which is an integral part of the entire of my factory, because without a cold storage, I cannot store the products which I manufacture.
The subsidy is meant for manufacturers or cold storages?
This is, my lord, for manufacture, it's for the industry. So this I have applied, my lord, for this purpose.
there was initially, I had also obtained some subsidy from the central government under a central government scheme. When I applied for subsidy, a part payment was made to us, 10 lakhs, and the balance part was refused, about rupees 50 lakhs, that was refused on the ground that we have already obtained subsidy from the central government. There was an earlier round of litigation. Initially, a writ petition was filed where there was a direction for consideration of our representation, which was done, and then it was rejected. Then another writ petition was filed challenging, my lord, that particular the rejection of the learned single judge held that the service that the cold storage there it is also part of the services which we are rendering, and therefore the amendment to the scheme, which I'll of course show your lordship, that will apply in our case. So we are not entitled to any further benefit under the scheme. In the division bench, my lord, the division bench held that it has to be seen as to whether the cold storage which is present it is either an integral part of the factory, or it is also used for other purposes, service related purposes, which is the host from the manufacturing process.
Yes.
So pursuant to the division bench order, they inspected the property, and upon inspection, they have once again rejected it. Now holding that this is a part of a service. This cold storage is a part of a service, and we are providing services. So therefore, we are not entitled to the benefit, and the amendment to this.
You are using the cold storage for imparting service to others also, or do you use it for exclusively for yourself? I do job works for others. Because I'm a manufacturer of milk and milk products. Now, a manufacturer of milk and milk products, my lord, I do get orders from, my lord, other companies to whom we manufacture and supply. The cold storage is required for me because without the cold storage, whatever products I manufacture, I won't be able to store it, because milk requires. The cold storage is also used by others to store.
No, not others. My products which I manufacture.
Cold storage service is not given to.
No. Cold storage service is not provided. Cold storage is an integral part of the manufacturing process. Without the cold storage, I would not be able to even manufacture the milk, because it is required to be kept.
Because it's an integral part of your manufacturing does not mean that you do not share the cold storage with others. I mean, it may be an integral part of your manufacturing process. At the same time, you may also, let it out to others for their use.
No, it is not. There is no letting out.
There is nothing.
There is no letting out here, my lord. My lord, may I start with, my lord, the scheme and the amendment, my lord, which forms the subject matter, and thereafter I'll proceed, my lord.
What have you challenged here?
My lord, I have challenged the order, the rejection which has again taken place post the division bench's order. Now, my lord, I have to, my lord, show the division bench's order for this purpose. And in fact, my lord, may I proceed with the division bench order first? My lord, that will give a clarity as to the entire factual background. It's, my lord, at page 352. Next. In fact, my lord will permit me to place the entirety of the order, because this will give the entire factual background of the matter. Page 352, the judgment and order of 19 July 2019.
Yes.
The appeal is directed against the judgment and order dated 15th of December 2016, passed by the learned single judge, whereby the appellant's writ petition, being WP number 133 of 2011, was dismissed. The writ petitioner had challenged an order of the executive director, West Bengal Industrial Development Corporation Limited, which was communicated to the writ petition under a cover of letter dated 30th November 2010. In the said order, it has been essentially held that the petitioner company is not entitled to get subsidy under the West Bengal Incentive Scheme 2000. Then the operative portion, my lord, I will not trouble your lordship with that, but the operative portion is according to the clause 17 capital A, which I'll, my lord, place, which has been reproduced subsequently. The West Bengal Incentive Scheme 2000 was introduced by the state government through WBIDC letter with effect from 1st January 2000 for a period of 5 years for promotion of industries in the state. Clause 8.1 of the said scheme, which is relevant, has been produced. Then, my lord, clause 3 Roman 11 and clause 3 Roman 17, which define new unit, has also, my lord, been set out. Now, my lord, this notification is relevant per paragraph 4. By notification dated 12th December 2001, clause 17 capital A was inserted in the said scheme, which reads as follows. incentives to service-related activities in food processing sector, and development of post-harvest infrastructure. Units set up having the following mechanized facilities jointly or severally: grading, sorting, washing, and pre-cooling, controlled atmosphere, modified atmosphere packaging system, cold storage, refrigerated vehicle, then multipurpose cold storage units suitable for storing fruits, vegetables, flowers, fish, meat, milk, and milk products, units based on application of biotechnology, tissue culture laboratory, hybrid seed production. Then several other units have been. May I go straight to my lord, the paragraph after 6. The units registered with the district industry center or with the director of industries will only be eligible for being considered for benefits under the scheme. The project will have to be approved by FPI and each department. Cold storage, including multipurpose cold storage, will have to obtain license if required from Agriculture Marketing Department of the Government of West Bengal for getting registration from the District Industry Center in respect of small scale unit, and from Director of Industries for large. And release of incentive will be subject to the technical opinion FPI and each department in case of any doubt. State capital investment subsidy will be released on completion of total work. Project completion certificate should be issued by FPI and each department, Government of West Bengal. Such units enjoying benefits of any other source will not, however, be entitled to the benefits under the West Bengal Incentive Scheme 2000. Then the provision will come into effect from 1st January 2002. So this was what has created the impact. Subsequently, the appellant set up a project in the state for processing of milk and manufacture of milk-related products. On 2nd May 2003, the appellant made an application to the Director of Industries West Bengal for registration and issuance of eligibility certificate under the said scheme. Certificate of registration was issued in favor of the appellant on 19th May 2003 by the Director of Industries West Bengal. The items of manufacture noted in the said certificate were milk and ghee. The said certificate was amended on 25th of March 2004, whereby an additional item of manufacture, that is khoya, was added and the annual capacities of other products were increased. On 10th June 2004, WBIDC Limited issued an eligibility certificate for incentives under the said scheme in favor of the appellant for manufacturing ghee and khoya. On 22nd December 2004, the appellant received the first installment of rupees 25 lakhs as aid under a central investment scheme, incentive scheme. On 16 November 2005, the appellant made an application for grant of state investment subsidy under the said scheme. On 28th December 2005, the central government released the second installment of aid in sum of rupees 25 lakhs in favor of the appellant under the central scheme. In the aggregate, the appellant received rupees 50 lakhs under the central incentive scheme for setting up the project in question. On 22nd August 2006, WBIDC Limited sanctioned state incentive subsidy in favor of the appellant to the extent of rupees 10.80 lakhs. The appellant had, in fact, claimed rupees 61.54 lakhs. By a letter dated 23rd August 2006, the appellant sought to inquire from WBIDC Limited as to whether while granting subsidy, the state authority had deducted a sum of rupees 50 lakhs on account of granted aid received by the appellant from central government. By a letter dated 29th August 2006, the appellant conveyed his acceptance of the terms and conditions of disbursement of subsidy by state government as contained in a sanction dated 22nd August 2006 without prejudice to the appellant's rights and contention. Now, on 14 March 2008, the appellant made a representation to the Joint Secretary, Commerce and Industries Department, Government of West Bengal, regarding deduction of rupees 50 lakhs from the state investment subsidy under the said scheme. In response by a letter of 13 January 2009, the Deputy Secretary informed the appellant that a unit is not entitled to get the benefit of the said scheme if it has already availed the benefits under a different scheme. Thereafter, the appellant made several representations, but the several dates have been given. Now, if your lordship kindly takes the next paragraph, Malam. On 6th October 2010, the appellant moved a writ application in this court, being WP 1253 of 2010, on the issue of incentives. The writ petition was disposed of by a learned single judge by directing the appropriate authority to consider the appellant's representation by reasoned order within 4 weeks from the date of receipt of the representation. By a letter dated 25th October 2010, the appellant communicated the said order to the Executive Director WBIDC and also made a fresh representation regarding deduction of rupees 50 lakhs from the state incentive subsidy. On 30th November 2010, WBIDC Limited communicated the order passed by the Executive Director WBIDC Limited to the appellant, rejecting the appellant's representation. The appellant challenged the said order by filing the writ petition from which this appeal arises. The learned single judge, by the judgment and order dated 15 December 2016, which is impugned in the appeal, dismissed the writ petition. The operative portion of the impugned judgment and order reads as follows. The central government granted aid to the petitioner for setting up of a new unit for manufacture of milk and milk products. Such unit was treated to be under the food storage and warehousing by the central government. The petitioner has such a unit. Manufacturing of milk and its storage requires service. The unit may have an integrated service mechanism, or it may hire service provider for such purpose. It has not been demonstrated that the petitioner has appointed service providers. In absence of such evidence, it may be inferred that the petitioner has a provision for integrated service in relation to its activities that would draw the petitioner within the scope and ambit of Clause 17A. The petitioner being governed by such Clause 17A, the prohibition engrafted therein operates to deny the petitioner receipt of the benefits of the incentive under the scheme of 2000, having received the benefit under the central scheme. The impugned order has taken into consideration Clause 17A of the West Bengal Incentive Scheme 2000 and has negated the claim of the petition on such basis. In such circumstances, I do not find any infirmity in the impugned order, and therefore the writ petition stood dismissed. There, my lord, thereafter, there are submissions recorded. I'll not like to trouble your lordship, my lord, with the submissions and come, my lord, directly to the findings of the court. I mean, division. Yes. Lord, page 362, my lord, paragraph 19 onwards. We have given our anxious consideration to the facts of the case and rival contentions of the parties. The short question that arises for our determination is whether or not the appellant comes within the scope and purview of Clause 17A of the said scheme. The Executive Director of WBIDC Limited has come to the conclusion that the appellant is covered by Clause 17A. The learned single judge has upheld such finding by dismissing the writ petition. It is indisputable that the appellant carries on business in the food processing sector. The question is whether or not the appellant carries on or can be deemed to carry on service-related activities by reason of it being the owner of a cold storage. The answer would depend on whether or not the cold storage is such an integral part of the appellant's unit that the appellant would be unable to carry on its business activities without the cold storage, and also whether the appellant is permitting others to utilize the cold storage. If it is found that the cold storage is an inseparable part of the appellant's business and the appellant uses the cold storage only for itself, then in our opinion, Clause 17A of the said scheme would not be attracted, since it cannot be said that the appellant is carrying on service-related activities. In the several representations made by the appellant, it has consistently contended that its activities are purely in the nature of manufacturing of milk and milk products, and therefore Clause 17A of the said scheme is not applicable. This aspect was not at all addressed by the Executive Director of WBIDC Limited. He has not come to a finding of fact after due investigation that the appellant is involved in service-related activities. He has proceeded on the basis of the assumption that Clause 17A applies. Why it should apply has not been discussed. In that sense, the order is not reasoned order at all. It is the mere ipse dixit of the Executive Director that Clause 17A is attracted in the facts of this case. It is well settled that an unreasoned order, be it judicial, quasi-judicial, administrative, or executive in nature, is anathema to the rule of law and is violative of principles of natural justice. This issue has not been discussed by the learned single judge. We are of the considered view that this matter needs reconsideration by the Executive Director of WBIDC Limited. He has to undertake a fact-finding exercise and come to the conclusion as to whether or not the appellant's contention that it carries on purely manufacturing activities is correct. If it is found to be correct, obviously Clause 17A of the said scheme will not apply and the appellant would be entitled to the incentive that has been deducted. If, however, the Executive Director comes to a finding of fact that the appellant is engaged in service-related activities also, then of course the appellant's claim would fall. We, however, clarify that rendering service to one's own self would not amount to carrying on service-related activities. Clause 17.
I also asked you.
Yes, yes.
Whether rent out your service.
Yes. Clause 17A, as we read it, contemplates grant of incentive to such person who carry on activities which result in rendering services to others. In view of the aforesaid, this appeal succeeds. Then the order was set aside. Consequently, the matter is remitted back to the Executive Director, WBIDC Limited, for fresh consideration in light of the observations made in this judgment. The fact-finding exercise referred to above is necessary to come to an informed decision as regards the validity and legitimacy of the appellant's claim. We, the Red Court, are not inclined to undertake such an instance. Hence, and the matter then thereafter, my lord, was remanded back, and there was a direction the executive shall hold a local inspection of the appellant's business unit upon adequate prior notice to the appellant, and shall come to an informed decision supported by cogent reasons as regards the appellant's claim. The exercise shall be completed within a period of 3 months from the, and thereafter the appeal was disposed of. It is, my lord, after this order that inspection was indeed inspection was carried out. And if your lordship, yes, yes, page, but yes, was carried out, and subsequently they had called for certain documents and records. And then, my lord, I'll come straight to the impugned order which has been passed, which is at page 376.
Yes.
Yes. I place this order, my lord. In compliance with the directions contained in the order dated.
And I'm releasing the other matters. Other matters are released. Please carry on.
In compliance with the directions contained in the order dated July 19, 2019, passed by the Honorable Division Bench, I undertook a fact-finding exercise, including a local inspection of the unit of the company, Dolan Food Products Limited. On 5th of September 2019, I visited the plant along with the team. For this purpose, I had also approached National Dairy Development Board team leaders who are called to deputy technical person well conversant with milk processing. However, given to understand it does not have so and so. Third paragraph. We had a tour of the company's plant and its operations. Presently, only milk and curd are being processed in the plant. There are 4 milk storage tanks outside and 2 smaller capacity storage tanks inside the processing section. We did not find any traces of processing of coa presently. The company has a cold storage where milk pouches were being packed and stacked in AMUL crates for dispatch. Upon local inspection, I found that the company is doing job work for AMUL, that is Kaira District, so and so the company limited is. Subsequent to the visit, relevant documents like audited and CA certified financial statements were sought for from the company for the purpose of ascertaining the source of revenue and the taxes paid, and whether the revenue team is purely from AMUL or from any other source. Examination of agreements between the company and AMUL would have enabled me to understand if there is any exclusivity with respect to utilization of the plant and machinery for doing job work for AMUL, or is there scope of earning revenue by working for other parties as well, or on its own. The company provided a copy of a tripartite service level agreement by and between Dolan's Food Products, Kaira District Cooperative Milk Producers Union and Gujarat Cooperative Milk Marketing Federation Limited. We had also sought for copies of application filed with respective agencies for obtaining permission, sanction, approval, along with copies of such approvals. The company in its application filed with the Ministry of Food Processing, Government of India, was required to submit an affidavit it had not applied, will not obtain grant for the same purpose or activity from any other ministry or department, Government of India or state government. At no stage of the case, the company made any statement regarding the said affidavit, which it was required to submit to the Government of India. The company had not provided a copy of the said application made to the Ministry of Food Processing, Government of India. This was completely unrequired. This was not even required under the central government scheme. So now comes clause 17A. Clause 17 capital A clearly provides that a company enjoying benefit from any other source will not, however, be entitled to the benefits under the West Bengal Incentive Scheme 2000. However, WBIDC took recourse to case of Sapling Agrotech Limited in sanctioning of incentives to the company. In view of the facts discussed above, the company is the service provider and AMUL is the service recipient.
So you say that you do processing of milk for AMUL. In that, it's an integrated system, cold storage is also necessary.
Is also
So
necessary.
apparently the authorities have proceeded on the premise that milk processing itself is a service. You are
Is-
providing to AMUL. You
to
say milk processing cannot be a service.
Cannot be a service.
Service has to be something associated with the milk processing and all.
Yes.
So that is the crux of the matter.
That is the crux of
You
the
have
matter.
challenged this here.
This is what I have challenged in the writ petition, because this is also contrary to the order of the division bench, because the division bench has clearly laid down the guidelines which are required to be followed to decide as to whether
So, Bhattacharya, is there any definition of service or what is in the scheme, in the incentive scheme, or something related to that?
I'll, my lord,
Let
check.
us see the scheme once.
Yes.
Let us come to the definition clause and all.
Well, the scheme starts at page 89. Service name. And subject to correction, my lord, there is no definition of service. In fact, this was introduced first time by way of the amendment 17 capital A.
But we find 17A?
Yes, that, my lord. Page 238, my lord. 230. This is, my lord, by way of subsequent notification of 12 December 2001. This has been introduced.
Previously, what is the scheme for?
Previously, my lord, clause 17, my lord, will find that is at page, it was incentive scheme for setting up of industries. Now, clause 17A has been introduced thereafter, was in respect of incentives for leather units, page 105, for tanning, manufacturing sectors available.
Incentives to service related. So this comes in for the first time in 17A.
In 17A, page 230 December 2001. This was, my lord, quoted in the judgment of the division bench, this 17A.
Right.
Yes. So I'll just place it once again, my lord, the part of it which has been, it's insert clause 70 after 17.2 with the following heading: incentives to service related activities in food processing sector and development of post harvest infrastructure. My entire classification for getting the benefits of the incentive scheme is as a manufacturer of milk and milk products. I'll show my eligibility certificate.
And the purposes have been indicated here.
Yes, units set up having the following mechanized facilities jointly or severally. The one is, C is cold storage, which is there. But it has to be read with for service related activities in food processing sector and develop on post. So service related activities in connection with cold storage. Otherwise, I'm a manufacturer. My eligibility certificate, which is, my lord, page 221. This is the amendment eligibility certificate. Yes. Yes. And in fact, registration certificate. Oh, yes, I'll just. 212. Yes, 215, my lord, kindly comes to page 215. I'd shown the amendment. Yes. Kindly sees, my lord, 215 project manufacturing of ghee and khoya. Milk was, this is an eligibility certificate. Manufacturing. And my, yes, while a 221, my lord, this was amended, and yes, milk was added. Inclusion of milk in the, that's page 220, in the list of item of manufacture in the above eligibility certificate. This page 221 of 18 June 2006.
And please show me the bar in 17A, page 231.
Yes, page, my lord, 231, the last paragraph.
That.
State capital investment subsidy will be released on such units enjoying benefits, enjoying benefits from any other source will not, however, be entitled to the benefits under the West Bengal Incentive Scheme 2000.
So that limits the operation of this bar to 17A.
To 17 capital.
This is your entire case, actually.
This is my entire case, my lord. And in fact, as a manufacturer, I will not be only manufacturing for myself. I will be getting contracts. I will be manufacturing for.
No, that's different. I mean, you can manufacture for the others also.
Yes.
The question is whether manufacturing itself or processing can be itself labeled as service.
Yes.
And manufacturing cannot be service. That apparently so, unless Mr. Banerjee satisfies me otherwise.
I was wondering if Mr. Mitra wanted to add something, my lord.
So Mitra has added many things. Obviously, he has been the moving force behind it.
So long back, I last got ready in this matter. So I'm little.
No, Mr. Mitra, you are sufficiently ready to help him out in, I mean, you pointed out the pages and everything.
He's always there.
Yes, Mr. Banerjee. Neat eyebrows. How can manufacturing be service?
The finding, factual finding, if your lordship sees the reasoned order, factual findings upon inspection of that, my lord, he is supplying. I mean, he's not providing service by way of supplying products. Now, whether that is, my lord, their case is that it is being manufactured by them and supplied. But that is not the my lord finding. Kindly allow me to place the reasoned order once more, my lord. In compliance with the directions contained in the order dated July 19, 2019, passed by the Honorable Division Bench, I undertook a fact-finding exercise, including a local inspection of the unit of the company. On September 5, 2019, I visited the plant along with a team. I'm leaving this paragraph, my lord. We had a tour of the company's plant and its operations. Presently, only milk and curd are being processed in the plant. There are 4 milk storage tanks outside and 2 smaller capacity storage tanks inside the processing section. We did not find any traces of processing of khoa presently. Company had a cold storage where milk pouches were being packed and stacked in AMUL crates for dispatch. Now, my lord, this part lordship kindly takes note of that the stacks are not the crates are not the company's stakes, my lord. The crates belong to AMUL, which were being stored there. That is the finding. It is not that they are processing, they are not supplying to AMUL. That would have been a case of they are manufacturing and not supplying. But the finding was that these are not AMUL crates which are being stored there. This is not the part where not we found that it is not a manufacturing process but a mere storage, which amounts to service. This part is, my lord, very important. Then, my lord, upon local inspection, I found that the company is doing job for AMUL. So, this is also a factual finding that they are doing job for AMUL. Subsequent to the visit, relevant documents like audited and CA certified financial statements were sought from the company for the purpose of ascertaining the source of revenues and taxes paid, whether the revenue stream is purely from AMUL or from any other source. Examination of agreements between company and AMUL would have enabled me to understand if there is any exclusivity with respect to utilization of the plant and machinery for doing job for AMUL, or is there any scope for earning revenue by working for other parties as well or not, or on its own. The company provided a copy of tripartite service level agreement by and between Dolon's Food Product, Kaira District Cooperative Milk Producers Union, and Gujarat Cooperative Milk Marketing Federation Limited. We had also sought for copies of application filed with respective agencies for obtaining permissions, sanctions, approvals, along with copies of such approvals.
Now, Mr. Banerjee, then the company had provided you a copy of a tripartite service level agreement. You label that as a service level agreement. Now, have you got a copy of that agreement?
Today I don't have. I'll have to produce that.
I'll ask them also for it.
Yes.
Let us proceed, because that was not discussed here. What was the nature of the agreement? Simple. If the agreement was for using the cold storage for packing AMUL's things, then it might be a service. Yes, you are right. Otherwise, if it is for manufacturing milk for AMUL also, like Bata's shoes are also manufactured by other small producers. I mean, small manufacturers.
If they produce and then not pack in the Bata's packet and send, then it's
right,
manufacturing followed by sending.
So the entire boils down to that, Mr. Bhattacharya, or Mr. that agreement between you and AMUL. What is that? You have not annexed that.
We can get a copy.
And the fact, my lord,
it was found that the packs were going out from your cold storage in the crates of AMUL. So that may be either way.
So they have to satisfy that crates of AMUL are being supplied by AMUL for say, putting their products and return of the
There
products.
is a letter from AMUL, which, my lord, page 379, in fact, which specifically states that this is a cold storage is an integral part of the manufacturing, and without that, the manufacturing itself cannot be done. My lord, when can you see page 379, which also, of course, we have was
Yes, there it is mentioned that
yes,
date of awarding contract for manufacturing and packing of milk.
yes. But milk to you under AMUL, man, there's basically a certificate given in respect of the cold storage unit of the plant. Now, kindly seize, my lord, this in all from time to time it was mandated that you have to maintain cold storage facility
But
for
this
storage.
was not produced to them at the time of inspection.
But the agreement was there, my lord. But this letter is there. We have disclosed this letter from
What is
AMUL.
a tripartite agreement? That is the only document handed over to them.
Yes, we can get it by 2 days. 2 days time. In 2 days time, we can get it, my lord. Or in fact, we can get it by tomorrow. We can get it by tomorrow itself.
Excellent, because it's practically heard completely.
Yes, yes, yes.
And one more point we shall be taking, my lord. This is not a factual finding arrived at after inspection.
Yes,
And
yes.
so
Factual finding, we cannot go into the factual finding. I mean, on the facts, we cannot go. We have to proceed on this premise.
if there is a error in the process, my lord, then they can assail in a read jurisdiction. If the factual finding is assailed by them that no, we are not storing in the crates of AMUL, or that the products inside the
You are
AMUL
right.
crates are prepared by us, that is the factual dispute.
Learned actor order. Learned senior counsel for the petitioner argues that
After in a few years' time, actually, he'll be applying and in the form. He has argued. I can do without that. I can very well.
Mr. Bhattacharya, appearing along with his senior, Mr. Mitra, submits, that will be sufficient indication, Mr. Submits that the writ petitioner was deprived the benefit of a subsidy floated by the state of West Bengal, on the ground of applicability of clause 17 capital A of the scheme, inasmuch as it was alleged that the petitioners are service providers for third parties with regard to the cold storage, which is actually an integrated part of the manufacturing unit of the petitioners. First of the next para, learned counsel places reliance on several annexes to the writ petition on such score. First up, the primary objection of the state is that an inspection by the respondent authorities revealed that that packets of milk of a different third-party entity were found to be packed in crates from the cold storage of the petitioner, which lends credence to the idea that the petitioner provides service to the said third party. Full stop. In such context, since a tripartite agreement between the said third party, namely AMUL, and the petitioner acquires importance and was referred to in the impugned decision of the respondents, the petitioners are requested to produce a copy of the said document. Full stop. Accordingly, let the matter stand adjourned till tomorrow for the purpose of the petitioners producing a copy of such tripartite agreement between AMUL and the petitioners. Full stop. It is expected that an advance copy of the same shall be handed over to the learned advocate for the respondent. Please just email to him a copy in advance so that it's easier. Grateful, madam.
May I prefer
Tomorrow.
Yes, Mr.
Well,
Kankani.
item number 28 to 33. I am appearing for the respondent, my lord. Mr. Dutt was appearing, my lord, for the petitioners. My lord, he's humbly prayed he's not come before lordship. He wants to withdraw these matters, my lord. If it could be under the heading for non-prosecution tomorrow, my lord. He'll be present tomorrow, my lord. He's made a request. He's for the petitioner.
Item 28 to
28 to 33, my lord.
28 to 33. তাহলে প্রদীপ বাবু ওটা কালকে একদম 1 to ওপরে গুলো to be mentioned.
Grateful, my lord.
My lord, I have a mention. My lord, I had a case I want to present on my
Can you
own.
please come to the microphone?
I wanted to present my case on my own, my daughter's case
Very
against
well.
University of Kalyani.
Is she represented
it
by,
was- it was-
is she represented by an advocate here? Have
No,
you
no,
engaged? in-
we'll present on our own.
The difficulty is you cannot place of your own. Either your daughter has to place it, you can help her,
Okay,
or it
okay.
has to be through an
You
advocate.
do it, send beside her.
Whenever the matter is taken up, please move the matter. Ask your daughter to move the matter.
It's
You
it's
be there.
listed, it was listed at 138.
138.
Yes.
Appellate side.
WPA over 22208.
Appellate side, we are taking up original side matters now. Whenever it is taken up, we'll hear it.
No, so
Come prepared, you have to watch the list since you're doing it personally.
I'll come early, but I'll wait then tomorrow.